Good afternoon and welcome to the special meeting that is replacing the regularly scheduled November meeting on November 29th at 4 p.m. of the Sunshine Ordinance Task Force. Mr. Rustin, will you, I don't know if you want to, you changed it a little bit so that the roll call is item 1. I don't know if you want to read item 1 first and then call the roll, or?
I can just call the roll, Madam
Okay.
Chair.
Please call the roll.
Yes, Madam Chair. Member Snyder?
Here.
Snyder present. Member Nee?
Here.
Nee present. Member Cotton? Cotton present. Member Manny? Manny absent. Member Washburn?
Here.
Washburn present. Member Costa? Costa absent. Member Wolf?
Here.
Wolf present. Member Chan? Chan present. Member Johnson?
Here.
Johnson present. Member West? West absent. Madam Chair, we have a quorum.
Okay, Member Costa let us know that he was not feeling well. So is there a motion to excuse Member Costa from tonight's meeting?
So moved.
Second.
And can we do that without objection? Okay. Oh, I'm sorry. Is there public comment on the motion to excuse Member Costa?
Yes, my name is Jason Grant Garza, and I've been here repeatedly to this illustrious, worthless board. There's 2, 4, 6, 7 people sitting here. You know, you would think that we'd have somebody from an ex officiato or somebody, you know, to take his place or somebody else's place. You know, the meeting last month was called short because of a lack of quorum. How is this in keeping up with, you know, trying to get us, the constituents, properly served? Yes, I do strenuously have an objection.
Thank you. Is there additional public comment? Seeing none, public comment is closed. Now, can we take that without objection? Did you have public comment? No, okay. Okay, so Member Costa is excused. We have a number of agenda changes to address before we get started. The first of which is for complaints. It's currently item number 15 through 27, and it's complaints 11072, anonymous, against a number of different individuals, to complaint 11079, or I'm sorry, 11080. Is it the anonymous complainant present?
My name is Pastor Gavin. I am the complainant, and under the Americans with Disabilities Act, under Section 504, I am asking the task force for a reasonable accommodation because of my own personal disability, which is a limited mobility. And in addition to that, a couple other residents have not arrived yet, but they also have disabilities. There was a transportation problem, so perhaps around 5:30 or 6 o'clock this evening. But I only want just one case heard, 11074 at this time. I do not want to...
I'm sorry, 11074?
11074, yes. And the rest will be on the next agenda meeting. I will appreciate it if you could consider that one case tonight.
And so that we're all on the same page, in the future meetings, should we contact you or to see if you only want one heard? I understand the request for them to be early in the agenda, and our ADA coordinator under the ADA rules has agreed that that is an accommodation that we should provide you. But in the future meetings, are you going to want only one case heard, or that?
In the future meeting, I would like for them all heard.
Oh, okay. Okay.
All right, and thank you very much.
Okay. So it's a little bit difficult because I don't know exactly when the complainants will get here. So the agenda change, we'll try to accommodate it depending on where we are in the
I can understand that.
change. I mean, if we move it first and they're not here.
Okay.
So we'll try to work with that. Is there a motion to make that change as it comes up? Or Member Wolf, Vice Chair Wolf?
Yeah, I'm a little confused. You're asking just for item 11074 to be heard at this meeting only, and the other ones to be continued to another meeting?
I do not want to impose on other complainants as well. It's really one case, just multiple people, but it's the same issue.
But Pastor Gavin, all the items are anonymous. We're not to know who is for which one.
Okay.
So, and we also had scheduled a special meeting to hear all these items.
No, those are different. Those
Those are different. I'm sorry. Okay. So, the only thing I would say is if the other items are to be, when they come up to be, just wanted that because of the number of items that are here, that there's not to be another special meeting, that they go to a regular meeting.
I would like to accommodate that, but there are 28 outstanding complaints that are not including Pastor Gavin, so I can't promise you that they're going to be on a regular. We do have one special meeting scheduled for December 14th, and depending on what happens today, some cases may be moved, or they may be filed. I'll do my best to. I understand what you're saying, and I'll do my best. But the only reason we're having special meetings is that there was an extremely large. In fact, there's now 31. There's now 31 complaints. We just had a really large number of complaints, and they all came in starting at the end of September. I don't know if you consider that some of these are similar.
Yes.
That you decide you may have, for example, I don't know if it's a little bit difficult because there was not a lot of information about what the exact complaint was. So I don't know if the complaint against Supervisors Chu and Ellsburn are similar, but if you decide that there's two or something that are similar before the other complainants get here, we may be able to hear them at the same time. I'm not sure.
That would work.
Okay.
That'd be okay. Thank you.
Is there a motion to?
I move that item 11.
Oh, I'm sorry. DCA 3 wanted.
Okay, sorry.
I apologize.
To the chair, through the chair to the members. The chair and I have discussed this issue of the accommodation somewhat extensively, and the request, as we understood it previously, was that there was a burden and difficulty sitting for long periods of time through a meeting that would necessitate or make it reasonable to move up the items. And the advice I gave, and I think also the consulting that the ADA coordinator provided, was based on these items coming as a bulk number. And we were concerned that since there were so many, that just hearing all of them might itself create a burden. But what's confusing at this point is that the complainant is asking for one to be heard tonight, and then at the following meeting for all of them to be heard. So it's difficult to understand the basis for the accommodation with that twofold request. And I think it might be useful to explore further why one should be heard tonight and the remainder heard at the subsequent meeting.
If I can address that.
Yes.
I do realize that I have a lot of cases that have been scheduled to be heard, and I do not want to hoard the task force time. I respect other complainants as well, but just as the situation with a former case, Supervisor Chu was heard, and there was a continuance the following month, is what I would be asking, that one case be heard to accommodate a reasonable accommodation, and perhaps the other cases will come up December the 14th, that there be a continuance in regards to the others.
Member Snyder?
What would what would be the objection, Pastor Gavin, to just continuing all of them to a future meeting? I don't understand why the one at this meeting.
Well, on this agenda, I was scheduled on this agenda. I don't want to get into a long litigation process because, as I said, I am new to Sunshine, and I do realize that other people have other cases that are outstanding as well. And so my request for a reasonable accommodation was that one case be heard. That is what I'm requesting under the Americans with Disabilities Act, Section 504.
Member?
Could you explain, I'm sorry, I didn't really hear you clearly when you said what the disability was that
I did not disclose what the disability was. That is illegal to do so.
Right.
But because you're disabled, because there is a disability involved, I was wondering how the disability and the continuance meshed.
Well, I do not want, I don't think that it would be fair for me to hoard the time and to request that all these cases be moved to the front. And also, on the last agenda, the agenda for October, I was not on that agenda at all, even though this case had been filed. So I'm requesting to just have one case heard.
I have another
Well, there were some cases scheduled on October, but they were moved.
Yes, that's
And
correct.
then one of the problems we're having with continuing them is that there's so many of them that they back up the other agendas. So there's already, even without your cases, there's already a number of cases on the agenda for the special meeting and then for January. So I think there's 6 of I don't know if they're yours, or there's 6 additional anonymous similar complaints to this that are already on January. So rather than take up more time, if the task force is not willing to continue all of them, we will move them because that is, required by law to move them forward in the agenda to accommodate. So does the task force, and I didn't mean to interrupt you. Go ahead, Member Cotton, and then Vice Chair
I just
Wolf.
wanted to finish up, Ms. Gavin. I read them all pretty carefully, and I thought there was a good degree of similarity among them. Could you tell me how they differ from one another?
11074 is a little bit different. There's a response, an additional fiduciary responsibility there.
But the remainder are pretty much the same.
They will be similar.
Could you tell me why you didn't file them as one complaint? The ones that are totally similar?
Well, I am new to Sunshine, and the last time I did that, I think it kind of got a little bit confusing with supervisors Weiner, Cohen, and David Chu's aides. It could have been like that. That's not an issue for me. And if that's something that the task force would want to do in regards to this, I am open to that. If they could all get here at like 6 o'clock, and when there's room in the agenda for us all to be heard, I'm very open to that.
Well, I think that's prudent. The problem we have is we want to hear everybody's case, but we want to give everybody due process. So
Yes.
that takes time.
Yes.
So that here we are, and it's 15 minutes to 11, and we have to leave at 11, and we've got a lot of people out there in the audience. So if there's any way to kind of condense and boil things down, we look forward to it, and thank you for your generosity.
Yes, I would be open to that.
Vice Chair Wolf.
No, I think all that has been said. My concern is that we start backing up agendas and we start having to deal with the 45-day rule, with regards to documents, disclosures, cases. This is an open meetings issue, these issues, which is not having to necessarily do with documents. So we end up dealing with a 45-day rule, and we have to give priority to those, just so you know. So my concern is that with as many cases as you have, this is a little unusual for us to have so many cases on a similar subject, all coming from the same complainant for so many different respondents. So it almost demands whole meetings unto itself for these cases, because we don't know what we're going to be having to discuss or what kind of information we're going to have to ask for, or how the discussions are going to go. So I'm just a little concerned about our time here, and be respectful to other members of the public who have been waiting so long to get on this agenda.
And that is why I only want one case heard. And I can understand.
So there. I don't know. Is the representative for Supervisor Chu's office here? Are they attending? Do you know, Mr. Vilberding?
I don't know.
Okay. Are you here for Supervisor Ellsburn? Okay. So Supervisor Ellsburn's aide is here.
It can as soon as the other people come.
Okay.
I'm waiting for some more people.
Okay. Member Snyder.
I wonder if there's anything in our bylaws or in our procedures that would prohibit us, with the consent of the complainant, from just consolidating a lot of these cases into a single complaint. One thing that I could see perhaps being a problem is that we would need to give I think the full amount of time
If I
to
could
each
just,
individual
if I could just,
respondent.
if I could just try to move it along. DCA 3 and I have been through this.
So there's
for-
that's not going to happen.
Well, we asked for a little bit more information to see if that could happen about the complaint. And this is not a criticism of the complainant, but they did the best that they could, and it was difficult to each respondent needed an opportunity to be able to be heard. So some of that's been going on in the background,
All right,
and what's
so
really
That's all I was asking. So
Yeah.
we can't do it, is what you're saying.
it's not
That's
that
it.
you can't; it's that there's a number of considerations that we already went through in the background. So we're taking up a significant amount of time. So
Well, I just think it would save like hours, if not an entire meeting, if we could consolidate it into one complaint. I mean, that would, but if it's not possible, it's not possible. That's fine.
if DCA 3 would like to address that.
Through the chair, I'll keep it short. There's nothing procedurally that would keep that from happening. You'd have to give each respondent an opportunity to respond, however, which would itself prolong that one complaint longer than a usual complaint. However, there is an additional consideration that a majority of the Board of Supervisors have been named in this complaint, and they cannot all attend this meeting at the same time without violating the Sunshine Ordinance and the Brown Act.
Oh, they would be able to stay out because they wouldn't, or their aide could. So somehow we have to decide how we want to move these. We're going to move at least two of them and to the beginning of the meeting, depending on what time there was a transportation issue due to some ADA issues, and so we have to wait for some of the other complainants to arrive. Why don't we try something like moving 11074 and 11072 to items 5 and 6 and then 7 and 8, and then at that time we can consider if we're going to continue the rest of them. Member Washburn?
Except the complainant just said that all of her people won't be here for a while, so.
I know, but if we move them to the front, we can.
Okay.
I can't pick a time.
Right,
So
okay.
I have a question. Is the request for accommodation for moving the items for all the items as people show up, that they should be moved to the front? to be the very next one? Or is the complainant just asking for 11074? Because I would hate to start moving all of these items to the front, because you're now looking at accommodating the respondents.
Well, do you want to move just the two and continue the rest?
Why the two? I thought only one was requested,
Because
11074.
Mr. Volberding is here, and Pastor Gavin and I just had an exchange, and he's here to represent Supervisor Ellsburn. There's nobody here from Carmen Chu's office,
I
so
understand.
they're similar. And rather than force Mr. Volberding to come back again, or Supervisor Ellsburn, since they're here, and we have a lot of things on the agenda, perhaps we could hear that one, and she had agreed.
I understand, but from what her testimony was, is that 11074 is her only case. That is her only one.
But would
All
she-
the other ones are based upon other complainants, not her.
But we can hear 1102.
And she had said, she had sent us this email saying that the specific request is that the reasonable accommodation that it be moved at the beginning of the meeting.
I would like to know, as far as how many different anonymouses are there?
One, but we're waiting for some of her support. Then they
So
also
it's-
have ADA issues, and there was a transportation problem.
Are they complainants, or are they people in support?
There are people in support.
So they are not complainants. They're not necessarily party to the case. The
Yes,
ADA
they are. Yes, they're parties to the case, but they're support.
Are they complainants, or are they parties in support? The two different
They're
classifications.
complainants.
They're complainants, so they're not parties in support.
That is correct.
Okay.
So no, I'm sorry.
Say something.
I'm sorry. Can we wait just a moment? We need to move forward because we're taking a lot of time, and we have a lot of things on the agenda. So we need to move forward with at least some of
It
these.
just appears to me that you're taking a long time. It's to get to this one item, which is what she has asked to give. It's just one, regardless as to all the other particulars.
There are
This is just
considerations of the
one.
respondents too. The respondents have a right to be notified. They need to be notified as well. They have rights too. They have a due process. So if we want to move the complaints to, maybe we can move the two complaints, continue the others, and move the two complaints to after, maybe move them to item 7 to see if everybody is available at that
Right.
time.
Right.
Is there an objection? Is there a motion or a second?
I so move.
Second.
Do you want to call roll? Or can we do that without objection?
No? Public comment on the motion.
Okay, I'm sorry. Public comment on the,
Hi, member of the task force, Ray Hartz, Director of San Francisco Open Government, and you have spent 20 minutes arguing about something which has been told to you is a reasonable accommodation under ADA. She asked for one specific case. This was sent to Mr. Rustam more than 2 weeks ago. He did not respond to her at all. She contacted me. I sent an email in saying specifically she wanted one case moved to the front because a lot of the people involved in this are elderly, disabled, and so forth. And it does not seem to be anything which requires this amount of derm and strong and discussion to move one case forward. I'm one of the people she'll be moving in front of, and I don't have any problem with that. I understand somebody who's 80 years old doesn't have the fortitude to sit here through 6 full cases. And she's asked for one to move forward and the others to be continued. And I think what this really is you're miffed because you set up a special meeting, let her know on a Friday that you were going to hold it the following Tuesday, and because she couldn't get her people together, you had to cancel that. And I think this is really taking out on the complainant a simple issue. That's all this is, a simple issue. She asked one case be moved up, and I think it was very, very reasonable of her not to say, yeah, I want all of my cases, which under the law she could have done.
My
I'm
name is-
going to have to ask that, I'm sorry, Mr. Garza, we'll start your time again. The audience is going to have to be very quiet because in the past, the task force has tried to be very, very lenient about public comment and the 3 minutes, but people have been taking advantage of it, and it's becoming unfair. So we really need the audience to be very quiet during this time so we can get through this. I would appreciate it. I'm sorry, Mr. Garza, please go ahead.
My name is Jason Grant Garza, and I've been before this board for 10 years. The farce that it is, the lack of hope, the undue process. As I was sitting here listening to all this, about ADA and accommodation, it just suddenly dawned on me that, I also asked for ADA accommodation, programmatic access, and I'm staying right here without
Yeah, we're
it.
going to call you next.
We spoke of due process. That was brought up by Sue Kaufman. It was also brought up by Bruce Wolf, due process. Well, what is due process? Because my case, which was supposed to have been heard last month in October, extends past the 45 days. So what is due process? Now, another interesting question is, how does this august committee sit in judgment of others for breaking the ordinance when it itself doesn't comply with the ordinance? You've gone past my 45 days in my cases. You've not helped me with my ADA request
This is
and my
public
program.
comment about moving the agenda. So
And
if
I'm
it's not-
objecting to it because I too have ADA issues which were not addressed appropriately nor handled correctly through this august body. And I'm just pointing out that it's more of the same. There is no due process. Get used to it, madam.
Thank you. Is there additional public comment on the motion to move the 2 items?
I think my problem with the comments that were made is that I don't think it's fair, or I don't even think it's legal to bundle, a person's complaint and then try to process it. So if this was a trespassing or jaywalking, you see 10 people jaywalking, and then you just put them in a room and then have a judge do whatever. I mean, the Sunshine Ordinance is parallel to, federal and state law. You can't just bundle them all together and run them through. I mean, to me, it just seems to me that y'all need extra meetings, maybe 2 a week or maybe even more. So those are...
Thank you. Is there additional public comment? Seeing none, this is an ADA request. I am not in support of continuing the items because we have so many complaints that there are a lot of things falling behind. But this is a federal law, and it is not something that we, that we're doing necessarily because we're choosing to move them. Now, the motion as it is that we're going, I do now see that some of the other aides are here from the other supervisors. But because of an ADA accommodation, the complainant has requested that we hear 11074, which is against Carmen Chu's office. I'm sorry, against Supervisor Carmen Chu. And they agreed that they would hear 11072 against Supervisor Sean Ellsburn and continue the remainder. Is that the motion that we're?
Yes.
Can you please call the roll? We're going to move them to item 7, so they'll follow 11058.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny? Aye. Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 9 ayes. The motion passes.
Madam Chair.
Member Nee?
What does this do now with the other complaints filed by Anonymous? Are they continued, or are they kept on the agenda for tonight?
Well, I just said that we would be continuing them.
Okay.
That was part of the motion.
Okay.
I don't know exactly how that's going to work out because we are going to have to start addressing the 45-day rule that's only associated with documents and not the meetings. But there's nothing. This is an ADA request. DCA 3, do you have any? No, okay. So we have one additional ADA request, and that is from Mr. Garza, and it involves two complaints, 11070 and 11081. Mr. Garza, do you have a specific accommodation?
All those requests were already sent in, and I have the paperwork to show it, which this body did not
Mr.
respond
Garza,
to.
Mr. Garza, I'm sorry. Do you have a specific
Yes, you are, as in
accommodation?
state of condition, not apology.
Are
so it's not
you?
accepted.
Do you have a specific accommodation?
That was already sent in.
Do you have
guys
one? Are
did
you?
not, you
we
failed
we
to
do
perform.
not have a specific accommodation from you.
I have the paperwork. Would you like for me to read it to you?
Yes. Do you have a specific? I'm not going to read all of the administrative stuff. Do you have a specific accommodation at this time?
I'm confused. I just told you I had the paperwork, and you just told me you didn't want to hear the administrative portion of it. So I'm confused. Could you please explain it to me?
What procedural accommodation do you need for the
Programmatic
hearing?
access.
Which one?
It was definitely sent in already.
What programmatic access is a
Why was
number
this
of
not
things.
requested or sent to me priorly when I asked specifically for it?
Mr. DCA 3 specifically asked you which programmatic access you
Yes,
wanted.
madam. She certainly did last
What
week after.
programmatic access do you need?
After weeks of me asking for it. Last week, 1 week prior to this hearing.
Mr. Garza, since you either will not, you refuse, or you cannot tell me what accommodation that you need, do you want to go forward with your hearing?
Yes, I do want to go forward. Yes, I
Thank
did
you.
tell you what accommodations I need. That was not the whole truth that you spoke of, as was said in the July hearing, which I questioned the
can you
interpretation,
tell
the
me-
interpreter accommodation, which you misrepresented, and I said we'd get back to it in an open forum, and you never responded to that. Administratively, in every which other way, programmatically, in every which other way, you have violated my rights under ADA. But yes, I will continue. Thank you.
Can you explain to me why you won't tell me what accommodation you need now? Okay. So we will not be moving Mr. Garza's complaint because I don't know what his accommodation is, but he has agreed to go forward and hear it, so that is what we will do. Mr. Rustin, will you please read item 2?
Yes, Madam Chair. Item number 2 is changing the time and day of the week of the Sunshine Ordinance Task Force holds its regular monthly meetings.
All right, I'm only going to say it one more time. We need to have respectful quiet, not just because everyone has an opportunity to be heard and to feel comfortable in what they're saying. We cannot have the audience members speaking out. The task force has had a number of requests to change the day of the week that the task force meets on, because it meets on Tuesday, which at the time, it's my understanding a long time ago that the Board of Supervisors met on Mondays, and then when President Gonzalez came, he changed their meetings to Tuesdays, and ours were still on Tuesdays. So before we schedule all of our meetings for next year, we wanted to have a brief discussion about changing the day of the week to maybe Wednesday or Thursday. Member Washburn.
I think it might be a good idea to change the day of the week, but just personally, I won't be able to come on Thursdays, at least through the first of the year. I mean, until June. Thursdays. She mentioned we could change it to Thursday.
Does anybody have a problem with a Wednesday?
I have a problem with Wednesday. I would have to leave early. I have another board that I'm on.
Is it every Wednesday?
It's
Can you speak into the mic?
It's one Wednesday a month.
Because ours wouldn't necessarily have to be the same Wednesday, and we'd also have to find out when a room is available. Isn't that correct, Mr. Rustum?
Yes, Madam Chair, that is correct.
So it may not be the fourth Wednesday. What Wednesday is your,
My meeting.
yeah.
My meeting is the second Wednesday.
Would you have a problem with Wednesdays on other?
No.
No? Anybody else? Okay, so why don't we have Mr. Rustem look to see if the first, third, or fourth Wednesday might be available in a room. And we can take that up again when we find out that specific information at the special meeting on the 14th. Vice Chair Wolf.
How does this affect committees, or doesn't it?
I don't think any committees meet on Wednesday.
I mean, the Tuesday committee meetings, or the Thursday committee meetings. I mean, is there any?
Member Nee?
Well, generally, our committees have been meeting the second week of the month, so I don't see a conflict.
Okay.
If we meet the fourth week of the month, I don't see a conflict.
With regards to Member
Tuesday.
Washburn, who mentioned she won't be able to make Thursdays, are you on any Thursday committees?
No.
Okay, thank you.
Okay. Mr. Rustem, can you please read items 3 and 4 together? I'm sorry, apologize. Public comment, is there public comment on item 2, which is changing the time and day of the week?
Yes, Peter Warfield, Executive Director of Library Users Association. I want to thank the chair and the body for considering this. I guess I had hopes that Monday might be considered. I'm not sure how Monday was ruled out. Many bodies do meet during the week. Typically, Friday is not a day, and Monday is often not a day as well. I would ask you to leave out the second Wednesday, which you are doing, as well as the first and third Thursday, which is certainly something that I go to regularly and that has that schedule. I'd also suggest that in deference to any particular members of the body, including some who have spoken up, you consider, if necessary, delaying the implementation of the changed day so that it's easier on your existing members. In other words, if somebody can't come on the day you choose, that you consider the possibility of continuing with the existing schedule until sometime within the year, at which time you would change. But what you've said so far, as I'm concerned, is fine, and I hope that you do go forward. I've brought this up previously, that your meetings now conflict with the Board of Supervisors since that time when Matt Gonzalez changed, and I appreciate your taking this up and considering it, and hope you go forward with it. Thanks.
Thank you, and thank you for reminding me of public comment. Is there additional public comment? Seeing none, public comment is closed. Mr. Rustem, can you please read items 3 and 4 together?
Yes, Madam Chair. Item 3 is approval of the annual report to the Board of Supervisors, and item 4 is approval of minutes from the October 25th, 2011 regular meeting.
The reason why I asked Mr. Rustem to read these together is that the October 25th minutes were not in our packet, and they were inadvertently left out of the second packet that was mailed, so I'm wondering if we might want to continue that. And then the annual report, a number of things have happened since this agenda was created, and there are a couple of things that I would like to add that I did not have time to add. So I'm wondering if we might continue that to possibly the 14th or the special meeting on the 14th.
Do you want a motion?
Member Nee?
Well, I believe Member Cawthon was ready to
Yeah,
make a
I see no
motion.
reason not to continue them. And so if no one has anything else to say, I would move for continuance of both the minutes and the annual report.
Second.
And can we do that without objection? Oh, I'm sorry, public comment on the motion to continue items 3 and 4, the annual report and the minutes of October 25th.
Peter Warfield, Library Users Association. I don't know that I or others will be present for the discussion. What I did want to say was thank you for postponing those minutes approval because they were not attached and they're not in the document that's here in the room either. With respect to the annual report, there is a section whose name I don't recall offhand, which I think could use some augmentation. It has to do with overall long-term issues, and I think that the body would do well to note a long-term problem, which is multiple violators, wholesale violators, persistent violators, as well as satisfying the rule of 45 days. So I think that might be useful to consider when you take it up. And otherwise, I agree with the motion to postpone. Thank you.
Thank you. Is there additional public comment? Seeing none, public comment is closed. Member Nee?
Yeah, I wanted to inquire of Mr. Threet. We are ordinarily, if memory serves me correctly, supposed to submit the annual report in September, and so I'm wondering, is there any kind of statutory violation or anything like that we're risking here by continuing item number 3, the annual report?
Through the chair, Member Nee, things like reports that have deadlines are generally considered directory statutes rather than mandatory statutes, so there's generally not a consequence for failing to fulfill that date.
Thank you.
Is there any additional discussion? Can we take the motion without objection? Okay, so those 2 items are continued. Mr. Rustam, can you please read item number 5?
Item number 5 is determination of jurisdiction on complaint filed by Nick Pasquarello against the Film Commission for allegedly failing to release public records.
Is there a motion to find jurisdiction?
So move.
Second.
Is there public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Can we take the motion without objection? So the motion passes to find jurisdiction. Mr. Rustam, can you please read item 6?
Item number 6 is hearing on complaint filed by Nick Pasquarello against the Film Commission for allegedly failing to release public records.
Thank you. I know that the complainant is here, but I wanted to I wanted to make sure that the remainder of the task force is aware that the Film Commission, Susanna Robbins, said that she is unable to attend this meeting. And the complainant is aware of this, but has requested that we move forward with the hearing. Is that correct, Mr. Pasquarello? What is the task force? Vice Chair Wolf?
When was that communication received?
The Film Commission?
Yes.
This is the the 21st. This is the notice that to Mr. Pasquarello that she won't be there. Oh, here it is, the 16th of November.
Did they ever respond to the complaint? In writing? There's no response in the packet.
No. Was there any additional information, Mr. Rustam?
There wasn't any, Madam Chair. However, she was in the audience for the past, I think, 2 meetings.
We did. He said no.
Madam Chair.
Member Nee?
Through the chair, Mr. Rustam, did the respondent give a reason for not being able to attend tonight?
Through the chair, Member Nee, the respondent in the November 16 email said that she had to attend a Film Commission function that was organized through the mayor's office, I believe.
Do you want to move forward?
Yes, I'd have to move.
Member Washburn?
I think we should move forward. The complainant, this is the third time he's been here. He wants to move forward. We've certainly done so in the past when the respondent's not here.
Okay, Mr. Pasquarello, you will have 5 minutes to present your case.
Thank you. I would like to respectfully object to the way this has been filed. My original complaint, and I did notify Mr. Rustam of this, is against Susanna Robbins as the executive director of the Film Commission, not to the Film Commission as a body. So there's a problem straight off in the filing. I emailed Mr. Rustam on November 19th. Please correct this complaint to reflect and read the original complaint, Nick Pasquariello versus Susanna Robbins, Executive Director of the San Francisco Film Commission. I asked also that he forward this email to Hope Johnson. I don't see any evidence that he corrected that or responded to that email. So.
Is there, I'm sorry, DC 3?
Through the chair, the administrator did consult me as a result of Mr. Pasquarelli's request, and I took a look at the complaint. The complaint itself is very clear and names Ms. Robbins as a part of the complaint. Ms. Robbins received that. So there's really no official action that needs to take place because the respondent had noticed that she was a respondent. And although it is, it could be said that it's misnamed versus the Film Commission, when you receive the complaints, and I believe in part that this is a difficulty with the online form, because it says department involved and then it says who did you contact. It doesn't, I think, require the complainant to name the respondent. So often I think what happens is that the department is placed in the position of respondent in the names that are put in the agenda. But there was sufficient notice for all the parties, so Ms. Robbins could be held responsible for the violations, even though it reads differently on the agenda, because she received the complaint, and it's clear that it's also against her.
Thank you. That's similar to what I was going to ask you. Ms. Robbins is the respondent, so I'm not sure. I understand your concern. I did not receive. I don't know if I can't remember what day I received this email, but it was after the agenda had already been posted, so it was difficult for me. Now, I'm not sure what your reasoning would be if you just want her name on the complaint.
Well, the closest I have to a precedent at this body was a complaint I filed last year against Bay Area Video Coalition. We went through many hearings, and in the end, the task force held, I forgot the gentleman's name, the executive director personally responsible and in violation. So, I mean, this came up in a slightly different context because BAVEC is not a governmental agency, it's a contractee. So and I was told by Frank Lanke, people who have more experience before this body than myself, that I don't know how to put it, but the accountability, the level of accountability is far higher when the person officially in charge of an agency is named as the respondent versus naming a body, a governmental body.
Okay.
Is that clear?
The only thing I can tell you at this point is if you would like to change the name of the complaint, we cannot hear it tonight because it has not been noticed that way.
Okay.
So that part of it is up to you.
Yeah, well, as you pointed out, this is my third time here, and I let's get it over with.
And Member Snyder?
And just to make clear, I think what everybody's saying is that if we find a violation here, we can find a violation of the director of the director, not of the commission. So your concern is the director's not named in your complaint. In terms of the task force's ultimate decision tonight, that doesn't matter. We can find, if there is a violation found, that violation may be found of the director, even though your complaint doesn't, or the title here doesn't say that.
I appreciate that. That should take care of it.
Okay. So I'm not sure how much of your 5 minutes that took up, but we'll try to accommodate. Do you know how much time? So it was like 2.5 minutes. The respondent is not here, but I can't give you 7 minutes to.
You can or cannot. Yes or no?
DCA 3. What?
I didn't understand what you said.
You used up some of your 5 minutes to complain about the. But we need to be able to hear what you have to say.
Madam Chair, I believe that the complainant actually spent talking very little of his time. Most of the time that was spent was taken up by myself and members of the task force, so I think it's fair to just give him his 5 minutes.
Thank you. So you'll have 5 minutes.
Okay. So back in August, I requested from Susanna Robbins phone numbers, email addresses, the names of all the production companies, the names of the people who filed for permits, and the number of days of the shoots and the dates of the shoots for about a 1-year period from August 2009 through, let me see here, August 2010. August 2010 through August 2000. Actually, 2 years worth. 2 years of. Now, as you may or may not know, the Film Commission, the Film Commission functions as a intermediary body between film production companies and city governmental agencies, and issues permits to shoot on city-owned property. So those are the records I requested. What I think are bona fide public records. I did hand out, since this is the third time I've done this before, I handed out a sample of the response I got from Susanna Robbins, where you can see that she has redacted email addresses and cell phone numbers for people who filed and or worked on these productions, people responsible for seeing that the laws and regulations that the production companies must abide by are met. So that's my complaint, that she has failed to provide complete records of the people who filed these reports and the people who work on these productions, all of whom are accountable to the city and its officials for carrying out the terms and conditions of location film permits. So that's my complaint, that she's failed to, I want to say it 3 times. So I do have a letter from her in which she said this is personal information and we don't give out personal information. Unfortunately, I didn't give you a copy of that, but it says personal information is not released from our office. She claims that what she's redacted and deleted is personal and not business. I have every belief that everything on these forms that the applicant filled in is public record, filed for the purpose of doing public business. I guess that's all I have to say. I really don't know that there's much more to it, but I'd answer any questions if I can to clarify the issue.
I have a question.
It's not time for questions yet. We're still going to go through the procedure, but I'll come to you as soon as we get. You can go first as soon as we come back. Thank you.
I'll sit down.
Yeah. Is there anybody to present facts and evidence in support of the complainant? Seeing none, I'm going to double check that the respondent is not present. Mr. Rustum?
Madam Chair, I spoke to the respondent after the meeting on October 25th, and she did not give me any proof, but she claimed that on her attorney's recommendation, she has released all the documents.
She
She
has
released it
them?
without any redactions. I do not have the proof, though. This is what she told me,
Without the redactions?
without the redactions.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Cawthon?
Mr. Pasquarello, I had a question for you. So now, this sample response, how many of these did you get? Did you get a lot?
Yeah, I have a whole pile of them here.
And
But they're all redacted.
and exclusive of the redactions, do they answer the questions you asked?
I'm sorry?
Exclusive, deleting the forgetting about the redactions for a minute, is the rest of the information that you wanted in this document, in these documents that you got?
With all due respect, for the purpose of this complaint, yes.
Okay, so your complaint is that personal information was redacted.
I would not characterize it that way.
I would say, let me ask the question again. The information they characterize as personal was redacted. That's your complaint.
Right.
Okay, thank you.
But I have to, somebody said that the information was released. I never received the unredacted information.
You did not receive
Oh, no.
information
I
that
wouldn't
was...
be here. I wouldn't waste your time. I mean, this is not a game.
Okay.
With all,
Member Snyder?
Mr. Pasquarello, did anybody from the Film Commission ever explain why they'd redacted the information? Other than you said earlier that you got a letter saying that they don't release personal information. Was there any further explanation?
No.
Does that letter cite any authority for not having to release personal information?
I don't believe so. I can pull it up here. I believe should I read the letter into the record?
Sure.
Okay. This is addressed to me at my post office box, dated August 8, 2011. Dear Mr. Pasquarello, enclosed, please find the records you requested. The addresses, all phone numbers, and email addresses of the production companies that applied for and received permits to shoot in San Francisco for the periods indicated below. Please note we did not include email addresses, as these were private email addresses of the location manager who pulled the permit, not related to the production company. Personal information is not released from our office. The following public information from your permit files for all TV spots and commercials shot in San Francisco for the period August 1, 2010 up to and including August 1, 2011. The name of the production company, the name of the person who filed the permit, the number of days of the shoots, the days of the shoots, the gross aggregate count for the number of shooting days for all TV spot commercials for the August 1, 2010 through August 1, 2011, and August 1, 2009 through August 1, 2010. That was an asterisk. See, if that sentence didn't make sense, it was an asterisk from above. The rest, in just one more sentence, in 2009, -10, there were 48 commercial permits with 82 days of shooting. In 2010-11, there were 69 commercial permits for the 111 days of shooting. I hope this helps you in your job search. Best regards, Susanna Greason Robbins, Executive Director. Just one more comment. I think informally, Ms. Robbins advised me that she had consulted a city attorney.
With respect to the release of the personal information?
That's my recollection.
Did she say anything further? Did she say what the attorney had said, or why he or she explained that she couldn't release it?
No.
Okay. Thanks.
Vice Chair Wolf?
I'll give a little latitude to you, Mr. Pasquarello, because reading your complaint, it doesn't specify that you haven't received the documents, but you're saying that you received the documents, but they were all redacted. Is that correct?
Yes.
So your complaint is based upon receiving the documents. It's not based upon the redaction. That's not and I'm willing to give you a little latitude on it. I just want you to know that
they're not complete. I asked for complete records. Did I not?
Be it as it may, you received documents.
Yes, I received
So the further complaint would be if they were redacted, why were they redacted? So again, I'm willing to give you a little latitude. I'm concerned that because the way the agenda reads and the way your complaint reads and and the fact that you've received the documents, redacted or not, that could be challenged. I'm just giving you fair warning.
Well, if I could return the comment, I wonder where you draw the line.
Well, the line is that somebody could say that we took action on something that was not appropriately agendized.
Well, no, but I'm saying they could send 2 lines on a piece of paper and say this is the document, even though we've erased most of it. I'm getting a little bit confused.
No, I'm just saying
agendized.
I'm willing to give you a little latitude on this, okay?
Okay.
But just know that somebody can challenge this because the way what has happened from the point of you making the request, you getting the documents, and you making your complaint, and what your complaint specifically states is failure to release public records. And in your complaint, you had asked for specific documents. You say you received the documents, but they were redacted.
I asked for all the phone numbers, and those aren't in that
I understand
part of my
that.
request.
So all I'm saying is that I'm willing to give a little latitude. I feel it's important to voice that because it could be challenged. So I'm going to ask you a question right now, okay? Do you know, are you claiming that these documents that the information on these documents are not considered personal?
Not considered? I don't consider them personal.
You don't consider them personal?
I don't think the city considers them personal. I think they're
Thank you. Through the chair to DCA 3, are these considered contracts? Would these be considered contracts with the city, these permits?
Through the chair to Member Wolf, I've not seen the documents. They weren't provided with the complaint. The complaint said that there was a failure to release public records. That's what the analysis was based on. I haven't either seen the documents or been able to analyze that question.
Member Nee?
Yeah, just want to revisit the timeline on this because you stated, I believe, that your initial request on August 4th, that was an immediate disclosure request. Is that correct?
Yeah, and I have one more sorry for interrupting. One more point of information that's important. I filed this complaint with the task force after I received the redacted documents.
Okay, just a quick question. When you filed your IDR on August 4th.
Yes.
And when do you first hear from anybody at the Film Commission, Ms. Robbins or anybody else? When was the first response that you got?
I don't remember. I think it was timely. Can I say that? I think it was timely. I think it was within the rules of this body to, that it was only when I got the documents. There was no problem until I saw the documents that they were severely redacted.
And how soon did the documents come to you?
Well, I'm really straining my memory, but I would say within a week or two I had the documents.
Thank you.
DCA 3, I just have a quick question. I know you said you didn't have an opportunity to review the permit, the documents. In general, I'm not sure exactly how to ask the question. If a city entity, a department is provided with information that goes on the permit, how is the department making the determination that that's a personal email as opposed to a contact email, or how do they know that's a personal email?
Madam Chair, as a general matter, information is provided as part of a permit request is often public. I don't know how the department made the determination on this. I haven't seen it. I haven't had any information from the department. I don't know what their analysis was. I can't speak specifically to that.
Okay. Without the respondent here, it's a little bit hard to say, but I'm going to, I'm leaning towards the idea that it would be difficult. I don't know how she would know that those were personal or why somebody would provide a personal email to the city. Member Snyder?
The more fundamental question is, even if it were personal, would it be releasable? Should it be released nonetheless? And I'm just looking through the Sunshine Ordinance. I can't think off the top of my head, and I know some about this, of an exemption from release that would automatically apply to email addresses and cell phone numbers. Without them here to explain what their basis in law is for redacting that information, it's a little hard to know why they did it. But they didn't provide any basis in law to Mr. Pasquarello. And so the Public Records Act and the Sunshine Ordinance presume that records that are in the possession of public agencies are public, unless there is some reason to exempt them. If there's a basis in exemption for redacting the information, then they might have been within their rights to do so. But I can't think of a reason off the top of my head that would be valid, and I can't with some quick research right now, think of a reason that they could have withheld it. So, DCA 3, do you know of any basis that they might have asserted for withholding?
Oh, well, what I can say is that there is a specific exemption in the Public Records Act for information, the release of which would unreasonably invade the privacy of another, such as medical records. Now, it's a different question whether that exemption would apply in this case.
Yeah.
As I understood what Mr. Pasquarello said, Ms. Robbins was initially claiming that these email addresses were not the permittees, but were some sort of separate business people that were obtaining permits on behalf of the permittees. I don't know that that would necessarily make a difference in the analysis, but that was her claim.
Are you're talking about the personal, medical, or other information?
Yes.
Yeah,
Yes.
That's the exemption
Yes.
from the
Yes.
CPRA. And I don't know. That's my understanding of that exemption is that it applies to things like can apply to things like Social Security numbers, home address, home telephone number. It can apply to those. Doesn't necessarily.
Yeah, there is federal case law under. I'm trying to remember what the acronym for the federal public records law is. Yes, that says the private emails of, I believe it's government employees, or exempt from production, and it's a very similar exemption under that law. As far as I know, there's not a case on point under California law.
Yeah. And as to just another quick point, as to Vice Chair Wolf's point about Vice Chair Wolf made a distinction between this form being the record and the redacted information. I think it's a safe description, a fair description that Mr. Pasquarello makes that, let me start over. When Mr. Pasquarello says that they have withheld records, I think it's accurate that to say that they've withheld records because they've redacted certain information from this form. In order, they don't have to withhold the entire form for them to have withheld records. They've withheld records even if they redacted only a sentence from this form. So I think assuming that this information can't be validly or lawfully redacted under some exemption to the public records laws, I think the task force could find that they have withheld records. They did, in fact, produce the entire document. It's a good point, and it's a distinction that I think would matter in some cases, but I'm not sure it does here because the Film Commission did withhold records. I think the question for us is whether they had a valid reason in law to do so.
Okay. Member Wolf?
So as I said, I was willing to give some latitude on that because there is a clear distinction between getting a document and having it redacted versus not getting the document at all. Okay, the fact that, and I'm going by his complaint of having received it, and now his testimony. So I'm willing to give a little latitude on that. Through the chair to Mr. Rustum, when you receive communications from the Film Commission and they said that they were advised upon legal counsel, did they cite any section of the CPRA or Sunshine Ordinance?
Through the chair, Vice Chair Wolf, I had that conversation with her after the meeting of October 25th.
I understand that, but my question is, when you had that discussion with them, and they said that they had discussion, they were advised by legal counsel, did they state a particular statute, a particular section of the ordinance that says that they can redact, or can't, that they are allowed to redact?
Vice Chair Wolf, what she said was she had consulted with the DCA and had released everything.
Okay, thank you.
If we could move this forward,
Yeah.
just to try to save some time. I think we've pretty much narrowed down the issues, and it'll come back to us. Okay, I'm going to make sure this time we're going to move to your rebuttal comments. I'm going to make sure again that the respondent is not present. The respondent is not present, therefore the complainant will now have 3 minutes.
I have worked in the movie business. I have worked as a location scout in the movie business. If you showed this to anybody who worked on any of these productions, and you said to them that what's missing here is personal, not business, it is on this form for other than business reasons, they'd laugh at you. The purpose of this form is to conduct business. There's nothing personal about this. The city charges fees. I think you could see at the bottom where the fees were paid. I think SFPD deposit $750. I don't know how it could be more a business form than that. So just on that basis alone, it's a form that has nothing on it but business information. So I'm just reciting what I think to be common sense, and also based on my experience working in the movie business. The information on here is conducted for the purpose of shooting films and videos. Those people need to contact one another repeatedly all the time while they're on the job. That's business. That's what they were doing. That's why Susanna Robbins even has these in her possession or in her office to conduct business with the city. And these people are responsible, as I said before, and I guess I'm repeating myself, they're responsible for conducting the business in a manner consistent with the laws of the city and county of San Francisco. So, and that's not personal, that's business, that's legal. So that's my common sense explanation of why I think we're not talking about anything personal at all. This is not a personal letter that somebody sent to the director to let's have a dinner or do something personal. It's something, let's conduct business with the city. She's an employee of the city, and these people were conducting business on city property. I don't know that I could really add anything else to that.
Thank you.
So I can-
The matter is back with the task force. Is there, Member Chan?
Rebuttal.
Microphone.
I remember this a similar case that we've done it before. It's I think past practice that these information are whatever is in the document is not private. So basically, we've I guess some people and or the people that requested we've been giving to them too, and it's not private information if it's in government form. I think Bruce remembers that too.
Yeah.
Member
Chain.
Washburn?
I agree completely, and I'd like to make a motion to find violation of 6726 withholding of records and 6727 for failing to give written justification for withholding of records.
Second.
Member Snyder?
We could consider also adding as a friendly amendment, 6721E for failure to appear.
Mm-hmm.
Gives them.
I personally would be reluctant to do that because they gave us, she did sit here for 2 meetings all the way through. One of them she couldn't sit through because she had childcare issues, but she was here for some time. So I would be reluctant to add that because we have so many complaints that we just couldn't get through it.
That's fair. I withdraw the suggestion.
I'm sorry, Vice Chair Wolf.
Who is the complaint who is the violation against, please?
Susanna Robbins.
Thank you.
Is there?
One more thing. I understand the records are available, so I think the order of Ms. Robbins should be notified that we realize that, and she should make every effort to get them to the complainant. I don't know if we want to follow up with this compliance and amendments.
Yeah. Is there public comment on the motion?
I'll try to make it short. 6254C, the Public Records Act, exempt personnel, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of personal privacy. There is no expectation of privacy when you file an application for a permit, period, end of story. It seems to be pretty clear that either the person was ill-advised or misunderstood the advice, or someone in her department said, why don't we try this? There's no need to protect the people who filed for the permits. There are applications filed in the Department of Public Works, in the Department of Building Inspection, and so forth, and they never redact any type of contact information. In fact, it's available on their websites. Thank you.
Thank you. Is there additional public comment?
Yes, Peter Warfield. The question of redactions, first of all, I'd like to say that I support the motion that was made. But I'm very disturbed by the discussion that's been held here, in part disturbed by that. There's a lot of discussion about personal information. If I send somebody a letter saying, I really enjoyed that book, War and Peace, from the library, but I wish you had more copies available, is that personal information that has to be redacted that I read War and Peace? Certainly the library wouldn't tell somebody who inquired what I was borrowing. If I say, however, the type was so small it gave me a headache when I read more than 15 minutes worth, and you ought to put a health notice on here because I happen to be subject to headaches, is that personal information? Are you going to expect people to go through the contents of what they send to a public body for public business and redact every bit of so-called personal information? There is no support, as Member Snyder said, for the exclusion of personal information or color preferences or reading preferences or anything else. As the previous speaker said, 6254 in the state gives a long, long, long list, records of complaints to or investigations conducted by police departments and so on, ongoing investigations. There's a long list of what is redactable that is specified in great detail, and it goes on for pages, within the Public Records Act. There's nothing about so-called personal records or email addresses, except in certain cases. For example, there are specified cases where you're allowed to or supposed to redact. But unless that has been cited specifically by the respondent, there should be no serious consideration of redactions. Those redactions are not legitimate unless they are specifically allowed or required by the law and cited by the respondent to the complainant. There was no citation. There was nothing except a vague reference, as I heard, personal information. What's personal about an email address? Millions of people have their home addresses and their phone numbers in the phone book. What's personal? If you get mail from Mr. Pasquarelli you don't want, you send him back a note saying, please don't send me, I'm not interested. And that's probably the end of it. If there are huge hassles, there are also laws and court orders that can keep people away from calling or from coming to the door or sending mail.
Thank you.
Please find the motion. Thank you.
Is there additional public comment?
Call the question.
Seeing none, public comment is closed. Back with the task force.
Call the question.
Mr. Rustin, will you please call the roll?
Yes, Madam Chair. Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Cotton?
Yes.
Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 9 ayes. The motion passes.
Okay, so the motion passes, and we will send this to compliance and amendments with the standard 5-day order, even though we know she said the documents were available.
I wonder if we can or need to specify in the order of determination that what we're saying is they need to produce the records without the redactions. That maybe is clear, but maybe we should, just to remind myself and the chair, that we should say in there, give them the records without the redacted information. Should say
Without the
with the information, right? Give them
They
the
already did
records
that.
with the information not redacted.
Okay.
Madam Chair?
Member Nee?
Yeah, before we move forward on the agenda, for the benefit of the respondents who are here to the various complaints filed by Anonymous, I think it's a good idea to remind them or restate that the only two items, the only two complaints we're hearing among those tonight are numbers 11072, anonymous against Supervisor Sean Ellsburn, and 11074, anonymous against Supervisor Carmen Chu. The other complaints by Anonymous have been continued. This is for the information and benefit of the respondents in these matters.
Thank you. So it's past 5 o'clock. Normally at 5 p.m. we take public comment on matters not on the agenda. So at this time, we're going to take public comment on matters not on the agenda.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. This is a public request for action on order of determination number 10050, Ray Hartz versus Police Commission. This was a violation of 67.16D and is in no way substantively different than Sue Cawthon versus the Library Commission. The violation occurred in September 2010. The hearing was in January 2011. The order of determination was issued in March 2011. There was a 6-month delay before the EOT committee heard the case in September 2011, and I sent an appeal to the task force on September 20, 2011. The appeal did not even receive an acknowledgement. The task force needs to take immediate steps to move on this order of determination. At a minimum, it must be sent to the Ethics Commission for a hearing, as it addresses the same issues in the one case they have opted to hear and act upon. This is an appeal for action at the earliest opportunity. Justice delayed is justice denied. I have really tried to be very patient. I spent 5 consecutive months sending emails to Mr. Rustin every month asking him why this was not on the EOT agenda. And I got responses back saying it would be on the next agenda, and it wasn't. And so this has now gone 1 year and 2 months since the determination was issued, and I'm still waiting for the case to come back to the full task force with a recommendation from EOT. And I had some serious concerns, and I put those in my request for my appeal, stating what those specifically were. in that what happened at that meeting was that the representative from the police commission came and said, well, this problem won't occur again because we went through and he showed up one sunshine declaration for 2011. What he failed to do, and what I was unable to do at the hearing, was show the other 4 times that same person had been through the sunshine training previously. So I think it's kind of ludicrous to say, well, you know, you've been through the training 4 times, and now that we've been through the 5th time, everything's okay. And I think the simple fact that I've waited a year and 2 months to have an order of determination go out into limbo and just remain there is something that I'm having a real hard time understanding. Mr. Reston?
Yes, public comment. Once again, it's Jason Grant Garza, and I concur with what Mr. Hartz has said. I've repeatedly asked what happens when you go past the 45 days. I've never received a response from the chair or from the administrator. There is obviously no procedure set in place in this committee to ensure the process is followed correctly. Everything is set up as a farce. No one is responsible. Nobody accounts. Nobody responds. The responses are de jure, not de facto. When I ask for case law to be cited, it is not. When I cite case law, all of a sudden I'm represented as being somebody who's malicious or harassing people. A good example would be in one of the cases I have today, I didn't even receive the respondent's request that my 2 hearings be combined until I looked at the agenda today. I never even got that from the respondent or from the Sunshine Task Force. It's amazing to me how much you'll bend for the lawbreakers and the people who don't do anything correctly, but for those who you have a responsibility to, you fail consistently. You have not answered the question about the 45-day rule that you have violated, but yet you're going to sit here in judgment of others having violated the ordinance. That's hypocritical.
For the record, my name is Randall Pancher. I had some dealings with the Shelter Monitoring Committee in the past year, and they also adopted a 45-day thing so that they could waiver the fact that I was beaten beyond recognition at one point and was robbed. And just speaking on that, I think that it is a way of copping out from doing your duties, this 45-day waiver. And this is my first meeting being here. Hearing that announcement is very reminiscent of the ill and foul behavior of another party that is inculpable and incapable of handling the true, efforts of what the body is supposed to be trying to do. So, thank you.
Peter Warfield, Library Users Association. Our complaint number 11084 is not on today's agenda. We filed both 84 and 85 in haste, hoping for a possible hearing in October. We were promised on both of the complaints that they would be heard in November, and then without any explanation, only one of the complaints, and not 11084, was put on the agenda. Only after we made inquiries and expressed concern about the scheduling was any explanation offered. Now, it's understandable if you have way more cases than you can reasonably take up at a meeting to want to deal with that issue. You want to be fair to the complainants and the respondents. You don't want to put a 97-item agenda out, which everybody knows you can't go through. On the other hand, you do have cancellations. If you have a lot of cancellations, you may have a short meeting and not get to the ones that you didn't put on the agenda. Above all, this apparent change of policy, to my knowledge, was never noted in any formal way or to the complainants who had presumably an expectation, or might have had an expectation, that you would be following your previous procedure, which is essentially to put stuff promptly onto agendas. What particularly concerns me is that by burying complaints in some bin that's not readily visible to the public, you are doing the opposite of sunshine. You're making those complaints invisible until when? When is 11084 going to come up? In 2 weeks, in 4 weeks, in a month or 2 or 3 or 5? Who knows? But in the meantime, nobody knows that that complaint is pending. And at least to have it on the agenda or in some other way noted would make it publicly noticeable, available, and something that the folks in the public could see as being on your pending list. So I urge you to, yes, take care promptly of your complaints. In fact, some of these complaints won't have been heard in 45 days, whether or not they're one category or another. But the solution is not to do it without public input, without any public announcement that I'm aware of, and particularly without any visibility, so that ordinary people can see there's another pending complaint, and wow, that's interesting. Thank you.
Thank you.
First, I think for those in the back who don't know you and haven't appeared before you, attended many meetings, they don't probably understand that you're volunteers, that based on what they've seen so far, there's a lot of work in what you do, and that you do your best to get it done as quickly as you can. And you're entitled to respect and to understanding for all of that. And I certainly can attest to that. But you can't do it alone, and you can't do it as a body unless you have administrative support. And that's where the rubber meets the road. And I think this meeting is a good example of why you're not getting good administrative support. Look at the agenda. You have 10 anonymous complaints. You cannot distinguish one from the next. You don't know what the complainant complained about. You go to the book. You look at Mr. Pasquarelli's complaint, 2 pages. His email, actually, it's only 1 page. No, 2 pages. His filled out complaint form and his email, and then Attorney Threed thought he didn't get any records at all. That was one of his first questions. Did he get his records? Of course he got his records. But it meant that whoever was processing the complaint didn't ask enough questions. There was no response from the respondent, and you had nothing in the book to tell you anything. I could go on and on about the problems involved in the administration that is serving you. And I think the time has come to have an in-depth review of the administrator and his performance. And I'm on record now that this is very serious. Mr. Rustam has taken inordinate amounts of time off. The clerk of the board has not adequately covered in his absence. There are innumerable emails complaining about the lack of either attachments, descriptions, all kinds of holes that have been created. And I think if the clerk of the board, who's an ex officio member of this body, would be here or send her delegate, then you would have a better chance of getting your job done in a very professional way. But right now, you can't do that. I don't want to go into all the details. The other question I want to put out, I have a complaint that's coming up before the Compliance and Amendments Committee against the city attorney. I want a knowledgeable person from the city attorney there. Thank you.
Thank you. Is there additional public on items not on the agenda? Seeing none, public comment is closed. I just want to quickly address the complaints we had about the 45 days. We are a volunteer organization, and we meet once a month, and we had a significant number of complaints, which has never happened before. So we're doing our best to try to address the situation. In addressing the situation, there are indeed two sides to a complaint. And if I were to make an agenda that was 97 items long and require respondents to stay somewhere and spend their time just sitting there, I don't think that that is a reasonable way to conduct the committee. I don't think that we would get much respect from the city departments for that. So I'm trying to find some kind of a balance to that, because respondents have a right to have a little bit of due process and consideration as well when there's something that's that obvious. So that, and also please feel free to send us any suggestions that you might have on handling that number of complaints. And we also take very seriously public comment. But I want to make sure that the people that are up here, that you know that they volunteer their time, and it takes a lot more time than just the time at the meeting. It takes a really long time to review all of these documents. And as you know, I am well known for going back and watching hours and hours of video. So I spend a lot of time, and I just want to let you know that we do care, and we are all, everyone here is contributing the best that they can to try to fix that issue. At this time, I would like to ask the task force if does anybody need a break before we ask Pastor Gavin? Okay, in order to accommodate the anonymous complaints, we're just going to take our 5-minute break now. So we'll have a 5-minute recess. The meeting is now back in session. Mr. Rustum, then we're going to take the item, the one that Pastor Gavin requested first, which is 11074. Or do you prefer to have 11070 first? I mean, two. Sorry about that. 11072 first. Is that? Do you have a preference?
I would like to start with the one that I requested first.
Okay. So, Mr. Rustum, could you please read items 19 and 20 as the next in line? And start with 19, I'm sorry.
Yes, Madam Chair. Item number 19 is file number 11074, determination of jurisdiction on complaint filed by Anonymous against Supervisor Carmen Chu for allegedly violating certain sections of the Sunshine Ordinance at a recent Board of Supervisors meeting.
Is there a motion to find jurisdiction?
So move.
Second.
Is there public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Can we take the motion to find jurisdiction without objection? So with jurisdiction is found, can you please read item 20?
Item 20 is file number 11074, hearing on complaint filed by Anonymous against Supervisor Carmen Chu for allegedly violating certain sections of the Sunshine Ordinance at a recent Board of Supervisors meeting.
You will have 5 minutes.
Greetings, Chairwoman Johnson and members of the Sunshine Task Force. I would like to thank you for the ADA accommodation. As I said before, we had some issues in regard to public transportation, but we're all grateful to have had that tonight. I would like to say 6 months to the day is the first time I began to find out a little bit about what sunshine really meant. It has been 6 months to this very, very day that I have been trying to get the documents for the Park Merced Development Agreement, and I have not done that as of yet. The Planning Department has never released them. Having said that, I would like to say everyone is represented in Washington by a rich and powerful lobby, it seems, but there is no lobby for the people, said former U.S. presidential candidate Shirley Chisholm. The Park Merced developers were billed by various city departments in their assistance in regards to the development agreement with the Park Merced developers. The City and County of San Francisco, the City Attorney's Office, the San Francisco Planning Department, San Francisco MTA, San Francisco Office of Workforce and Economic Development. All of these departments combined is a total over $1 million, is the amount that was billed to these departments with the development agreement. Throughout the entire process of the development agreement, Stellar Management, the owner of Park Merced, were represented by attorneys, as was the City of San Francisco. However, as previously stated, the people had no lobby. Written in the Sunshine Ordinance are sections that are concurrent with the Brown Act. Under public testimony, it states the following: the members of the public have broad constitutional rights to comment on any subject relating to the business of the government body. In addition to, as I paraphrase the Brown Act, prohibiting critical comment is a form of viewpoint discrimination, and that such prohibition promotes discussion artificially geared towards praising and maintaining the status quo, thereby foreclosing meaningful public dialogue. In a recent previous case I brought before you, it was regarding sunshine rights that we felt were violated. My neighbors and my friends and I, who are residents of Park Merced, as well as members of the public. There was a decision from the order of determination that some sunshine rights had been followed, and some of those rights were filed also in this case. During the Land Use Committee meeting on May 24th, given the enormity of the situation, because we're not just talking about 1,538 apartments, we're talking about the homes of thousands of people, and they are impacted by whatever decision pertains to their home, as we all are, in addition to the environment. At the beginning of the Land Use Committee meeting, Michael Yarney, who was the project manager from the Office of Economic Workforce Development, stated that the changes made were only structural and organizational. And as we were not allowed to speak on these revisions, Board President Supervisor David Chu said that they were for extra tenant protection. And if they were so great and so stellar, why is it that the tenants could not read them? But after that meeting, which was phenomenal within itself, and it's very hard for me to watch that and the Board of Supervisors meeting without a cup of Irish coffee. But going forward into the Board of Supervisors meeting, I think for those of you who've seen the video or know the history of the video, Supervisor David Campos, he nailed it. He nailed it. He stood out amongst all of the Board of Supervisors, with the exception of two, all of whom are lawyers. He said there was a possibility that they could be in violation of the Brown Act, and he asked the city attorney, could she cite a case, and she could not. He was adamant, he didn't back down, and I thought it was very valiant of him to do so. I mean, we're talking about something that's going to immediately impact the lives of thousands of people. We're talking about the homes where people live and where I live with my family. And their cavalier and reckless behavior, because they are the board, or perhaps they sit on the diocese, they did not allow us to speak. And because they didn't allow us to speak, there is a conflict of interest in the development agreement, where there is a memo that acknowledges that Stellar Management will contribute $50,000 to a project in Supervisor Carmen Chu's district. She did not recuse herself, nor did anyone disclose it, and we had the right to know what was in that development agreement.
Before you step away, just really quickly, so you're the allegation against Supervisor Chu, just so we can be very clear before everybody speaks, is that there was a conflict of interest and she did not recuse herself from the vote at the board on May 24th?
That is correct. Okay. It was a conflict of interest. She did not recuse herself, and no one brought this to the attention of the public.
Okay, thank you. I see that there are a line of people that are here to speak on behalf of the complainant. You will have up to 3 minutes each.
Madam Chair?
Member Need?
Yeah, I think it's a good idea to remind the speakers, if they are going to be presenting facts and evidence in support of the complainant or in support of the respondent, that makes them part of the party in interest. And so when a motion is made, and we call for public comment on the motion, the people who have offered facts and evidence in support of either side will not be allowed to speak during the comment on the motion. So we welcome, we encourage the people to speak, but they have to decide when and under what basis.
My name is Laura Traveler, and I have lived in Park Merced for 26 years. I'm a retiree, an educator, principal and teacher for 37 years. I want to thank the task force for the kinds of things that you do for the public. On this issue, I'm speaking on section 67.15 of the Sunshine Ordinance. Every agenda for special meetings on which action is proposed to be taken on an item shall provide an opportunity for each member of the public to directly address the body concerning that item prior to action thereupon. Now, this I'm speaking to Sunshine Ordinance 67.15. Shock, insult, outrage, horrific, revolt, are just a few of the adjectives that described how the residents of Park Merced were made to feel when their constitutional rights to give public testimony was denied, as it was the last opportunity for them to provide meaningful public comment regarding the demolition of their homes. And as I said, I've lived in Park Merced for 26 years, and of course, it's my home. I live in San Francisco, and the people have voted for open government, and I believe in open government. Thank you very much.
Thank you. You can just go ahead and come forward as they're done.
Hi, my name is Marianne Greb. I'm a resident at Park Merced for almost 2 years now. Thank you for the Sunshine group for allowing us to speak today. I'll be speaking on Sunshine Ordinance Section 67.15, public testimony also. Every agenda for special meetings at which action is proposed to be taken on an item shall provide an opportunity for each member of the public to directly address the body concerning that item prior to action thereupon, which was not respected on May 24th. Also, I'm shocked and dismayed for this lack of oversight. And as a Park Merced resident, we were made to feel that our constitutional rights to give public testimony was denied, as it was the last opportunity for them to provide meaningful public comment regarding the demolition of our homes prior to the Board of Supervisors meetings vote. I've lived in San Francisco for almost 30 years, and we, the people, have voted for open government. We believe in open government, and I insist that you observe it. I also want to take this time to thank the Season of Sharing Fund for helping me to secure my home. And should anyone want to contribute to nonprofits for year-end tax write-offs, donate to the Eviction Defense Collaborative and or Season of Sharing Fund. Thank you so much. Happy holidays.
Thank you.
Save our homes.
Thank you.
Good evening, Task Force. I'm here this evening to support Pastor Gavin.
Can you hold on a second? Stop the clock. Can you just pull the microphone? Yeah,
okay.
Thank you.
I'm here this evening to support Pastor Gavin and to speak on the Sunshine Ordinance Section 67.8, Agenda Disclosure. Closed sessions. A. In addition to a brief general description of the items to be discussed or acted upon in open and public session, the agenda posted pursuant to Government Code Section 54954.2, any mailed notice given pursuant to Government Code Section 54954.1, and any call and notice delivered to the local media and posted pursuant to Government Code Section 54956 shall specify and disclose the nature of any closed session by providing all of the following information. We were hoodwinked, misled, duped, and confused by trickery. This is how many of my neighbors and I felt when we left the Board of Supervisors meetings, when they prohibited us from the last opportunity given to us to make any meaningful public comment as it pertained to the demolition of our homes. I live in San Francisco, and I voted for the open government. I believe in open government, and I'm very happy to be here tonight. I'm very happy that you have taken the time and trouble to volunteer to be here. Thank you very much.
Thank you.
Hi. Excuse me. My name is Randall Pancher. I'm here to speak on the behalf of Pastor Gavin and the Park Merced community. I am a resident of San Francisco. I actually live in the Upper Tenderloin. But what I do know is that there is a drastic lack of housing, affordable housing here in San Francisco. And I think to start this discussion, my 3 minutes, I think it is absolutely ghastly and appalling that people are not being transparent with monies that are being paid and tossed around like it's a tennis game. I think that it obviously was a breach of, legal actions, and I think it should be. I would advise the board to actually really look deeply into a conflict of interest situation, seeing as that I'm not a lawyer and it's very obvious that there was one. This is a trend in San Francisco right now. Hunters Point, the Lower Soma District, the Mission, Haight Street, many of these places have been disenfranchised by people who could pay higher rent in the area. Therefore, the impoverished citizens or the seniors or the people who need the care are being pushed into the streets, and through the city's policymakers are being considered homeless and pushed into their general assistance program, which is a criminal organization altogether, because it's stripping money out of the federal hands and it's making it a third-party system. So I think this entire criminal network should be looked at. But please consider the conflict of interest, which is obvious, that the lady noted. Thank you very much.
Hello. Thank you. Sunshine Task Force Board. I'm here to speak in behalf and support of Pastor Gavin, my friend and neighbor. I am a longtime San Francisco resident, and I will speak briefly about Sunshine Ordinance Section 67.9, Agendas and Related Materials, Public Records. Section A, agendas of meetings and any other documents on file with the clerk of the policy body when intended for distribution to all, or a majority of all, of the members of a policy body in connection with the manner anticipated for discussion or consideration at a public meeting shall be made available to the public. To the extent possible, such documents shall also be made available through the policy body's internet site. However, this disclosure need not include any material exempt from public disclosure under this ordinance. Put one over on. This is how my neighbors and friends felt when they left the Board of Supervisors meeting when they were prohibited the very last opportunity to give meaningful public comment as it pertains to the demolition of their homes. I live in San Francisco, proud voter. I believe in open government, and the people, including myself, have voted for open government. Thank you.
Hi, I'm Michael Lyon from San Francisco Gray Panthers and Senior Action Network. Our group of seniors and people with disabilities have an incredible shortage of affordable housing in San Francisco. I think anything which impinges on the rental stock of affordable housing needs to be protected with every way possible. the Board of Supervisors meeting, which suddenly pulled the rug out from everybody who thought that they had some kind of legal defense against having their homes torn down. That procedure of that meeting needs to be looked into very carefully, and I agree about the allegations of conflict of interest. This whole process has just been incredibly corrosive to the community.
Hi, my name is Thomas Agee. I'm here in behalf of support of Pastor Gavin. I started living in Park Merced in 2002, and I'm still on the lease, but I'm temporarily not there right now, but I'm still very close to Park Merced. And I'll tell you, in the very beginning, I was for the Park Merced project, but actually after I started going through and really educating myself on it, I am very much against it. And from the latest thing that I've heard as far as Carmen Chu and the $50,000, it really makes me very, very concerned. You know, when I hear, okay, cases get referred to ethics and then the district attorney's office, and from what I understand, when cases get referred to ethics, they don't go anywhere. From what I've heard, the ethics office has thrown out most of the cases or all the cases that get referred to them, and it's just horrible. And I think that I don't know if we need to get the FBI or the Justice Department to do a probe into this whole matter, but it just seems like there's a lot of shenanigans going on in this whole thing. And it just seems to be going on, and we keep finding more here and more there. And, you know, not to sound too dramatic, but it sounds like this might even just be the tip of the iceberg. We don't know. I mean, it just does not see. I don't think that this whole Park Merced thing was fully vetted. In the very beginning, it was not fully vetted. The guy, Daniel Mudd, I've heard that he has had problems where he has lost a lot of money, and there's been bailouts, and he's in with this whole Park Merced project. And we can't afford to have more screw-ups and more political corruption go on. And if we need to just put the brakes on this and try to get some outside entity to look into this, maybe that's what needs to be done. Because I'm just constantly, I'm hearing more and more stuff that gets discovered about this. And if this thing gets going forward, then it's too late. It's too late. You know, I mean, this is a very big, very important project that is before in San Francisco, and this city cannot afford to make a mistake. There's billions of dollars involved. It is not like somebody's coming in with their own money and using it, and we just can't have another bailout.
Thank you. Is there anyone else to present facts and evidence in support of the complainant? Okay, seeing none, is there a representative from Supervisor Carmen Chu's office? Okay, before you begin speaking, you can come to the mic if you would like, but before you begin speaking through the to DCA 3, perhaps you're thinking the same thing I am, and I'm not sure if this is the best time to ask you about this, but if you go to page 169 of our packet, there's an email from Supervisor Chu, and she is asking about additional specific details so that she can address the complaint. And I have some legal concerns about notice of this allegation about the recusing herself since she did ask and nothing was provided?
Madam Chair and members of the task force, I did note this in the memorandum. One difficult issue with all of the complaints is that there are no specific factual allegations or supporting documentation provided by the complainant. The complainant specified the statutory sections she alleged were violated, but that's all we had, really. So Supervisor Chu's concern is well-founded. She was not provided the opportunity to prepare a full response to the allegations, and in particular, Supervisor Chu, I don't know what she knows or what communications have gone on between the complainant and the supervisor's office. It could be that the supervisor's office knows some of these details that the task force was not provided, but assuming that they were not provided that, it probably is a surprise today to learn that the core allegation is that there's a conflict of interest. And I personally have had no opportunity to research that issue or see the letter, or I don't believe, although I could be in error, that there's anything in the Sunshine Ordinance that addresses a conflict of interest.
But you may research it based on disclosure, or it depends on.
My first impression, and again, I haven't had the opportunity to go through the Sunshine Ordinance in more detail. I'm not aware of any provision of the Sunshine Ordinance itself that prohibits voting with a conflict of interest. I believe that there are other local statutes that prohibit that, but at least as I understand it correctly, I don't believe that would be a violation of the Sunshine Ordinance.
Okay. Were you aware of this allegation about the recusal?
No. I'm here. I'm Jillian Gillette. I'm Legislative Aide to District 8 Supervisor Scott Wiener, and I was asked today to read a statement from Supervisor Carmen Chu regarding the complaint against her. Shall I
The
begin
audience
again?
needs to be very quiet so that everybody has their appropriate time.
Excuse me, sir. Let her speak, please.
Why don't you go ahead and read the statement so we can try to assess what's going on, because this was not told to us before. So I want to make sure everyone has a fair opportunity to respond. But since I'm not sure what the statement says, please proceed.
Thank
and you
you.
have 5 minutes.
Supervisor Carmen Chu did not violate the Sunshine Ordinance by following the city attorney's advice that it was legal to consider the amendments to the development agreement and to vote on them without a continuance. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Okay, seeing none, the matter is with the task force. Member Nee?
Yes. Particularly in light of what Mr. Threedas told us, but I've already been thinking along the same line. With all due respect to the, without prejudice to the accusation regarding conflict of interest and regarding acting under conflict of interest, that is not something that is covered by the ordinance, as near as I can tell. And that's not to say that it doesn't deserve attention. It does. And I would strongly urge that the people who are alleging conflict of interest take that to the Ethics Commission, because that's where those allegations properly belong. I do have some other thoughts regarding the other sections that are alleged to have been violated, but I'll hold those for now.
Member Chan?
Well, I just want to add, if there's any criminal conduct you reported to the district attorney's office too.
So I'm a little bit confused as to whether we should I didn't hear any sort of detail about the specific codes related to Supervisor Chu herself. Is that these codes, they made mention of things being violated, but not with respect to what Supervisor Chu actually did. Is everybody on that same page? So I'm not sure if we want to continue this for the administrator to try to see if it's something that they should be sending to ethics, or, you know, based on the allegation of the recusal, or for DCA 3 to move forward. If someone has a thought on that, Vice Chair Wolf and then Member Neem.
My concern is that in hearing the complainant, the original complainant, Pastor Gavin, and then all the witnesses thereafter, they each stated a different section of the code without explaining exactly what the violation is. Just they're here to support in relation to that part of the code. The complaint that's made is usually this happened, and then it's in violation of something. We're not quite sure, and reading through the lots of memorandum from our legal counsel, he watched all those videos, as did I, and hopefully all the other members of the task force did too, to see where the particular issues that have come up are, but these particular sections don't necessarily speak to them in a way that can make sense to me. I'm more interested to have the complainant be very specific as to what it is the complaint is. We can figure out necessarily what part of the Sunshine Ordinance it violates, but we need to hear, it's not really lots of times incumbent upon the complainant to figure out what part of the law it violated. It just needs to tell us that they didn't do something. And then we can determine whether the item was public or not, whether it was given to them or not, whether there was a violation with regards to a meeting procedure or not, so on and so on and so on. And we'll determine, based upon what parts of the ordinance, those violations, because it could be one or more, any parts. And as you may have experienced in the previous sections that we've, we may have taken advice from our legal counsel and also from the complainant as to what those sections are, but we could also add or subtract from that. So I'm a little perplexed right now as to how to proceed. Okay. I'm equally a little concerned about the response from Supervisor Ellsburn's office, notably a communication that we received just today, which I won't refer to because I generally don't like to refer to items that are received on the day of a meeting. But I'm a little concerned with just the statement that they followed their city attorney's advice and that it was legal for them to consider the amendments and to vote with them without a continuance.
Before we get into that, let's address what their complaint is.
Okay.
I mean, just because I don't...
Well, I've heard conflict of interest, but then I hear all these other items.
Well, Supervisor Ellsburn's is for 11072.
I understand that, but but she was speaking on behalf of
Carmen
Supervisor
Chu.
So my concern here, you did ask Pastor Cabin what the complaint was about, and she mentioned it was conflict of interest. So that's really the thing, and I'm not sure if the representative from Carmen Chu's office is not here that we can get any answers. So,
Member Need?
A couple of things. First of all, conflict of interest, again, that's not our determination to make. That would rest with the Ethics Commission, if anybody. Second, Ms. Gavin, please approach the microphone.
Well, before you start asking questions, I wanted to try to see how to proceed. So that's something that we were going to do.
I have absolutely no doubt as to how we should proceed. But
well, could you tell us so that as the chair I would know?
That will come. Well, I think we should go ahead and finish hearing this case, but I have a specific motion that I will make at the appropriate time.
Okay, so if before you ask, I don't know if this is what you were going to ask, but just so that the full task force, we all seem to be confused, if you could just very specifically state what it is you're saying that Supervisor Carmen Chu violated, and relate it back to your complaint, and then you can proceed so that we're all on the same.
I wanted to ask the complainant, Ms. Pastor. Ms. Gavin.
Wait, but we're not there yet, Renee. What I'm trying to say is you're taking over the meeting, and I'm trying to make sure that everybody here has an understanding what's going on before you move forward. Can you just give us a very brief?
What I'm trying to say in layman's terms, because we were not allowed to see these documents and address them, the 14 pages of revisions, I have discovered something else that was there. I cannot say what she did know and what she did not know, and that's not what I am trying to say, because this has all transpired. We're very troubled that we have found out this information after the vote. And my supporters and I, we think that had we had the opportunity to read these documents before the final vote and give public testimony, we might have also had the opportunity to address this issue. So my whole argument really is because we were not allowed to do that, things like this happen, and it is very unfortunate for all of those involved. I cannot ask you who, what, when, where, or how, and But
can you address that specifically? Since this is against Supervisor Chu.
Supervisor Chu voted for the development agreement. It is also going forward. As with the Land Use Committee meeting, we were not allowed to give public comment on the 14 pages of revisions. We did not have the documents to see what was actually going into the development agreement, and that is the premise of my complaint.
So you are alleging not only that she should have recused herself, but also the same administrative sections about the agenda.
That is correct.
Okay, specifically against Supervisor Chu.
Yes, because this memo only surfaced with the final development agreement. It's not in any of the other ones prior to it, any of the drafts. So it was that very day. It was concealed, I think concealed. But if they all knew, we should have known. That is what I'm trying to say. So this is the only place it surfaces.
So let Member Nee continue now that we have a little bit of a better understanding. I'm going
to. Madam Chair, you've pretty much nailed it, but I will again ask, where or when or how did Supervisor Chu, not any other supervisor, Supervisor Chu, who is not on the Land Use Committee, how did she violate 67.7? Because 67.7 refers to an agenda, all right? She is neither the chair, she is not on the Land Use Committee, she is not the president of the Board of Supervisors, she does not shape the agenda. So I want to know how she violated 67.7. In terms of 67.15, which deals with public comment, again, she is not on the Land Use Committee. So she, as near as I can tell, did not do anything to prevent public comment at the Land Use Committee, which is where public comment was appropriately fielded. So where did Carmen Chu, specifically, Carmen Chu, where did she violate these sections?
It is the opinion of my supporters and I that she violated our constitutional rights at the Board of Supervisors meeting. When Supervisor David Campos raised the issue that they may be in violation of the Brown Act. Now, that gave everyone the opportunity to put the brakes on this thing and to find out what was going on, and he asked Supervisor Cheryl Adams to cite a case that she could in regards to what was going on, because none of them had allegedly read the 14 pages of revisions, and so his answer is valid. His statement is valid, and if they have not read them, and the public has not read them, whom are affected by these decisions, why should they go forward that date with the vote? And that is the issue I'm bringing before you tonight, because she voted to go ahead. She voted on the development agreement knowing that the residents nor the public had the opportunity to read the 14 pages or revisions or to provide comment. And it's troubling, and because of that, this is one of the issues that has surfaced.
Pastor Gavin, the document that you have that you found out about after the meeting,
yes,
could you give us a little bit of detail of how you came to acquire that document?
The document is with the development agreement that the Board of Supervisors voted on. I have a copy of this from the clerk of the board, and I went through all the other ones several times. It is not there. The document only surfaces with the development agreement the day the development agreement was voted on, May 24th.
Was it from the agenda on May 24th?
It's not referenced in the agenda at all.
I mean, was it included as part of the documents attached to the agenda?
It's in the development agreement. It's in terms of, it's Exhibit X in the development agreement.
So it was available to the public?
No.
It was not. You're saying
no,
it was not.
I can prove that, but
No.
that's not the issue. We're disturbed by it. It only surfaced the day, May 24th, the day that the Board of Supervisors voted on it. It is not in any of the previous revisions, which was one of the contentions that I came before you about the revisions of the 14 pages. It's not in that draft of May 20th. It's not there. So I could only, and I'm not trying to ask you, it's troubling. I'm not trying to ask you to decide if she knew or not, but somebody knew this was there, and who, we don't know. It's May 24th has passed. But what I'm just trying to say is, given how caught up we were with those 14 pages, how in the world did this document get in there and nobody say anything? Nobody has said anything about that. And it should have been disclosed to us because it was in the final vote.
Okay. DCA 3, you had a comment.
Madam Chair, the complainant is referring to an exhibit to the development agreement. The agenda item was approval of the development agreement, and the ordinance that approved that development agreement referred to the development agreement as being in the office of the clerk of the board. It's a voluminous document that, and when there are voluminous documents that are part of a agenda packet, the members of the Board of Supervisors typically may have copies of those if they request them. Often they are simply kept in the clerk's office, and they can be looked at as PDFs on the computer by the supervisors. So, I don't know personally whether that development agreement was present at the board, but it's more typical that the agenda specifies, as it did here, that if you'd like to see the full documents, you can go to the clerk of the board and request to view them.
Does the task force have any more questions? Vice Chair Wolf?
Yeah, my concern is with the comments that were made on behalf of Supervisor Chu by a representative, Supervisor Ellsburn's office. Sorry?
She's Supervisor Wiener's.
Oh, Supervisor Wiener's office, I'm sorry. My concern is, and I'm sure we're going to hear a lot about this in most of these kind of cases. But the issue is not, we have no power or authority to prevent a vote of anybody, any entity or any particular policy body in the city. It's not our purpose here. Our purpose here is to determine whether items are public and whether items have been made public or not, and whether meetings have been held properly or not, and whether, as I observed for this particular case in the videos, whether, and the questions that were brought up, whether amendments were of some substantive nature, that they changed the actual nature of the the item that was going to be voted on, and thus were not properly made, were not publicly noticed properly. With regards to this particular case, I'm having difficulties because it seems the focus of this seems to be on these additional documents that surfaced sometime after the vote of the developers agreement was made by the Board of Supervisors. And so I'm not quite, I have to agree with Member Nee and with our legal counsel that, I've just been trying to search high and low for a conflict of interest statement or statute of some sort from the state level all the way down to our level, and I am still searching. I still can't find one. So it may be a board rule. We do hear about board members of the supervisors recusing themselves for such things, but it's not necessarily within our jurisdiction. That would be something that would again, I agree with Member Nee, be taken up with the Ethics Commission, because it would have been in violation of their own rules. And their rules, we have no jurisdiction over their own rules.
Does the task force have any more questions? Okay, at this time, the respondent and then the complainant will have 3 minutes for rebuttal. Does the respondent have any additional comments to make? Okay, just for the record, I'd like to note that the respondent is stating that no, they do not have additional comments to make from the audience. So the complainant will now have 3 minutes.
There are known knowns, known unknowns, and unknown unknowns, things we don't know that we don't know, said former Secretary of Defense Donald Rumsfeld. We do not know the who, what, where, and how. It is just alarming that this document surfaced on the day of the final vote. It is our belief that had we been given the opportunity to read the documents that were amended, perhaps we would have caught this. We will never know that answer, and that's something that not even the task force can determine. But because of actions like this is why you were created. Because the people in San Francisco want open government, and the people in San Francisco deserve open government. Once again, I said that we will not know, but we were denied the opportunity to read those documents going forward in the Board of Supervisors meeting. We were denied the opportunity to comment. And it is very disturbing when those things happen, situations like this arise. And we, the people of San Francisco, we deserve open government. Thank you.
Thank you. The matter's back with the task force. Member Nee?
I'm not sure a motion is even necessary in this matter. If there is one, it would be, I think the appropriate motion would be to dismiss the complaint against Supervisor Carmen Chu. We already found previously in a complaint brought by Ms. Gavin against Supervisors Chu, that would be David Chu. Scott Wiener, Malia Cohen, and then also the name Eric Marr was later added to the list. This was in case number 11048. We found that there was violation of 67.7. And I don't think that under those circumstances it would be necessary to repeat, to take that vote again. But this particular complaint is against Supervisor Carmen Chu. She is charged with these violations, and I just don't see that in her case they're there. I would recommend that no action be taken, but if a motion is necessary, then it would be to dismiss this complaint against Carmen Chu.
Are you making the motion?
No, I don't think a motion is necessary here unless there is a motion to find violation.
Okay. Is there any other? Okay, I tend to agree with Vice Chair Wolf and Member Nee, and especially what Member Nee said about it. We don't mean to say it's not an important matter, and there are other administrative remedies, but this may not be the appropriate jurisdiction, and we urge you not to take that as a meaning that you shouldn't move forward with what you have found, and that this is specifically about Supervisor Chu. Is there any public comment on this item? You'll have up to 3 minutes.
Thank you. My name is Jason Grant Garza. Once again, I'm in front of this august, robust body, and I'm a little perplexed here. I have in front of me the San Francisco Sunshine Ordinance, and the spirit of the ordinance is that, it says, that the public should have access to the workings of government, and that new approaches are constantly affording, people the ability to circumvent sunshine. If something was conflict of interest, well, that is sunshine. Excuse me. That's good government. How can you have a conflict of interest and then vote on something? This should be brought up in sunshine. To go to ethics? I mean, here it says the public officials who attempt to conduct the public's business in secret should be held accountable for their actions. Well, if this document just came up, it sounds pretty secretive to me. So as far as the spirit of the Sunshine Ordinance is concerned, once again, I think you're failing. Thank you.
Thank you. Is there additional public comment? Okay, seeing none, public comment is closed and the matter is back with the task force. Is there Member Washburn?
I think I want to just reiterate what you said earlier and add a couple of things regarding this particular case to the complainants, that we're looking at these matters, all of these different complaints we're finding that we have to look at them on a complaint-by-complaint basis, that we did find, as Member Nee reminded us, violations for the Land Use Committee. And so the matters before us now are with regards to the later in the day, Board of Supervisors meeting. And there were a lot of parties of interest there, and so in reading through DCA Threat's thorough analysis, I think there are some other matters that will be pertinent to other complaints where we will have different issues and may reach different decisions. So those are my thoughts.
Okay, seeing no motion, this matter is closed. Mr. Rustin, will you please read items 15 and 16, which are going to be heard next?
Yes,
I'm sorry,
Madam
item 15, just the jurisdiction.
Item 15 is file number 11072, determination of jurisdiction on complaint filed by Anonymous against Supervisor Sean Ellsburn for allegedly violating certain sections of the Sunshine Ordinance at a recent Board of Supervisors meeting.
Move to find jurisdiction.
Second.
Is there public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Can we take the motion to find jurisdiction without objection? I just did public comment. Okay, so the jurisdiction is found. Mr. Rustum, can you please read item 16?
Item 16 is file number 11072, hearing on complaint filed by Anonymous against Supervisor Sean Ellsburn for allegedly violating certain sections of the Sunshine Ordinance at a recent Board of Supervisors meeting.
The complainant will now have 5 minutes to present her case.
Supervisor Sean Ellsburn is the sponsor of the Park Merced project. It's his district that the project is going to take place in. Supervisor Ellsburn sat on the diocese of the day of the Land Use Committee meeting. Supervisor Ellsburn is also an attorney. I find it difficult to believe that Supervisor Ellsburn did not think it was important when the rights of his constituents were being violated in a land use meeting, and they voted to move forward with the revisions to the development agreement, which ultimately has led to many other things. So I am here because I do think that Sunshine has jurisdiction in both of these cases, and I think it is extremely alarming that moving forward to say that the supervisors vote. I think one of the things, as I said, I'm new to Sunshine, but out of everything that happened that very day, it was a very contentious day. One of my neighbors who was here with me, she turned pale. I thought she was going to have a stroke. And I left respecting Supervisor Avalos. I left respecting Supervisor Campos, because if they didn't understand anything, those who were present at the Land Use Committee meeting, Supervisor Campos told them what might be wrong. He told them. He said the Brown Act. He said it to all of them. And I'm thinking, my God, how can they stand there as officers of the court, sworn under oath, sworn to protect the federal and the state constitution of this country, and say we cannot read the documents, to say we cannot speak? I am an American. And those who violated the rights of the residents of Park Merced, thousands of people, because what you do not know is that the toxins alone that are in the EIR will stay in the air for 20 years. That is what they said, not what I said. So for any of them to go forward and vote on this development agreement that impacts people directly, not 5 years from now. We're talking about people's homes. People's homes in the United States of America, not the Gaza Strip, not Pakistan, San Francisco, California. We're talking about open government that was voted for under Proposition G in 1999. And in my opinion, as many of them, 9 out of 11 are attorneys, they are in violation of our rights under the federal Constitution, and they are domestic terrorists.
Thank you. Is there anyone in the audience to present facts and evidence in support of the complainant? Seeing none, is the respondent present? So earlier, Mr. Volberding was here. Does anybody know where he went? No? Could you speak into the microphone so that it can be recorded? I'm sorry to...
Sorry, all of us, I'm Andrea Bruss, I work for Supervisor Malia Cohen, so I think all of us were prepared to go forward with our respective complaints today and had sort of the same response based on the information that we had in the complaint. I think the majority of us, having not received any follow-up or supplemental detail about what it was, assumed that it was similar to the complaint that we addressed on September 27th, at least for the respective land use committee members. So I know that Alex had to leave, but he had the same statement that we also read for Supervisor Carmen Chu.
Okay.
And I know that he submitted something supplemental. So
Thank you. So Mr. Volberding did present a response. You received this today, Mr. Rustum? Is it?
Yes, Madam Chair, at about 3:30 this afternoon.
And it's pretty lengthy, although we just received it at 3:23, and it would have been nice if Mr. Volberding had told our administrator that he had to leave. But nonetheless, although respondent is no longer present, he was aware that we were going to be moving forward with this particular complaint. So is there anybody in the audience to present facts and evidence in support of the respondent? Okay, seeing none, the matter is with the task force. Before we get started, I want to introduce one additional thing that I learned. And that is that Supervisor Ellsburn was present at the May 24th meeting of land use. And the reason I'm introducing this is because Supervisor Chu's aide, Judson True, and I were trying at the meeting at our meeting when we heard the complaint against David Chu, we were talking about why this had been continued, why it had been continued to May 24th, and I thought it had been continued for this environmental impact report. But what really happened is that on March 29th, the Board of Supervisors heard the Planning Commission had already approved the EIR, and they approved it by a narrow vote, 4-3. And there were a number of appeals, I think, on March 29th before the Board of Supervisors, because they were appealing the Planning Commission's approval of the EIR. So the EIR, there was some significant discussion about the rent control provision and whether it could be enforced. And they were curious if that would impact the EIR. And eventually, after a lengthy discussion about whether the rental agreement could be enforced, they moved it for 2 months. They continued the appeal, the decision on the appeal of the EIR for 2 months. Meanwhile, the development agreement itself was moved to the Land Use Committee. And there's this 60-day rule, I'm not exactly sure what it is, but it waits like 60 days before the committee hears it. So on May 16th, just before the March 24th meeting, just before the May 24th hearing of land use, on May 16th at land use, the development agreement was on the agenda. But it was, I don't know why, but Supervisor Marr begins the meeting on May 16th by stating that the development agreement was improperly noticed, so they wouldn't take any action on it. And he states that at the very beginning of the meeting. They hear a different item, and then they hear the item of the development agreement, and Supervisor Marr again states that no action will be taken on the development agreement because it was improperly noticed. Supervisor Ellsburn then introduced some technical amendments. No mention is made of these 14 amendments that David Chu introduced. So there's nothing about the amendments, the 14 pages of amendments. But what's interesting about that is that even though they stated no action would be taken, Supervisor Ellsburn asks them to approve his technical amendments, and they approve them. And then they move the meeting to May 24th because it was improperly noticed. So on May 24th, they introduce these amendments. They talk about the technical amendments, Then they introduced the 14 pages of amendments with David Chu. Meanwhile, at the board, at the board, just a few hours later, they were going to hear the appeal, the land uses referral, and the development agreement. So I wanted to clear that up because there had been significant confusion when we were discussing the different items about the environmental impact report, the land use meetings, and that's Vice Chair Wolf.
Okay, so I have a number of questions. And first, Pastor Gavin, if you can come up to the microphone, it'd be good if you can sit in the front row because we may have more questions through the proceeding. In this item, can you give me a specific? Can you tell me specific, or tell us specifically what you feel Supervisor Ellsburn violated? Not the sections of the code, but what you feel he violated that is different than the item that we heard in September.
I think Supervisor Ellsburn violated the non-disclosure of this document as the sponsor of this project.
Which document?
The memo.
Which memo?
The memo for Stellar Management to make a contribution to a project in Supervisor Carmen Chu's district, and the memo is approved along with the development agreement. If we can all remember, the only thing that was allegedly new on May 24th were the 14 pages of revision. Nothing else was discussed or said that was new. Therefore, I can only surmise that the document was already with the development agreement as it is online. If you go online this very minute, it's with the last development agreement that is voted on, and it is not in any of the previous drafts, not even the one for May 20th. And given that the people were not aware of it, I cannot definitively say that he knew, but he is a lawyer. He has sunshine training, he's undergone it. Someone knew the document was in the development agreement and didn't get there by themselves. But we're here because when you cannot read things and you cannot address them, heaven knows what else is in there.
Okay.
Heaven really knows.
Okay, so the problem I'm having, logically I understand exactly what you're saying. The problem I'm having is that I'm not fully prepared with either legal advice or with information that points me to that particular memo that will give me enough knowledge and education so I can, come up with my own decision about this that could either support or not support the item. So it makes it very, very difficult not knowing exactly what it is that we're supposed to be here to rule on and to decide. And I don't know how many pages of advice that DCA 3 have put out for us that I've been reading throughout my Thanksgiving vacation. I mean, this is my agenda.
Yeah.
Okay. And so, there's nothing in here that speaks to your issue.
I think the Brown Act.
No. But I don't have any information that says that this document existed here, but it didn't exist at this particular point in time, but it existed at some other point in time. That document isn't even part of the agenda. So I don't even sitting at home before coming here and reviewing all my notes and all my I have tons of questions to ask. None of these questions apply to your complaint.
I understand that, and I'm not trying to get caught up in the memo. I think that, as I said, when Supervisor Campos said that they could be in violation of the Brown Act, I think all of the supervisors should have taken note of that. He nailed it.
I know, but what's the complaint?
That is my complaint, that they went forward. Given the behavior of the Land Use Committee, they voted on items that they said they had not seen. They did not allow us to read the items, nor were we able to see the revisions. They went forward with that reckless behavior.
So are you talking about the 14 amendments?
Yes.
Okay. So if we're talking about the 14 amendments, I'm prepared to proceed with that.
Yes.
I cannot proceed with additional items that may or may not have been in the agenda that you're now you're saying that recently surfaced or what have you, because that's not we didn't actually get a sufficient complaint from you. So it made it very difficult. It's why this is going to take some time, because now that I hear what you're saying, now I can proceed. Okay. But I cannot, and I will not address the issue of the memo.
I understand that, because it's a phantom memo and we don't know who did what. I understand that.
So thank you very much. You can have a seat.
That.
I have a few questions for DCA 3 to start with first. There in the video and in your memo to us, there was a section that stated that that the developers had seen the amendments and had agreed to them prior to the meeting, the land use meeting, and that was a quote. It was DCA Adams who had said that during the Board of Supervisors, I believe during the Board of Supervisors meeting. So the question,
I think it may have been DCA Sullivan, but yes.
Okay.
Yeah.
So the question I have is, what is the status of those communications prior to a meeting with a developer? In this case, this development agreement between the city and a developer. So this is not an RFP situation where you have a competitive, secret kind of procedure. This is a open, a kind of agreement between the city and an existing developer. Are those communications considered public information prior to the meeting?
You're assuming they're written communications?
Yeah, well, they said the statements, the testimony was from the DCA, whichever DCA it was that the developer and the developer had already agreed to the amendments.
Yes, let me just back up for a minute and give a little fuller context. The question before the board at the time was Supervisor Avalos had stated that he would like to amend the development agreement at the Board of Supervisors. Excuse me. The chair then turned to the deputy city attorneys and said, is that legally possible? I believe that DCA Adams first gave a response and then DCA Sullivan gave a fuller response. And that response was that a development agreement is a contract between the city and the developer. And that the only way to amend a contract is if both parties agree to that amendment and consent to it, that the Board of Supervisors could not unilaterally do so. Supervisor Avalos took a period of time to think about that, and then he had another question for the DCA, which was, well, then why is it okay that the 14 pages of amendments were approved by the Board of Supervisors? And I believe as DCA Sullivan said that those amendments had previously been negotiated between the city and the developer, and therefore when they were introduced at the Land Use Committee, there had already been mutual consent and the board could adopt them.
So my question is for the discussions or communications or paperwork or information that was passed between the city and the developer prior to the land use committee, would that information, those communications, would they be considered public information?
I'd want to take a close look at it. My initial read on it would be certainly after the agreement is adopted, probably so.
But we're talking about prior to the agreement being adopted.
I don't know the answer at this time.
Okay.
I'd like to review the ordinance.
And
can I ask you, is it something that you need an answer to make a decision tonight?
Well, kind of, because there's questions as to whether I'm going to go down a line of questioning as to whether the amendments that were introduced that day were made available prior to made available to the public when the agenda was presented. And the question then becomes, if the amendments were available even as work product, even as documents that were and I'm trying to determine whether they were public or not, whether they may have been available to the public even prior to the meeting, and would the supervisor, if asked, made those documents available. You follow where
I follow what you're saying. I don't exactly see how it's relevant to this complaint, because there's been no complaint that they were requested prior to that meeting. There is some dispute between members of the public and members of the Board of Supervisor and their staff about when the documents, the 14 pages of amendments, were made available. The Board of Supervisors staff and the supervisors alleged that they were made available at the same time that they were provided to the supervisors on the Land Use Committee. There were many members of the public during public testimony who had said they had been unable to obtain those documents.
Okay, well, let's ask the
Could I just ask you a question?
Yeah.
And I don't know if this will help you,
Mm-hmm.
but Supervisor Cohen in the Land Use Committee said that she had seen them 1 hour before. She'd only had about an hour? No? You're going to have to...
She said, and I quote, "I would have liked to have seen them like most people in the audience, but Michael Yarney had called her the day before and referenced them to her, and she felt comfortable going forward, but she had not seen them either before that day."
Maybe that does not help you.
No, it doesn't. My question becomes, if they're saying that the amendments weren't available until that day, and there's a statement saying, and I'm reading from your notes, DCA Sullivan responded that the 14 pages of amendments adopted that morning had already been agreed to by the developer prior to their introduction. The question is, and then during the Board of Supervisors meeting, the chair states that all the supervisors have the amendments, and so I don't know when those amendments were delivered and how quickly. But my concern is if they had been agreed to by the developer prior to their introduction, who was working on them with the developer, and who and for how long prior to that? It's more of a question for the supervisor as to where at that point were those documents then available.
Member Wolf, if I may, I believe under an analysis under public meetings law, under the Sunshine Ordinance, the public meeting portion of that, that the relevant question is, were they made available at the same time as they were made available to the public at the same time as they were made available to the members of the committee?
Right, okay.
Now, in terms of if someone had made a public records request, that's a different question.
Okay.
I'm not aware that any was made.
Okay.
And I can tell you, although I don't have detailed information of this, my general more anecdotal understanding is that DCA Sullivan was advising the department in the negotiations with the developer, and so he probably was the one who had the most, possession and knowledge of where the documents were at any particular point.
Was he doing this on behalf of a supervisor or on behalf
No,
of?
I believe he
department?
was representing the. Trying to think of the exact department that was heading it. You know, it was either the planning department or the mayor's office of economic and workforce development. I'm not
It's
sure.
not David Chu because they were his amendments?
Excuse
Was
me?
he working on them with David Chu because they were his amendments? I know they said they worked on them all night the night before together.
Yeah, I believe you're correct. And Supervisor Chu was holding multiple meetings according to what he said at the committee meetings. But the contracting party in the agreement is not Supervisor Chu. So the department is the contracting party on behalf of the city.
Okay, so then that takes me to my next question, which goes in alignment with your your supposition that around open meetings. In the actual agenda item, it lists a number of, it lists the item that it would include any one of the following documents. It doesn't mention anything about amendments. I don't know whether that, on page 3 of the agenda, you notate, on page 122 at the top.
Yes.
You say, in addition, page 3 of the agenda contain the following language. Now, is this just general language? It's always in every agenda?
It is, as my understanding is that it's a general notation.
And is it within the, how should I say this? Is it appropriate, is it in, because I don't know this for sure. I don't know how to say it in a way that's not leading. When amendments are presented to a committee on an item that has been continued, so it comes back up again, are those amendments required to be agendized?
The question is whether I think there's two questions. One is whether the agenda description was sufficient to cover the item as amended. If it is, generally the agenda descriptions are of such generality that they tend to cover amendments. Occasionally it happens that they're not, as has occasionally happened here. And the other question is whether any amendments that have been introduced make such a substantial change to the agenda item that it requires that it be continued and additional public comment taken.
Okay, so going down that line, when I think it was DCA Adams was asked by Chair Marr of the Land Use Committee whether this was appropriate or not, and whether it changed things substantial. Let's keep the Board of Supervisors meeting because that makes it even more apparent, the questions. She said that it was within the scope of the contract. And the question then becomes, that is for us to determine as to whether those amendments were substantial or not. And she used, I think, a statement, something that it was a matter of art.
A term of art.
A term of art, which I find to be a little odd use of by an attorney. Well, not necessarily. I wouldn't necessarily say that because if things are up for at certain, if things are written very vaguely and it's up for real interpretation, people can get very creative in how things would be presented. But I think with regards to substantiality, especially on a contract, it would be fairly clear as to whether the amendments would be substantial in changing the nature of the motion or the item that has been presented on the agenda, which is what...
Yeah, I would say I believe under that portion of the ordinance that is a fair statement of the question. It's whether... I'm sorry, I've lost your exact phraseology, but it's whether, you can look at a substantial change in different ways, and really the appropriate question is whether the change is substantial in relation to the item as it was being considered. Because there was an item, it was agendized, and now it's going to be changed. Is the changed item substantially different than the one that was originally agendized?
Okay.
So when DC Adams phrases it as a term of art, I think what she's saying is that you have to consider the context which the phrase is being used in and what is its purpose. And I believe she was saying that the changes made by the 14 pages of amendments, when considered in the totality of the development agreement, do not substantially change that agreement, and therefore it need not be renoticed.
Okay. Have you reviewed those amendments in relation to
No, I have not.
Okay, so we can't ask your advice as to whether you feel that they were, as a lawyer, our attorney, as to whether they were had substantially changed the
I'm not
item or
prepared to give that, and I tend not to give advice on that particular issue because that is a determination that is within the responsibility of the task force. I'm trying to illuminate the question as best I can so that then you can ask questions of the complainant and the respondents as to whether these are substantial changes under the ordinance.
I'm disturbed by that. Okay. Okay, the only, I'll let others have at it in a moment. I just wanted to say that I find it very interesting that Supervisor Campos, who is also an attorney, who has also worked in the city attorney's office, found that the 14 pages were very extensive and they were substantive, and they made substantive changes. So,
and I'm happy to speak to that as well. You said let's put aside the Board of Supervisors for a moment. And
yeah,
focus
okay.
on the Land Use Committee.
Let's do that.
I think Supervisor Campos was looking at it through a different lens and different context. He was looking at the changes themselves and how they affected the residents in the area of Park Merced. Looked at through that lens, they are substantive changes.
But how do we know that unless we ask them? I mean,
I believe that they've been very clear that they believe that those are substantive changes.
No. But how do we know that that's what Supervisor Campos was thinking?
Because he described these changes and he said they're obviously substantive. Look at what they do.
Right. So
he's taking them in isolation as they relate to the residents.
The task.
I'm sorry, Member
task-
Snyder?
I mean, so other members can correct me if you think I'm wrong, but we've already decided in the context of the Land Use Committee that the changes were substantive and that it was improperly agendized.
Right.
We've already decided that.
Okay.
So I think, I mean, right? Is that not the decision we made?
Yes.
Yeah. So
But the hard part here is that Supervisor Ellsburn is not a voting member of the Land Use Committee.
So the question, so the question here is,
okay.
does the same analysis apply to the Board of Supervisors?
Got it.
I think that's the question, right? And so does the Board of Supervisors agenda item, does our analysis, assuming we want to carry it forward from the Land Use Committee, does the same analysis apply to the Board of Supervisors agendized item?
Okay.
And I
Go for it.
I don't have the answer to that question. All I can do is tee it up. I honestly, I don't know. I haven't been able to.
I was thinking about that, and then the context of what we decided was that they were substantive, and they didn't provide adequate time for the public to review them and comment on them based on the agenda description. But what's different at the board is that because the public comment was being taken by land use, there would be no public comment at the board.
Right.
So that makes it a little bit different. I mean, what we were saying about land use is that they had the opportunity to ensure that the sunshine ordinance was followed before they referred it to the full board. Now, I know they were referring it to the full board only a few hours later, which is why we didn't feel there was adequate time for them to review it. But would that apply to the board where no public comment would have been taken anyway? Yeah. Member Cawthon?
At the Land Use Committee, Supervisor Marr was very concerned that the precepts of open government were not being followed because there was not an opportunity to observe those those 14 pages of amendments, so that even if they did have public comment, the public comment was exclusive of people having reviewed the document. But I thought, frankly, I thought we'd already ruled that that was inappropriate.
Well, that was at land use, and Supervisor Ellsburn has no control over land use. And this is directed at Supervisor Ellsburn. He's not a voting member, and he's not on the committee. So that makes it a little bit difficult for me, because he couldn't vote on it there. Now, I know they're bringing this before the board too, although keep in mind that on May 16th, they added those amendments, even though they said they wouldn't be taking any action. And that was at Supervisor Ellsburn's request, but that's not the 14 pages of amendments. So that makes it difficult, because now you're focusing on the board, where Supervisor Ellsburn actually had an opportunity to take an action. And the question for me is, as Vice Chair Wolf was saying, we don't want to tell them how to, what kind of a vote they can, they can take. Member Washburn?
Yeah, I think the reason we're even listening to or hearing this matter, this wasn't the one that Pastor Gavin asked us to consider tonight, is because Alex Volberding was in the audience. And I think that for the Carmen Chu matter, we decided we didn't make a motion to find any violation. I think this is similar, but we do have complaints against DCA Adams and DCA Sullivan, and I think there the matter becomes different, because they're advising the supervisors about this agenda item and whether it's substantially different. And so we found with the land use committee that it was substantially different, and the public didn't have a chance to comment. So I think when we get to those matters, then the issues will be different, and there might be some violations there. But I think in this particular complaint, just as with Carmen Chu, I don't see a violation for Supervisor Ellsburn.
Vice Chair Wolf?
I'm a little bit of a disagreement with that, because the legal counsel's purpose is to provide counsel. It's supposed to be appropriate, and it's supposed to be factual, and whether they know that particular area of law or not well or not, it's only advice. The actions that are taken by the elected officials is what really counts. And it's really the responsibility of the chair to conduct a meeting properly and to make rulings as to whether something is appropriate or not appropriate with regards to a meeting procedure. If any of the other members have a problem with that, there is a Roberts rule to appeal the decision of the chair, where they all then vote to determine whether the chair was correct or not. And I think that's the crux of the matter here, is that if there is question by the supervisors as to whether it was appropriate or not, because whether the items were substantive or not, I think the crux of the matter is that the item of the 14 amendments was introduced that day at an earlier land use committee hearing. It didn't provide the public enough time to be able to review them and provide any kind of public comment. That's why we have a 3-day rule on agendas and items that are presented. And then when they get to the Board of Supervisors meeting, their board rules are, if there was, actually I think it's Brown Act, right? If there was a subcommittee where public comment was made available, that there's no further public comment is needed at the final decision by the policymaking body. So I think really that's the crux of the matter here, that we really have to determine as to who is responsible. Now, maybe some of those supervisors, maybe they don't know Robert's rules, or maybe they weren't strong enough to step up to the plate and that were concerned about it and say they wanted to make a motion to move to continue or what have you. But be it as it may, if there was a question by the chair, which I think at that time was Chair Mercarimi. I think the gavel had been passed to Supervisor Mercarimi so that Supervisor Chu could speak on the matter of the amendments. I think it was Supervisor Merc. Am I correct in that?
What about what Member Washburn is saying, that basically this is the same case as Carmen Chu's with all the same facts?
I understand, and but the case with Carmen Chu was not presented in the same way.
Okay.
The case with Carmen Chu was presented with the memo as being the center of focus.
Okay.
Okay, despite our insistence to ask what the complaint is. And that's why I was very insistent at this time, because the memo is not specific to Carmen Chu in this case. We're talking about something different. So the question is who's implicated? Are all the supervisors implicated because they all violated the people's right to be able to see, in that kind of way? This particular case is focusing on one supervisor. Obviously, when you look at the agenda, almost every supervisor is mentioned. So, and even the ones that brought up the concern that may have voted against the item, they are also implicit of this too. I mean, everybody who's in the meeting is implicit of the violation, as far as I'm concerned. So I'm going to stop there so I can think a little bit, because I'm not sure how to formulate where to go next.
Would it be helpful to go to rebuttal? Okay, so the respondent, I'm going to double check that the respondent is still not in the audience. The respondent is not here. So the complainant will now have 3 minutes to issue any last remarks.
Good evening. I would just like to reiterate that there are many things that happened that day. Perhaps if someone had taken a moment and stepped back and maybe we're going too fast, maybe we need to think this through, or just had continued it one more week, I might not be here. We may not be here. But that did not happen. I am here because our rights were taken away in regards to public comment and the ability to be able to read these documents to find out what was going on. What you do not know is that it impacted the community adversely. It was a traumatic experience for many of the residents, including myself, and this has been the forum where we could address it, because we did not know. We were not given the opportunity to read these documents. Planning has never been forthright with them. But this is what happens when the public cannot see what is going on, when we do not have open government. It's things such as this and many other things that can be devastating in the long run after the ink has dried on the paper.
The matter's back with the task force.
Okay, Madam Chair.
Yeah.
So I'll have to defer to our attorney appointee member and to our legal counsel with regards to the intention of both California Public Records Act and the Brown Act and the Sunshine Ordinance in deferring or making, giving deference to the public for the most open government, whether it was appropriate or not for the Board of Supervisors, of which this supervisor was possibly, depending upon our decision today, implicit to, was the public given enough time to be able to analyze, research, and make a proper response, so that the best interests of the public by the Board of Supervisors' decisions would be made. And if your answer is like it was for land use, that no, not enough, then I think we can make a motion.
Well, I think the Brown Act. I think the Brown Act and the Sunshine Ordinance both have fairly, and I think they're identical, specific requirements as to when documents that are under consideration by the body have to be provided to the members of the public. And there are a few different circumstances that apply, and I don't have all of the details on memory. I think, and we decided in the context of the Land Use Committee, I think we did not find a violation of those provisions. I'm going from memory here. I think we found a violation of the agendizing requirements of the Brown Act, which are, did the agenda fully and completely describe, or sufficiently describe the actions that were to be taken and were taken by the body. And we decided that that wasn't the case. I don't think we found a violation based on the provision of the documents to the public. I may be wrong about that. But I think the more fundamental issue here is whether we can find Ellsburn, whether Ellsburn was in a position, whether Ellsburn can be said to have violated the Sunshine Ordinance or the Brown Act as an individual supervisor. And we decided in the context of Chu that she was not in a position, that she was in a position where she couldn't be said to have violated either, because there's nothing she could have done. And so I think the question is there anything different about Ellsburn? Because it doesn't matter if the documents, let's just assume right now that the documents weren't provided to the public in a timely fashion under the Brown Act or the Sunshine Ordinance. Just assume that's the case. Even if that's true, could we find Ellsburn in violation? Because did he have any control over when those documents were provided to the public? That's the question I think that we're to answer here.
I think one difference is that the land use was assigned with making a referral to the board, and those amendments were introduced at land use, and they were the ones that had the opportunity to stop them. But the board, the notice of the board was the approval of the overall full development agreement. And the land use did not they made a referral without a recommendation, but they're the ones that adopted the amendments. Vice Chair Wolf.
My concern is not so much with land use. My concern is what happened with the Board of Supervisors meeting.
I'm just saying that's what the difference is. They didn't adopt the amendments. The amendments were adopted by land use.
Right. Well, they were adopted by land use, but then they would have to be finalized because they were inclusive. The amendments were inclusive, and I don't believe that they could be voted on. They could be approved by the land use committee de facto, and that's the end of that. They would have to be presented as amendments to the Board of Supervisors, and the supervisors would have to vote on it.
They were not presented as amendments, nor were the technical amendments. The land use is the one that approved both the technical amendments introduced by Ellsburn and the 14 pages of amendments introduced by Chu. Now, I don't know. I'm not familiar enough, and I don't think we're covered by it to know if they could have tried to adopt those out, but they were not introduced as as amendments that needed to be approved. They were introduced as a collective of the development agreement at the board.
I was in the impression that it was the development agreement plus the amendments plus something else that they were voting on.
DCA 3.
Through the chair, the excuse me, the referral from the Land Use Committee to the Board of Supervisors was the ordinance adopting the development agreement as it had been amended in committee. There were two sets of amendments that day. One were referred to as the technical amendments by Mr. Yarney, and the second set were Supervisor Chu's 14 pages of amendments. Those
But
were
the
all
technical amendments were adopted the week before.
okay. You were correct, but they were described by Mr. Yarney at the beginning. So the referral to the Board of Supervisors and the agenda item that was before them at the time of their vote was the ordinance adopting the amended development agreement. There were also two, I believe, related items. One was in the IR, and I don't recall what the third one was, but it was also related to the project. But the one that's being complained about is the ordinance adopting the development agreement.
Right. So that's to me, it's inclusive. They're by adopting the ordinance, they're also adopting the amendments. And they're noticing a change because the item had already been introduced, it had already been in committee once, it had been continued. The amendments then came that day, and then, the whole package got moved forward. So I'm just, to me, I'm looking at whether, what is appropriate as far as what's under the Brown Act or Sunshine Ordinance with regards to presentation of amendments. Like the board may have its own rules with how amendments get presented, which are not law. They're just their own. They're just their own rules. This is how to go. They're guidelines, basically, on how to do things. And so, whether they were law or not, the Sunshine Ordinance supersedes those, because they're not. If we're gonna, I don't want to get into the argument about the charter because those items wouldn't be contained in the charter. They'd be contained in lesser codes. So, to me, when you look at 6736. Even if they had a guideline that presented how to present amendments, if it says that amendments could be presented at any time as long as they were, didn't change the item substantively and documents were delivered to everybody in person on the day of or what have you, I believe I'm paraphrasing it correctly. Question is whether that results in greater or lesser or more or less expedited public access to public information. And that's where the ordinance has its power and authority. Did the action of not allowing further public comment by continuing the item, which I'm stating the entire Board of Supervisors and whoever was chair, individually or as an entire body, was implicit to. I mean, I think it was made apparent by many supervisors, especially the ones that voted against it, that the public did not have expedited public access to the public information. And
So you're saying they should have taken public comment at the board, even though?
No, they should have continued the item. Now, there is issue as to time frame, and that time frame, based upon your explanation of how things got shuffled back and forth, I don't know whether that was by accident or on purpose. I can't tell you, but the fact that it ended up at the day of the deadline that they had to make the decision, I think they could have opened it up for public comment, or maybe even, continued it to the end of the day. I mean, during budget time, they go till midnight sometimes.
Right, but you're bordering a little bit on changing their normal procedure.
No, I'm stating that whatever procedure they need to make to provide greater or more expedited public access of public information shall apply.
I'm just going to let DCA 3 make his statement, whatever it is, because I think it's relevant to whatever you were saying.
Through the chair, I just wanted to add one additional thing. In terms of, I wasn't here for the determination on the last complaints Anonymous made, but my understanding from the description from Member Snyder is that the task force found that the agenda description was not sufficient to cover the amended ordinance. Well, there was the same agenda description at the Board of Supervisors. So to the extent the task force did not believe it was a sufficient description, then the same conclusion would necessarily be the case on the ordinance that was adopted by the Board of Supervisors that day.
So, but what about the idea that there was no public comment? There would be no public comment anyway.
That's a wholly different issue. I'm not speaking to that issue at the moment.
You're only talking about the agenda.
Yes.
Wasn't.
If the task force concluded on the previous complaints, which were about the land use committee meeting, that agenda description was not sufficient to cover the amended ordinance, well, it was the same amended ordinance and the same agenda description at the Board of Supervisors.
But it was based on, you want to see? Part of the thing is that there was a dispute as to whether the public received copies of the amendments with adequate time in connection with the agenda item to notice the substance of the relevant agenda item.
Are you looking at the order? Is that what you're speaking
Yeah,
for?
so
Okay.
maybe there are two separate, because we found, do you want to see?
Yes, please.
This is the Eric Marr one, but the others are identical. I have that one too if you want to look at it.
Madam Chair.
I'm sorry, Member Neem.
The task force already found that the agenda was insufficient. We found this in complaint number 11048, Anonymous versus Supervisors Chu, Wiener, and Cohen. Later, Supervisor Marr's name was added. We've already found that. So that's water under the bridge. We are being asked here to look specifically at the conduct of Supervisor Ellsburn. There are specific complaints lodged against Supervisor Ellsburn, specific sections, allegations that he violated specific sections of the Sunshine Ordinance. With respect to 67.7, he is not on the Land Use Committee. He could not have shaped the agenda. With respect to the
No, but they're talking about the board meeting.
okay, he's not the chair of the board.
Okay.
He's not the president of the board.
Okay.
With respect to section 67.15, public comment was taken at the Land Use Committee. Again, he is not on the Land Use Committee. He has no control over that. Because public comment was taken at the Land Use Committee, it was therefore not required at the Board of Supervisors unless there was substantive change in the item between when it was at the Land Use Committee and the Board of Supervisors. So I think 67.15, at least in Supervisor Ellsburn's case, is out the window.
That's sort of what I was trying to say too, that they have a procedure that they followed, but we declared that land use was not adequate, but the board kind of went through it. But Member Washburn?
Yeah, I agree completely, and I was happy when DCA 3 made the comment he just did. I think we've already found a violation with the Land Use Committee. I think we could find a similar violation with the Board of Supervisors, but not in this particular complaint.
Okay.
We'll have to wait till Supervisor Chu's matter comes before us.
Vice Chair Wolf?
And I would have to read through the Brown Act in a little more concisely, but maybe either attorneys can answer that if they know. Is it incumbent upon any member of a voting body to ensure that the Brown Act is being carried out? And if not, would they be considered in violation?
Well, I think the first question is whether there's anything they could do to prevent the action.
Well, is it their responsibility?
Well, but even if it were their responsibility, if there's nothing they could do, then they couldn't be in violation. If you get my drift, like if the Brown Act said you must prevent an action that would be in violation of the Brown Act. Well, if the member is not in a position to prevent it, he can't prevent it. He couldn't be in violation of the Brown Act. He could protest, and to my knowledge, the Brown Act doesn't require a member of a body to protest an action that may be in violation of the Brown Act, but I don't know that for sure. If DCA 3 has more knowledge on that.
54-959. Each member of a legislative body who attends a meeting of that legislative body where an action is taken in violation of any provision of this chapter and where the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled under this chapter is guilty of misdemeanor. So it doesn't necessarily, that's an active action if they seek to deprive the public of that. And, there's no, in this particular case, there's no, it's more implied versus active, that there could be some deprivation.
The point I'm trying to make is that if all Ellsburn could do is not vote,
you could say, yeah, go ahead.
Even if he didn't, well, I don't know. Actually, I don't know what the vote total was.
He has to vote yes or no, or
he has
step
to
out
vote,
of the room.
Yeah, he has to vote yes or no. I suppose he could vote no in protest because it's a violation of the Brown Act.
He can make a motion.
Do you have any insights on this, DCA 3? I don't know the answer.
In terms of the Brown Act, I think there's two remedies, and one is if there's an intentional violation by an individual public official, there's possible criminal penalties. But if it's a non-intentional violation, the remedy is not specific to the individual legislator. It's a writ of mandate in certain cases that would possibly overturn the decision. There's only limited circumstances that's provided for, however. Under the Sunshine Ordinance, however, it's a different issue. The task force does have the ability to refer individuals for further enforcement. Right. And I would say that just as a general matter, every public official has an obligation to ensure that these acts are complied with.
Yeah, I'm just so you know, I'm not on a witch hunt here. I'm just trying to answer all the questions that may come up around this kind of issue, because it helps us kind of hear them, and in the future, if something else similar comes up, we have some basis to ask these questions on.
Do you feel you have, and does anybody feel they have enough information to make a motion? Okay, so seeing no motion, I'm going to ask for public comment on this matter.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I think in this particular case, couple things I'd like to throw into the mix. One, the comments made at the Board of Supervisors meeting by Supervisor Campos, at least, and others, raised questions as to whether they were following the Brown Act or the Sunshine Ordinance. And I think that would be what they would consider constructive notice. It's basically saying to the people, hey, we're doing something here which may very well be in violation of the law. And whether they said that simply to cover their ass or whether they were serious, I think, from what I've seen of David Campos, he's usually very serious. And in particular, the one person who had probably the most responsibility for considering that is Mr. Ellsburn. He is the supervisor that represents the area in which Park Merced is. Therefore, all of the constituents, all of the residents of Park Merced are his constituents. And I don't know about him, but if I were a member of the Board of Supervisors and I was the individual responsible for every single person that was going to be affected by the act, and one of my fellow supervisors said, hey, we're probably violating the Brown Act here, I would have said, you know, we need to really step back and look at this and not just get a CYA opinion from the legal counsel here. I think we need to continue this for a week and really decide whether or not what we're doing is lawful or not. Because if it is not, then it is affecting every single one of the 8,000 plus residents of Park Merced, all of whom live in my district. Okay? So basically, what I'm saying is that it was made very clear at the Board of Supervisors meeting that they were acting on an item which was questioned by at least one supervisor, if not more, as to whether it covered the Brown Act and or was a violation of the Brown Act and or the Sunshine Ordinance. And they made the conscious decision to simply not do anything and simply move forward. And the whole thing, from beginning to end, that entire day, was a rush job. And it was basically done in a way that they knew they were denying people an opportunity to make public comment and meaningful public comment, because they had never had a chance to actually see on the actual thing that was being voted on. And as a result, the comments that were allowed at the Land Use Commission were kind of irrelevant. It was kind of like, well, yeah, we let you make comments, but we just didn't let you see anything you were commenting on. And that was just carried forward right to the supervisors meeting.
Unfortunately, once again, I'm Jason Grant Garza in front of this august, robust committee here, which apparently there is no sunshine, the Ministry of Sunshine here. One of the things I'm having a hard time with this entire thing is, where's the knowledgeable representative from the other side to answer the questions, whether it was intentional or not, so that we can know whether it was a misdemeanor or a crime? But since he didn't show, I guess you can wash your hands of giving these people their due process. You know? Once again, the system set up to fail, defeat, and rigged. Also, I'd like for you to tell all these people just exactly what has happened when you've ruled against a supervisor and sent him up to ethics. What has the consequence been, or has it basically been a cause with no effect? You know, oh, let's support the hungry children. Oh, well, here's $1, but you know what? We'll only give them 5 cents and everything else will just be, you know. It's the same thing here. The exact same thing here. Oh, we care so much. We're going to send them up to ethics. We're going to do all these things, and nothing comes from it. You're a volunteer organization. Well, I think you should volunteer to leave, because you're not accomplishing anything except jerking these people around, giving them false hope, going over the 45 days, bending over backwards to help the supervisors and everybody else who knows what the Brown Act is, who are well trained in the Brown Act because they've had many years of being trained, but the constituents who aren't are being played by this entire system rigged process. Thank you.
Is there additional public comment? Seeing none, public comment is closed. Does any member of the task force have a motion? Seeing none, the matter is closed.
Oh, no, I do have a motion. I'm sorry.
Do I have to, Vice Chair Wolf wants to make a motion, and I closed it. Do I have to reopen it? Do I have to have a vote to reopen it, the item?
It's like 5 seconds.
Okay, but
not like I asked an hour from now. I was busy reading. I just was going through the...
Madam Chair, I move to reopen reopen the matter in order to allow a colleague to present a motion.
I'll second that.
Okay.
Thank you.
do public comment?
Through the chair, if the audience could please be respectful. Thank you.
We need to take public comment.
Don't need to.
Vice Chair Wolf?
So I'd like to move.
Excuse me.
Oh, I'm sorry.
There
we
was
need
a
to vote.
motion. There was a motion to reopen the matter. I don't believe the vote's been taken on that.
We were going to take the vote without objection. Would you like a roll call?
No, I'm fine with that.
Okay. Is there? All right, Vice Chair Wolf.
So thank you. I would like to move to find Supervisor Ellsberg in violation of 6721E. I don't know if that's appropriate, is it? No, not E.
The knowledgeable representative.
Well, let me put it out there, and if it's 67.
We have a lot of things on the agenda.
I'm sorry. All right, I may have misspoke. I'm sorry. My question was is because there's not a representative, whether this would apply to 6721E for failing to provide a knowledgeable person. 6721E deals with public documents, not necessarily meeting procedure. So I may have misspoke. Okay, I'm sorry.
Okay, so the matter
The
is
matter's closed.
is closed. We are going to lose another member at 8:15. So I want to make sure that we will still have 6 members for till 9 or 10. Okay. So, Mr. Rustum, we are now back to item number 7.
Yes, Madam Chair. Item 7 is file number 11060, determination of jurisdiction on complaint filed by Lars Nyman against the Department of Public Works for alleged failing to produce requested documents.
I have to state that I live across the street from Montgomery and Union, but that won't affect my ability to view this dispassionately.
Thank you. Number 7. It would not. Okay. Is there a motion to find jurisdiction? Is there
Second.
Okay. Is there public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Can we take the jurisdiction without objection? Okay, so jurisdiction is found. Mr. Rustin, please read item number 8.
Item number 8 is file number 11060, hearing on complaint filed by Lars Nyman against the Department of Public Works for allegedly failing to produce requested documents.
Is the complainant present? Mr. Rustum, did you hear from the complainant?
No, Madam Chair, I did not hear from, but I did contact and inform him of the meeting.
Is the respondent present?
The Department of Public Works is here. I'm Frank Whitney.
Was this continued last time?
Yes, Madam Chair.
And what was the reason? Do we know?
Because we had lost quorum.
This one was
Yes.
from a lost quorum? Does respondent have an objection to continuing
No,
it?
just to refresh your memory, this was on the October 25th agenda. I was here until 9 o'clock. It was never the item was never up.
We can't
I'm
hear
sorry.
you.
This agenda item was on the October 25th agenda. It was a long agenda, and you guys never got to our item and continued it, so we're back. I'm back.
Okay. I'm not sure what the task force would like to do, but when I reviewed this information, one of the questions that I had was to ask the complainant what documents were believed to exist. I'm not exactly sure how we could do that without the complainant present. Are there any thoughts on that? Member Nee?
Yeah, without the complainant here, my inclination is to move to table this till next month, and if the complainant doesn't show up next month, it's gone. He has to refile.
DCA 3?
Yeah, just through the chair, just one bit of information. If you review the email correspondence, it appears that, and this appears because it's not entirely clear, but it appears that the complainant believes that there should be some budget for fabrication and installation of custom tree support and saddle, which apparently was something added to this project along the way. The DPW appears to say that there was never a separate budget for that, and they've provided all the documents. That seems to be the dispute from my review.
Do we want to go forward with this, or do we want to continue it?
I'm not inclined without the complainant.
Okay.
Yeah.
Member
I
Coffin?
agree. I mean, as you know, the complainant seemed very diligent in his complaint, so I feel that if he wants to pursue it, then he should appear next time. If he doesn't, then we can just drop it.
I'm having an issue with the complainants not showing up and not. I want as much sunshine as possible, but I also want to be fair to the respondent. So now he's sat here the entire time and sat here again. So we're going to have to come up with something other than just perhaps the complainant will show up next time. I want us to be as open as possible, but the accusation is just that. It's an allegation, not an automatic condemnation. So to have them come again and again is proving to be somewhat burdensome for both the respondent and for the task force because we have a lot of complaints. Vice Chair Wolf.
Then I would say don't table it and let him refile.
Did the complainant contact you?
Through the chair, Member Cawthon, no,
Oh, really?
the person did not.
Was the complainant here last time?
Madam Chair, he was not. He did contact me to say he would not be able to attend.
Okay, I'm going to make a motion to dismiss this complaint.
I second that.
Is there public comment on the motion? Can we dismiss the complaint with the idea that he could refile it? Is dismissal automatically mean he cannot refile? It's not? Okay.
No.
Then can you please call the roll on the motion to dismiss?
On the motion, Member Snyder?
Yes.
Snyder, aye.
Public
We did call public
Yeah,
comment.
nobody.
Yeah.
Member Nee?
Aye.
Nee, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 8 ayes. The motion passes.
Okay, so the complaint, this complaint is dismissed, and I want to tell you that I do appreciate you coming both times, and I understand that you had to be here. But I do want to make sure that you understand that the complainant could file again. Okay, thank you very much. Okay, can you please read item number 9?
Item 9 is file number 11070, determination of jurisdiction on complaint filed by Jason Grant-Garza against the Department of Public Health for allegedly failing to respond to an immediate disclosure request.
Is there a motion to find jurisdiction?
So moved.
Is there public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Can we take the motion to find jurisdiction without objection? Okay, so jurisdiction is found. Please read item number 10.
Item number 10 is file number 11070, hearing on complaint filed by Jason Grant-Garza against the Department of Public Health for allegedly failing to respond to an immediate disclosure request.
Before I forget, Mr. Rustam, can you notify Mr. Nyman in the last case of what went on? We need to make sure. No, okay. I want to make sure that I know the complainant is present. Are the respondents present or respondent present? Okay, thank you. Complainant will have 5 minutes and then respondent.
My name is Jason Grant-Garza. I've unfortunately been here for 10 years at this august, robust committee, which of course is the Ministry of Sunshine, because it's completely illusion and it's not even right, accountable, or any of these other things. I had sunshined the Public Health Department for my copy of my medical records because I was denied medical care at the Tom Waddell Health Clinic, contrary to law, for indigent care, all other care, considering I'm disabled. I requested this was requested through an IDR, which was not complied with at any point in time. Priorly, I've been to the Sunshine Task Force before and had orders of determination in my favor, ruling that medical records do fall under Sunshine. I've submitted that to all you guys so that their claim that my medical records do not fall under Sunshine is totally false. I've submitted in the past in case 10038 when I was denied the Tom Waddell records for my medical records because this happened in June of 2010 and I brought them here. You guys found in my favor that the IDR was not properly filled and it was sent up to ethics and of course you were overruled again. This is concerning my health care. This is concerning my right to be able to get health care, to get the records I need, the public documents I need to prove that these law-breaking activities are occurring. Also, there was something in the packet that I received on a separate case that wanted to not only combine these two cases through an accommodation for their part, but also implied that I was rude and hostile and that they needed to be here with a sheriff or a deputy to make sure that I wasn't going to go off on them or be violent or something. And I really, really resent that picture painting of me, a disabled person who's not only told the truth all along, but has told you that they have unclean hands because I have a signed confession from where they broke the law, having denied me my medical records for an emergency services in 2001, the Department of Public Health. So basically, you're dealing with an organization that has already been found guilty, because I have an agreement that admits fault and guilt, for having broken the law, trying to paint the picture that not only am I wrong, but that, I'm not entitled to these records based on their interpretation of a law which they're interpreting incorrectly. Every time I write them back and say, no, this is incorrect, please cite the law, yada, 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 please explain, I don't get anything. Another interesting question also is that they state that they can't release my medical records without a HIPAA release. Well, it's awfully funny because in one particular case, she submitted to you guys a copy of theoretically my HIPAA release, which according to her is a medical record, which I hadn't signed to be released. So on one hand, they can break the law, fully knowing well that they're breaking the law, and yet deny me my own records with that same exact law. It's beyond amazing. It's simply beyond amazing. Then, in addition, this has been going on now for a very, very long time. This is over 45 days. I have my records of having asked for programmatic access. I have everything else, and these things never happening to me. I have my letters about the 10038 ethics failure for the Tom Waddell denial of health care. And I'm sure that when you fail me again, I guess I'll have to go back to Tom Waddell, be denied, and show up here again, because this seems to be a recurring habit as opposed to getting the person who needs health care his health care, or the records that he needs to prove that he's not gotten his health care, because I guess we just don't matter. And even under ADA and every issue that I've brought up, none of it's been responded to appropriately by the administrator or anyone else. My constant request for the Disability Task Force representative, Mr. Wolf, to contact me went completely ignored until today, conveniently, which I find extremely distressing. My programmatic access, which I specifically asked for, because I said that there was many tapes, there was many things that needed to be transcribed, because under programmatic access through MAUD, a person with disabilities, if he needs help in preparing, can get this help. That was never addressed. Mr. Treat this week, all of a sudden, for the last, I'd say, week to 10 days, became interested in helping me in my case until I, of course, wrote him back and told him where he was wrong. And then all of a sudden he informed me he wasn't responsible for getting me the ADA help. That was such good faith on his part. The due diligence of not having gone through and found the prior precedents of my medical records falling under sunshine, that was another failure on your part. It just continues.
Thank you. Excuse me. Is there anybody in the audience to present facts and evidence in support of complainant? Seeing none, if respondent will now have 5 minutes.
Good evening. My name is Eileen Shields, and I am the Public Information Officer for the Department of Public Health. And with me tonight to answer technical questions regarding medical privacy and records are Chona Parada, who is Compliance Officer, and Alice Gleghorn, who is our Privacy Officer. Because this complaint involves medical records, I wanted the task force, if you so choose to have the opportunity, to hear from our experts on HIPAA requirements and our mandates. And the information I'm about to provide in a timeline is based on all the public documents and records requested by Mr. Garza. And a second complaint was filed on 10/6, adding Dr. Pache and 2 additional items, repeating the original complaint, and this task force is scheduled to hear that complaint following this item. So the timeline goes like this. On 8/31, Mr. Garza goes to the Tom Waddell Health Center. He's accompanied by another individual with a small palm-sized video camera who attempts to videotape inside the clinic while Mr. Garza talks with the eligibility worker. The sheriff's deputy asks him to stop, as our medical clinics are considered confidential spaces where people are there for medical services. Mr. Garza becomes belligerent. His behavior escalates. They refuse to put the camera away, and he and his companion are escorted out. Prior to leaving, Mr. Garza is given another appointment with an eligibility worker for a later date. The next day, Mr. Garza calls the eligibility worker at Tom Waddell Health Center and was, according to the worker, abusive, hostile, and threatening. Mr. Garza did not show up for the scheduled meeting. On 9/15, Mr. Garza submits an immediate disclosure request for documents and medical records, and you have a copy of what he asked for. On 9/16, the Department of Public Health responds that his request is not an immediate disclosure request in that it is not simple, routine, or easily accessible, and nor are medical records public documents. We will provide, we assure him, all the documents within the standard time allowance, and we make arrangements for him to get his medical records. We make it clear that his medical records are not public documents. On 9/26, he files a complaint with the Sunshine Task Force. On 9/30, the department responds to his request on 9/15 and another directive to go to the clinic, sign an authorization form. If he calls in advance, the records will be ready. We also sent, at that time, we attached a copy of his signed HIPAA notice, which he requested, and we attached a copy of the documents produced in response to his HIPAA investigation at San Francisco General Hospital. On 10/3, Dr. Joseph Pache sent a form to release medical records to Mr. Garza, and Dr. Pache asks for a meeting with him. He also sends his HIPAA privacy authorization policy and the HIPAA federal regulations. On 10/4, DPH sends a notice to Mr. Garza that we cannot release his medical records through Sunshine, but he is entitled to obtain a copy with signed authorization form, and if he calls ahead, the records will be ready. On 10/4, Mr. Garza resubmits the same immediate disclosure request that he submitted on 9/15 to Dr. Pache, with 2 additional items, of which there were no responsive documents. On 10/4, the Department of Public Health receives a Sunshine complaint to appear again for not complying with the 9/15 request. On 10/6, Mr. Garza files a second complaint with the Sunshine Task Force, adding Dr. Pache's name to the complaint. On 10/19, Dr. Joseph Pache sends Mr. Garza another email suggesting 6 specific meeting times. The rules are no recordings or videotapings, and number 2, he will give him copies of his medical records and anything else that he has provided that he signs his authorization. In the ensuing weeks since that's happened, Mr. Garza has not returned any phone calls or responded to Dr. Pache's numerous attempts to set up meetings to access his records. Finally, and more recently, Mr. Garza has acquired the direct phone line of the Director of Health, has begun a pattern of calling the office several days each week, several times each day, issuing demands and verbally abusing the staff. His emails, as reflected in his complaints in both quantity and content, speak for themselves. He's also showed up in person in the director's office demanding a meeting. It is the position of the department that we have fully complied with the ordinance and at the same time complied with the mandates dealing with protected medical records and information we hold in our files on patients that are not subject to Sunshine. He has been given all documents he requested. He has been offered full access numerous times to his medical records. Mr. Garza has been well and dutifully served. Thank you.
Thank you. Is there anybody present to present facts and evidence in support of respondent? Seeing none, the matter is with the task force.
I have a
Member Cawthon.
I have a question for Ms. Shields.
Oh, could I just say one thing? We had this with the Library Commission too, and I don't want it to get caught up later on, but when somebody makes an immediate disclosure request, you have you can invoke an extension, but it's still an immediate disclosure request. It's the fact that they call it that makes it that, and then the information that you provided about your explanation is your right to invoke an extension, as opposed to not his changing what his request was intended to be. Does that make sense? Yes. And the Library Commission had a similar thing, and they went back to their city attorney. So you might want to check with them. The Library Commission said their city attorney agreed with that it's you haven't. It's not like you're violated anything, but it's your right to invoke the extension. Does that make sense? DCA 3.
Yes, it does. We were trying to explain to Mr. Garza why we weren't going to be able to have the information by close of next business day, but I understand what you're saying.
And Member Cawthon, I'm sorry, go ahead.
My question, Ms. Shields, you said he filed the IDR on on September 15th, and the next day you responded that he didn't really file an IDR, that it wasn't simple, and you stated some other issues. Am I correct in my understanding?
What I said was that he filed as IDR, and it was not simple, routine, or easily accessible.
But I was just reading our section about IDRs, and I don't, that language is not contained in the section. As our chair said to you, you have a perfect right to invoke an extension if it's voluminous or difficult. But under the normal purview of the IDR, the response the next day should either provide the document or give an indication as to why. So there are no requirements that the document, that the IDR request has to be simple or the other components that you stated.
Okay, thank you for that information.
Vice Chair Wolf? Did you?
Yes. This, I was not unable to find the last time that the subject came up, and I believe it was also for Mr. Garza. I could not find the past information. We did find in favor of Mr. Garza or that complainant, based upon that the way HIPAA reads, that the individual that is requesting the information is not necessarily the person who the information is about, and that the written request for information by a Department of Health or a hospital, what have you, wouldn't be necessary for the person who is the actual patient themselves. But if it was another individual, like a family member or a legal attorney, attorney of record, or what have you, some other party. So I want to preface it by that, and I don't know since then whether HIPAA or the sections that DCA 3 provided us on page 70 have been amended, updated since then, since it's been a number of years since we've had a chance to take a look at that. And that was the basis.
Member Snyder wanted to respond to you. Is this a good time?
Yeah.
I think you're incorrect. I think that the last time it was complaint number 10038. This was on August 24th of 2010. And we found no violation for the failure to provide the record based on on Mr. Garza's unwillingness to sign for it. We found a violation of 6721E for the failure to appear, but that was the only violation that we found.
It was before, it was in my last term.
Yeah, I mean, I remember that discussion, and you made the argument that you just said, but that's not what the task force concluded. We concluded that HIPAA required us, to my recollection, we required that HIPAA requires a signature for release, and we can't override the Sunshine Ordinance can't override federal law.
Just before Member Snyder was on, we did find that you didn't have to sign for a HIPAA if it was your own documents. But since that time, I have a question for you. It was just before you came on, I think. You might have been here. But then the last time it was a 5-to-1 vote. So my question, though, is we agree that the medical records are not generally a public record. Not anybody can have access to them. If we do find that they don't have to sign a HIPAA agreement to have their medical records provided to them, how can the medical people prove who they gave the records to if the person who takes the records suddenly makes the claim that they gave their records out?
Well, they can ask for identification. They don't necessarily have to.
I'm not talking about getting the records. I'm talking about if they gave someone their medical records and those records were given to somebody else, how could if there's no signature of who the medical providers gave the records to, and the person who they gave them to claimed that they gave them out all over the place, how could they prove that they didn't?
Look, I've asked for my records from my doctor. I asked my doctor, can I have a copy of my records? They say They'll be available to go up to the front desk, ask for them. They'll be available to you from whatever. Okay, later that day, that moment, or whenever. I come back, I pick them up. Nobody asked me to sign for anything. There's no requirement under HIPAA, as far as I know, in all my years of being a social worker and learning about HIPAA and regarding to releasing of information, that I must get a signed form to release the information to the patient themselves. To somebody else, that's a different story. And so that's where I believe I believe that we found that because we found in favor of the complainant on a similar issue was because we determined that the patient is not the individual that HIPAA is speaking of. The individual is a third party, not the patient themselves. So there's no requirement for the patient to have signed for it.
But what if the patient provided those documents to somebody else?
What if I signed for it and the documents go somewhere?
Well, then
what difference does it make?
Well, then the respondents or whoever gave out the documents would have proof that the only person they gave them to, well, they would have some sort of documentation that the person they gave them to was you. I'm just asking.
I understand that, but usually it's an order that comes from the doctor or what have you that you would request your documents for, generally. Now, you could go into, I've gone into just the records section, and they say go down, I can make a request for the records, and I write down what my name is, and I'm making the request. It's not necessarily a statement, some sort of specific statement for tracking purposes in that way. It's just a request so the person behind the desk can look at it and say, oh, there's the name, there's the Social Security number and all that. They can go find it. That's a different kind of thing. Here we're talking about a person's own personal records. The way, Mr. Garza, you'll get your moment, okay? We're talking right now. Thank you. We're talking about here in relation to access by individuals other than the patient themselves. Now, I could be reading this wrong. It may have been changed since the last time it was presented to us, and they may have amended it in a different way. I don't know, but that's for us to determine here. So,
did you have a question for?
No.
Okay.
I had a question for Ms. Shields. Ms. Shields, I note that in your comments in our packet, you say that there is a required authorization. There is a signed authorization is required. Could you elaborate on that a little bit?
If I might, I would like to call our
compliance officer.
Yes.
Yeah. Okay.
Yes, Dr. Gleghorn, please.
Good evening, Commissioners. I'm Dr. Alice Gleghorn. I'm the Privacy Officer for Community Programs at the Department of Public Health. And everyone who comes to a clinic, whether it's a health clinic, substance abuse program, mental health program, STD, HIV, is given the HIPAA Notice of Privacy Practices, DPH, and the notice is based on state and federal law and DPH policies. And so every client that comes in is asked to sign that to acknowledge that they've been informed about how information is collected on individuals who come to seek care, how that information is stored, and how that information is shared. It also outlines the rights that people have to access that information. If individuals wish to see that information, they do have the right to do that, but they do have to fill out a form so that we do, as you were pointing out, have a record that information has been requested, and then we post that form as part of the medical record so that we have documentation of how that information was released. If they wish to share with other individuals parts of their medical record, they need to fill out a very specific HIPAA authorization form and endorse the information that they wish to have shared. So they could choose, for example, to share health information, but cross off the section on STDs or substance abuse treatment. So there's a very specific form that's defined, the elements that are defined in federal and state law and DPH policy, and that is what covers the health information. And so the reason that we weren't able to respond to the request of the IDR is because it actually is protected health information and requires this specific document. And that's what we were attempting to have completed multiple times after the IDR was made. We'd be happy to provide this information to the complainant, but we need to have the specific form completed.
So did Mr. Garza, was he offered the form to sign?
Multiple times, yes.
And he
Ms.
refused to
Shields.
sign the form?
Question 2.
They've never been completed to my knowledge.
He's never returned them to you?
Yes.
Okay, thank you.
Could I ask you one question about what you said? You had said that if they want copies, they have to sign a HIPAA form, and it says how you can release the information. What if they don't want you to release the information?
They don't sign any form.
Well, what if they want the records, but they don't want you to be able to release information to other things? Can they? Is there a form they
That's
can sign
fine. They
to
can
get?
fill out the form to release it to themselves.
But nobody else.
Right. And in addition, there may be elements of the record that they look at but are not copied.
Okay.
So,
Vice Chair Wolf.
So I have a question. This is specific. So usually the way we operate is if there's some sort of refusal or denial of information, you have to present it with an appropriate statute that states it so. This is I'm going to reverse that a little bit. So I'm going to ask, with regards to the HIPAA form that you're talking about, what is that form? Is that required under HIPAA, and if so, where? Where can I find it?
So there are two types of forms that I think we're talking about.
Okay.
The first form is a notice, and that's the form that people see when they first come in for services.
Is that a form that person signs?
Well,
we're talking
they have
about
the option to not sign it, but
No,
we
that's not
have
my
the-
question.
Yeah.
Question is it a form that a person is to sign?
It is a form that has a signature spot on it for the client who comes in.
Is it required for a person to sign it?
It's not required that they sign it. It is required if you want to have services that we review the form with you. If you refuse to sign it, we will note that it was reviewed and it will be signed by the person who reviewed it with you.
The question is under HIPAA, is it required to be signed?
No.
Okay,
It's
so it's just a
required that
notice.
they're given notice of our privacy practices.
Okay, but it's not required for them to sign it.
They can refuse to sign, and
It's
then
not
we
my
note
question.
that. Yeah.
Of course, it can refuse to sign anything. I could refuse to sign a speeding ticket. Okay, but
It's exactly the same way, yes.
yeah,
You
I
can
underst-
refuse to sign it.
If I refuse to sign a speeding ticket, then there are consequences for that. Are there consequences for somebody not signing a HIPAA form?
No.
So it's just purely a notice.
It's notifying, it's a notification to people seeking care how the information is collected and to what uses that information goes to and who has access to the
And
information.
so what's the purpose of the signature?
Just because then we can document that the person read and signed and understood this and was given this notice. We give copies of that too, as well.
I understand that, but
Now there's a second form.
okay.
So the first form is what you get when you come in the door seeking services, so you know how we collect information and use information and share information. The second form is a authorization form. If you want to share your information or if you want to make a request for medical records, there's a form that you fill out that is very specific, your name, your your name and date of birth, the name of the facility that you went to that you want to get information from, description of the information that you want in there, the purpose of the information. You can put an expiration date on that if you only want information disclosed from one point to another. And then there are specific sections in each form that you have to check and say, yes, if I want to have mental health information, substance abuse, HIV, developmental disabilities, you have to actually check those in order for that information to be released. And there's others as well. And then the form also has to discuss that this is voluntary, and there's a number of other requirements. That form goes to the medical records, and the medical records department is responsible for accessing the records and disclosing the information, but they will not do that without the form. And so that is the form that we've offered to.
You're saying that that's
that.
required under HIPAA?
Mm-hmm.
And under what statute?
There are different statutes that pertain to HIPAA. I have the statutes under which we can disclose different pieces of information for treatment purposes. Anything outside of that must have an authorization.
Can you give me can you cite the statute for me?
I can cite the conditions under which we can disclose.
Can you cite the statute?
I don't have that specific now.
Because we work,
Civil
we're
Code
quasi,
56.
just so you understand, we're quasi-judicial,
Yeah,
so we
no.
have to work on a basis of actual law.
All these are based on
I
the
understand
federal
that, but
law,
you're providing me with more anecdotal information versus what is black and white letter. We like
Federal
to know what the
statute.
black and white letter is. I mean, we do our homework on this. We have our legal counsel do his homework to provide us with advice. It's incumbent upon the respondent to provide the same, to provide the statute if they're going to deny records to a and if they're saying, well, we're in the right, then you have to tell us how you are in the right, how you're correct. And so it has to come, it has to be stated in law.
Are there additional questions?
I'm waiting for an answer.
Okay, you're going to have to be respectful of her time up here.
If you want a specific reference for that, I will have to return to you with that from the documents I have. The HIPAA is based on the Civil Code 56 HIPAA.
56?
Mm-hmm.
On page 72.
That's not 56.
Yeah, but if you go on page 72, there's...
That's not 56.
I know, but we have it.
No, the respondent is required to prove their case based upon...
She's not required to cite it to us. She's required to tell the requester. She's
It's the
not
same
required
difference.
to cite the freaking case law right up there at
It's
the podium.
not case law. We're not asking case law. We're asking for the law.
Like the Sunshine Ordinance requires her to and you're right, she has to cite law to the requester, but it's not what you're asking her. You're trying to put her on the spot to cite case law right there. and
It's
that's
not
never
case
been
law.
a requirement.
It's not case
Cite,
law.
It means the
statutory
exact
law.
code.
That's not a requirement. We don't require that of people.
Of course we do.
They have to cite it in the response.
If somebody's going to redact something, they have to cite how
to the requester. Yes, we have the law here.
But if they didn't,
you're forcing her to go through these motions when we have the law right in front of us. I mean, should we walk around and give her from here and hand it to her at the podium? It just seems unnecessary to me.
Okay, all right. On page 72, it's 45 CFR 164.524. It's B1, at the end of the paragraph, the covered entity may require individuals to make requests for access in writing, provided it informs individuals of such a requirement. Okay, Mr. Garza, thank you very much. You cite in your complaint that you requested a copy of a signed HIPAA release.
Correct.
Did you sign a HIPAA release?
The HIPAA release that they had sent, the 2006 that they tried to send for when Tom Waddell illegally gave my health information to Haight-Ashbury without a signature, was a HIPAA form that I had scratched out and signed in 2006, specifically telling them not to release my thing. And above the signature line, I said, signed under duress. So not only did I tell them not to release anything, but that was the acknowledgement that I had read the privacy and practices, not that I wanted them to release any specific public information. The HIPAA law was written for patient health information and for my control of it. No one else's control of it. I have HIPAA law, Mr. Wolf, right here in front of me. I have section 164524, which states that I'm entitled to a copy. I also have the section that you read about asking for a written request. My Sunshine request was a written request, which would allow me a copy. It does not state here that I have to sign a HIPAA release and a written request. It says all I have to do is provide a written request, which I did do, and it also says I'm entitled to a copy. So all this rigor remorse, and them going around and giving you their interpretation of the law as to how it applies to my private health care information is totally wrong, because, like I said, if their claim is that their policy is that they have to have something written on file, I did write them. I sunshined them. And that's on file. Also on file is the previous time that they came here and pulled this same thing in case 10038, in which, you're correct, I did have 5 votes for me and 1 against me, because the system was rigged at that particular point in time so that I would have to have a majority of 11 votes. And that's the person who voted against me for my medical records.
I got your point.
Yes, you can quite well get me.
I got your point.
DCA 3 wants to make a comment.
Yeah, I just want to point to 45 CFR 164.508, subpart C, subpart VI. This is in the part of
Is it on a page in our packet that we could go along with you?
Say it again.
Is it on a page of the packet that we could read along with you?
Unfortunately, no.
79?
Yeah. It does not have section 508, I'm sorry to say.
Okay.
Yeah, we have section 508.
Is it in there?
Yeah. So read off the paragraphs.
Can you tell me where it is?
70 starts on page 75.
Yes, okay, on page 78. It's page 16 of the memo. Subpart C, implementation, specification, core elements, and requirements. A valid authorization under this section must contain at least the following elements. If you go down to subsection 6, signature of the individual and date.
Madam Chair?
Member Need.
Yeah. Does it, maybe you could answer this more quickly than I could, but under Roman numeral 6, signature of the individual and date, is there a statement somewhere else in here that the signature must be on a specific form? Just says signature of the individual and date. Must it be on a specific kind of a form?
I'm not aware if it has to be on a specific form. It does require a signature for the authorization to be valid, which I believe is the issue before.
Okay.
Thank you. Can you give me the section and paragraph?
Page 16 of the memo.
Right.
If you go about halfway down, there's subsection C.
C, right.
It says implementation specifications.
Right.
Core elements. Valid authorization under this section must contain at least the following elements, and then it lists a number of different elements, among which is number VI on the top of page 17.
But that's only by a personal representative of the individual, not the individual
it's
himself.
Not. It's signature of the individual date. It says if the authorization is signed by a personal representative, then you have to have additionally, you must have a description of his authority to act on behalf of that individual.
But if we go back to page 72, it says the covered entity may require individuals just to make requests for access in writing, provided that it informs individual of such requirement. It doesn't specify any need for a signature, just that it makes a request for access. So somebody sends them a letter saying, I want my records.
Remember, Wolf, I don't believe that all the requirements have to be contained in the same place in the Code of Federal Regulations.
But they should refer to each other, should they not? 508 comes, pretty far, comes before this section.
I've given you my advice. You may differ from it.
I just trying to brainstorm with you so I can get an idea of how to understand this. I mean, to jump from 508 to 524. I don't know what's in between and what this actually applies to. This is authorizations for uses and disclosures.
Well, I can tell you the reason that the entire sections that cover this subject are not included here with all the space in between them is because they're quite voluminous.
I understand that. But even in Section 508, under A2, it specifies other sections that it either provides for or not provides for. You would think that they would do that in regards to a later section if it applied to a previous section. So in 524A1, if it said that I'm not A1, sorry, in B1 on page 72, if it said that a covered entity may require individuals to make a request for access, it should also say that it requires a signature under Section 508, under Section 508 too.
Yeah, I understand your thought process.
Okay.
On page 65 is how DCA 3 combined all of those. I don't know if that will
I read
help
that.
you
I read that.
ask
but
a question or.
Go on.
No, I just wondered if it would help you ask a.
No, I've read this through, and I know this section of law, and because I've had to use it, and had to on both sides of the aisle on this one. It's not clear to me that a signature is absolutely required for 524. I've only seen it done for third parties, not for the actual. The request only needs to be made by the individual, by the actual patient themselves, in writing, signed or not.
And I think you're given your personal experience. I was actually surprised this was an issue because every time I've requested my medical records, my doctors required that I sign a HIPAA form before they release them to my new doctor.
Yeah, I don't. It's not in every case that I've seen.
Member Snyder?
Ms. Shields, could I ask you a couple questions? You may have already gone over this. I apologize if I'm asking you something that you've already covered. But when you denied Mr. Garza's, when you didn't provide him the records that he was requesting, did you provide a written explanation as to why he couldn't see them or what he needed to do in order to see them?
multiple times he was told that he needed to sign for them, and he was provided the form multiple times. Did I cite what Mr. Wolf is saying? No, did not. I went with what I have in our own policy within the department.
And do you have a copy? Is a copy of that in our record, or do you have a copy of it there with you?
It was. I don't know if you have a copy of it, but I know that Dr. Pache sent copies to Mr. Garza.
This is an important issue because under the Sunshine Ordinance, if you deny somebody access to records, even if you're fully within your rights under the law, and in my opinion, I think you all are. I've read the HIPAA regulations, and it seems like there's a requirement for a signature. I think you have in my opinion, valid reason to deny access to the records based on the signature requirement. However, you need to explain that to the requester. We had, the Sunshine Ordinance and FOIA also, and I think HIPAA itself has a requirement saying if you deny somebody records, you have to say why.
Well,
and in saying why, you have to cite to some law. I mean, it doesn't have to be a legal document. It doesn't have to have legal, be written in legalese or contain legal citations necessarily, but you need to say under what law you're denying access. And
that was, I can tell you that on 10-3, when Dr. Pache responded to him and asked him for a meeting, he also attached 3 documents. And one of them was the HIPAA Privacy Authorization Policy, one was the HIPAA Federal Regulations, and I'm sorry, I'm drawing a blank on what the other one was, but I know it was also a privacy statement. Do you know it? It was the notice.
And what's the notice again?
Yes.
The notice is the first document you see when you come into a clinic that informs you what information we collect and how we store it and how it may be shared.
So sorry, go ahead.
And it also tells you what rights you have to the information. So the notice that was sent to on 10-3 was it's a 10 or 8 page notice that says specifically in it, and I'm just going to say this since this has been discussed. All right, let me find the right page. It's really long. Well, I'll find it, but essentially that you have the right to inspect and copy. It's called the right to inspect and copy. You have the right to ask to see, read, and obtain copy of health information used to make decisions about your care. Usually this includes medical and billing records. If you want to look at and obtain a copy of health information used to make decisions about your care, you must take or send your request in writing to the medical records office at the location your care was given. This request was made to a public information officer. It was not made to the clinic at which care may or may not have been given. And that is what you have to do to get a copy of that information. It's not a public record. It's not something that would be something that Ms. Shields could access.
So at some point, did somebody tell Mr. Garza, if you sign this form, you'll get your records?
Yes,
and
multiple times.
In that and I see that my notes reflect that, but in that explanation, did anyone ever say, you have to sign because HIPAA requires it? We can't give you the records because HIPAA requires us to get a signature before.
That's part of the notice.
It says HIPAA requires it?
It says it in the notice.
It says HIPAA requires it.
Yes, it's titled DPH Notice of HIPAA Privacy Practices, and it has all these sections in it. So it tells you all about who follows the notice, what our pledge is about protecting health information, your rights regarding health information, how you can get that information, how you can authorize others to get that information. It's very detailed, and it is based on state, federal law and DPH policy.
All right, thanks.
Member Nee.
Ms. Leghorn, or Ms. Shields, either one.
Okay.
Does HIPAA or does federal or state law require that signature be on a specific form? And if I sent you, or if I sent the clinic where I had my care, a letter saying, I would like such and such an information, it's got my signature on it, maybe I even have it notarized, maybe not, but wouldn't that suffice?
There are required elements. And by the way, all of this information is on our public website, so it's fully accessible to people can access that. And it gives very specific information about what needs to be in that. Mm-hmm. But yes, you can, following these things, you can write your own request. Okay. The request that was made to the Public Information Office did not meet these requirements.
Okay, thank you.
But we make it easy by having a authorization form that all you need to do is fill out and sign, and it meets all these requirements.
Thanks.
Vice Chair Wolf.
So, in rereading the 508 section, I don't find that there's a requirement for the actual individual to have to make to request a signature from the actual individual. It speaks to other individuals for marketing purposes, for face-to-face communications, promotional gifts. There's all kinds of things. When you get to the section that DCA 3 specified in C on page 78, it speaks to valid authorization under this section must contain at least the following elements: description of the information to be used, the name or other specific identification of the persons or class of persons authorized to make the request. It's not necessarily, we're not talking about the actual patient themselves. The name or other specific identification of the persons or class of persons to whom the covered entity may make the requested use or disclosure. It has nothing to do with the individual again. I mean, reading all that down, there's no mention of the individual at all as part of the core requirements. It speaks to other people that may request the information, like insurance companies or companies that do marketing for various insurance, or pharmaceutical companies, or what have you, fundraising, whatever. I don't believe that 508 actually applies in this section, because reading it all the way through, it doesn't specify the individual at all.
Madam Chair.
Member Nick?
Respectfully, I disagree with what Vice Chair Wolf has just said, because if you scroll down to Roman numeral 6, now it says in C, a valid authorization under this section must contain at least the following elements, and under the following elements, signature of the individual and date, Roman numeral 6.
That's right, but that's for the purposes, if you have to go back to the beginning of the section to look at the uses for the purpose of the disclosure. This is not relating to Section 524. This is section specifically relating to uses and disclosure of 508. And so it's asking for a signature of the individual and the date for releasing information to third parties. That's what 508 is about, third parties. If you read through it, and if you read it from the beginning, from page 75, it's specifically about protected health information with other entities, not necessarily with the individual or the patient themselves. There's no mention of the individual with regards to sharing of information. The only time that comes up is in 524, when we're talking about the access of individuals to protected health information, the access of the individual themselves, not third parties, and the process. And it's very clear here: unreviewable grounds for denial of being able to do that, and then reviewable grounds. I mean, it's pretty explicit, and I think that's what we went through the last time. Is that there's not a case to say that if a patient requires access to their records, all they have to do is make a request, written, verbal, or what have you, and that the covered entity may require it. There's not an absolute requirement for it. It just says the covered entity may require individuals to make requests for access in writing. Doesn't say anything else, and it must inform the individual of such a requirement.
Member Nee?
Ms. Shields or Ms. Leghorn, please. You stated that in a request for a record, certain information must be provided, correct?
Mhm.
Now, in the request that Mr. Garza made for his health records from Tom Waddell, what elements were missing? What information did he not provide that is required?
Well, again, that must be made in writing, and it must be made to the medical records office at the location where the care was given. So I did not receive the request. I don't receive those kinds of requests. It went to Eileen Shields, and she's not the proper person to fulfill that request. So I have not reviewed his requests. I'm the privacy officer and was brought in.
Okay, Ms. Shields?
Else.
We've just heard that you received the request. Whether you were the proper party to whom to address it or not, you received the request. Do you have personal knowledge of the elements of information that such requests must contain?
Mostly what I know is that my office I can't put medical records on my computer and send them to someone.
Well, that wasn't what I asked.
Well, that's
Do
more
you
of
know what elements, if I make a request,
Mm-hmm.
or if Mr. Garza makes a request, there are certain elements, certain pieces of information that must be in that request, correct?
For his medical records.
Correct, yes.
I don't know about medical records. I only know that they're not public documents, and that when I get lots of people calling me or emailing me wanting their medical records, it's a really slam dunk. I send them to wherever it is that I need to send them to get their medical records.
You directed Mr. Garza to
Tom Waddell,
to
yes.
Tom Waddell.
Yes.
Is there a representative from Tom Waddell here tonight?
No. We have our privacy and our compliance officers, and they coordinate those requests.
Thank you. Mr. Garza, please. Okay, we've just heard from Ms. Shields that when she received your request for records, she directed you to Tom Waddell. Did you go there?
Yes, I did go to Tom Waddell. I did ask for my records. I was told I'd had to sign a HIPAA form. I said, no, I don't. And I was denied those. That's what case 110081 is over. Now, please, Mr. Nee, I want to finish answering some questions. One of the things that I'm upset about is that I have 2 prior order of determinations that I sent into you guys stating that medical records do fall under sunshine.
Okay. Did you sign something? Did you request your records in writing with a signature?
I requested my records in writing per the way that I'm allowed to under 164.524. In writing, I'm allowed to obtain a copy, and I did request that. It did not state that I needed a signature. I do not need a signature. I could be somebody with no hands and not be able to sign. I could just mouth it.
Did you sign it? Did you sign the request that you submitted in writing?
Well, I don't understand that, because when you say, did I sign it, I sent an email.
Simply yes or no question, sir.
Well, I consider sending an email in with my name on the signature down there, a signature. So it depends on your definition of signature.
So it was an emailed request then?
Correct, with my name on the bottom, which constituted my signature, because that's how people sign on emails.
Did you get any kind of response back from the Waddell Clinic?
Yes, I got numerous responses back telling me that I was wrong. And then when I wrote them and asked them to cite me the law, they never did.
Was any of those requests signed by somebody, or was there a name connected with those responses that you got?
Dr. Pachi, Barbara Garcia, the Director of Public Health, Faye de Guzman. Oh, I've been to all the people who are supposed to be responsible and knowledgeable on this subject. Let us not forget that we've already been through this in case 10038, in which you sent Ms. Shields here who did not respond to that IDR appropriately, and appropriately she didn't learn there either. She hadn't learned since you sent case 10038 to ethics, and that natural fiasco, which didn't get me those medical records either.
Thank you.
Thank you.
Okay, so let's have the respondent and then the complainant offer their rebuttal. The respondent will have 3 minutes, and then the complainant will have 3 minutes. Does the respondent wish to offer a rebuttal?
No, nothing at this time. Thank you.
Thank you. The complainant will have 3 minutes.
It is quite clear that the HIPAA law was written for the patient health information and for the patient to control that. It is also quite clear in the HIPAA law that under 164524, I'm entitled to a copy and to access and inspect my records. These are my own personal records. This is what is in the law. When they continually state what forms have to be filled in, those are policies. That is not law. When you specifically asked her to quote you the law and she couldn't, she's obviously not a knowledgeable representative. So, at this particular point in time, this repeated farce of denying me not only my health care, but my medical records based on their misinterpretation of the law, and you guys bending over for them, as in what happened in case 10038, in which Mr. Schneider, the only no vote out of 6, because I had to have, I believe it was 6 out of 11 because of the rigged system. Once again, we're going through the exact same thing here. Unaccountability, being rigged, not following the law per the letter of the law, having a different interpretation, no programmatic access, no health care, and I can tell you that if it requires me going to Tom Waddell again with a video camera, because it's not illegal for me to tape my own health care, only to be denied again, I can do that. I can even bring you the videotape that I have for their allegations that I was taping everybody else. I was only taping myself. So their allegation is specious that at Tom Waddell, I was trying to get over. As a matter of fact, I requested under Tom Waddell, because of the prior fact that the Department of Public Health has broken the law, signed a settlement agreement admitting fault and guilt for having broken the law for the 2 prior orders of determination that ruled that medical records were in my favor, that I should be entitled to all these things that I'm requesting.
Member Nee?
Yeah, I have some very strong concerns here. Somewhere in here, there's a dodge going on.
Say that again?
Somewhere in here, in this episode, there is a dodge going on. That's from all I've seen and heard, that's my hunch. I'm very curious to know, since the representatives from the Department of Public Health are not the ones who really can answer the questions we have. Why is a representative from Waddell Clinic who can answer the questions that we have not here? I mean, it seems to me that the people who are really accountable in this matter from the respondent side are not here tonight. And I would be very uncomfortable making any kind of a ruling without hearing from somebody at Waddell who is familiar with Mr. Garza's case, who can answer the kind of questions we have.
What could you provide an example of a question that you would ask the people from Tom Waddell, just so I can get an idea of what you're thinking?
Well, I don't think that the representatives here tonight could answer fully why the record was not provided. I mean, we heard Mr. Garza say that he did provide a request in writing. It didn't have a physical signature. It was sent by email, but it seems to me that's valid. You know, even if he didn't sign some kind of special of form. We also heard one of the representatives from DPH say that they did not know what information in Mr. Garza's request was missing.
Okay.
And it seems to me that if Mr. Garza made a request for information and didn't provide certain information on his own that was required, we need to know what that was. You know, I mean, if Mr. Garza wants those records, and he comes to us, and we have it within our power, I think we do, have it within our power to help him get those records. I think there is some responsibility here on our part to see what we can do to move that forward.
Okay. Member Snyder and then Vice Chair Wolf.
Like, there's a very complicated federal statute involved here, and the facts are kind of complicated, but this really boils down to a really simple requirement. In order to get his records, Mr. Garza has to, among other things, sign a release form to get his records. And HIPAA, in the plain language of HIPAA, supports that policy. That, I mean, and with respect, I think you're just totally misreading the statute, Member Wolf. It's plain as day to me that they can require a signature to receive records, and it makes sense in plain, common sense terms. They have to be able. These records are private records, and they have to be able to not only release them only to the person authorized to receive them, but to be able to document that. But even if it didn't make sense, it's what the federal law says, and we can disagree with that federal law, and I do, and HIPAA is a terrible law for information, the free flow of information. When I was a newspaper reporter, HIPAA came in. It got very difficult to get any records out of a hospital about anything, and they believe me, I ran into so many dodges based on HIPAA from hospital flacks who said, no, you can't have that because of HIPAA. Well, what do you mean because of HIPAA? They would just throw HIPAA out like this cure-all. I don't think that's the case here. I mean, I've read the statute. I understand what their policy is. They can't cite chapter and verse in front of us for what every single element that's required, but it's a very complicated statute, and they've drawn up a form to capture all of these elements, and that form requires a signature, and that's a very simple requirement, and Mr. Garza won't sign the damn form. Well, if he did, he'd get his documents. This is not complicated. There's just not a lot here, and I see no violation for failure to provide records because HIPAA requires them to get a signature, and the Sunshine Ordinance can't change that fact. It's federal law. And so there's no violation for failing to provide. As far as sending a knowledgeable representative, they've sent, I don't understand what questions could be asked that they haven't answered. I've not heard a good example of something. They've sent two people, who head of the privacy office and Eileen Shields. I've forgotten your title. I don't think this is very complicated at all, and I think that interpreting HIPAA to not require an individual's signature to release records is just a plain misreading of the statute.
Okay, Vice Chair Wolf, and then I'm not sure which of you two.
So I hear what you're saying, and in the August of last year, I had made a motion in reference to 6727B for withholding, but also that there was no citation of Sunshine as to why they withheld the information, okay, as you had suggested earlier, okay, which does need to be made. You know, if it's not made to the complainant, then it's if they forgot or they needed to, they would come and they would tell us here, right in front of us. If they don't know, then you really you got a double whammy going on there. You've got both the first stage, not telling the complainant, and you have the second stage of them not, after coming and seeing us, not telling us what it is. So that makes it equally problematic. Whether it's HIPAA or not, you know, I apologize, Ms. Leghorn, for putting you through the sticks, but you know, we have a lot of cases where a lot of respondents feel that the law is on their side and that's all they have to say. And the law is the law that we follow requires that the citation of the law be included in the response for denial of information, so that we have you can make a case. You're basically the defense. So that to me is what's important. As far as the signature is concerned, I hear you, but I was once off the grid. My signature couldn't be found anywhere. And I did that on purpose because I didn't want my signature floating around. I don't sign the back of my credit cards for that reason. Okay? You got a cell phone, you could take a picture, I can make a copy of it and sign any document I want. When faxes were around, there were lots of hackers that were doing that, forging signatures on forms and refaxing them out. So I understand where Mr. Garza is coming from with regards to, why do I have to constantly sign everything? Okay, I'll sign this form, but I'm not required to sign this other form, so why should I? Why should I have another document floating around in some other part of the system? That's what I'm trying to address here, and that's why I'm picking this apart, because I do not believe, based upon what I'm reading in HIPAA, it just says that they may require to make a request for access. There's no specificity as to what that is. I write you a letter. Please send me my documents. And I might sign it, or I might type my signature, whatever it is. If they receive it. Now, if they say it's got to be snail mail, it's got to be it's got to be stamped envelope, that's one thing. But I didn't hear that. I hear you have to use our form. There's no requirement for the entity to force them to use their form. All it says is that they may require an individual to make a request in writing. That's incumbent on the individual themselves.
Member Washburn, did you have a...
I was just going to say that I tend to agree with Member Snyder. This seems to be a fairly straightforward case, and what Member Wolf was just saying, that the entity may require in writing, or may require, that this particular entity requires a person requesting the records to sign this form. And I can see the reluctance of somebody to have their signature out and about. I understand that, but I also understand that medical information is particularly sensitive, and that medical facilities, physicians want to and need to, by law, protect that to the utmost. And I think requiring even the individual himself or herself to sign is, I think HIPAA law it can be read to require that.
Member Nee?
Yeah. HIPAA law requires a signature, but it does not. What we heard one of the DPH representatives tell us is that the signature is not necessarily required on a release form. The release form is there as kind of a facilitator to let the requester know what information is required. But if the requester provides all the information on some other piece of paper and signs that letter, the release requirement is met. That's what I believe I heard one of the DPH representatives say. I'm not.
If I could just say one thing about it. Before, I agreed with Member Wolf, but after reading through Mr. Garza's twisting and turning emails, I think that, an agreement on the language protects both parties, because anything that is said in here is, my concern is that how does the entity protect itself of what was agreed to? And I think this is a real solid case in point for, you know, that there may be some issues that they have to work out. For example, Mr. Garza took a video camera into a healthcare facility, and there's a dispute as to whether he was videotaping his own things or his, or what, if other people were at risk, and other people have rights too. And just to bring that back to the hippie progressive side, this issue comes up all the time in the medical marijuana clubs. People don't want you filming them in the medical marijuana clubs, and they're not out in public, they're in a facility. So I understand the issue, but I feel like they just writing a letter with a signature on it, if the entity doesn't feel comfortable with that, especially an entity that deals with it, these are not like you go to your regular healthcare provider. These people sometimes see people that they never see again, or things like that. So I'm not suggesting that you're wrong, but just writing it may not cover everything that the entity is trying to make sure that it's disclosing.
One, I agree with what you're saying, and one additional consideration that I think needs to be noted by both sides. This is a kind of a cautionary note to Mr. Garza, if you will. Somebody could create an additional email address under his own account with the name Jason Grant Garza and use that email account to request information via email. Doesn't have a signature, but you know, the internet creates some risks. And if I'm somebody at the DPH or at Tom Waddell and you email me a request for information, the email doesn't have a signature, a physical signature, how do I know that email is really from Jason Grant Garza? So there have to be some cautions observed by the respondent agency.
Vice Chair Wolf?
I don't know why the video issue has any concern in this matter. The matter is whether the documents are public or not, and whether they should be provided to him. The only thing that's blocking him is a signature. And I don't see that there's whether it was sent by email or whether it was sent by snail mail or whether it was faxed or whether it was delivered by messenger or in person, the only requirement is that if the covered entity, which is DPH, requires a request for access in writing, that's all it requires. It doesn't specify a signature. It doesn't specify a way for it to be in writing or anything. They can add, they can say we'll only accept something if it's by certified mail, you know, what have you. It could be like that, so they know that it's coming from a specific entity. But you can never, there's no privacy. There is none. And the purpose of HIPAA is to protect the individual's privacy against other people getting their information, not to prevent them from getting their own information. The purpose of HIPAA is to try and protect that information from other people so it doesn't get shared. But it's not to prevent an individual from getting their own information. Now, if we're dealing with just the signature issue, you know, that could be a sticking point for a lot of people. For other people, it may not be. You know, I go under lots of medical treatments. Now I have to sign lots of papers, but I don't sign all of them because there's no requirement for me to sign all of them. In this case, I don't know. I still don't see a requirement for a signature for a request of access. I think it's appropriate, but appropriate is not what the law describes. The law doesn't describe that there needs to be a signature for the individual to get their own information. The law describes that there be its signature from an individual in order to share the information. And that's the way I see it. And so, I mean, I would stand with my previous motion that I made in August with regards to this. If there's nothing
Is there a
else to be said.
motion?
I move to find the Department of Health in violation of 6727B for withholding.
Is there a second? Seeing none, the motion dies for lack of a second. Okay, so there is no motion and the matter is closed.
I think it was exactly the same the last time.
Mr. Garza, the matter is closed.
So if I want to bring
The matter is closed.
I get to go back to talk about it, come back and come back again. All right, well, let's move on to 11081.
Madam Chair, could I request a 5-minute recess?
Yeah, can I, yeah, I was about to say we neglected to do public comment because I saw Mr. Warfield standing up. So can we wait one moment because I closed the matter prior to public comment? I apologize. You're not a member of the public, you're a party. Okay, public comment is, no, is there public comment on the motion, on the item? Do you want me to reopen it? Is there a motion to reopen the case?
So moved. Second.
Can we do that without objection? No, I'm sorry. Is there public comment on the motion to reopen the case? You're not a member of the public.
It's procedural. We don't need public comment.
Okay, it's procedural. So the task force has agreed to reopen it because I neglected to take public comment, which is very important, and which I neglected. It was my fault. So now we are now reopening it for public comment. Please continue.
I'm Peter Warfield. I'm not a party to this, but I do have some issues with what the discussion has been, where the decision has gone, and some of the things I have seen. First of all, a definition of a public record, as I understand it from the Brown Act, is 6252. Public records includes any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency regardless of physical form or characteristics. Now, there are public records that are partially or even fully non-disclosable, but they are still public records. So there are some other issues that I've got here. Let's try and go through with them, and I'm not sure that they will change your decision. The letter that was sent to Mr. Garza looked kind of familiar in some of its wording, and it's very troubling. It kind of feels a little like Alice in Wonderland. A word means anything I say it means. So in this letter, which is on your page 86, dated 9/16 to Mr. Garza, he's told your request, your designation of a request as an immediate disclosure request does not automatically make it so. That's in the middle of page 86, in the middle of the first paragraph. Well, we already heard from the chair, it is an immediate disclosure request, no matter what the response is going to be. And then it goes on to misquote what's allowed under sunshine and what kinds of things are going to be responded to and what speed. There are 2 extensions noted, and I don't think there's a second 14-day one allowed. There is a 10-day one allowed. There's no citation for any of this. And then they say, we're not required and so on if the extensive or demanding nature of the request would impose an undue burden on the department to respond immediately. Therefore, we will adhere to the deadlines governing standard requests. That's not allowed under 6725. If you'll read 6725, it says, Maximum deadlines provided in this article are appropriate for more extensive or demanding requests, but shall not be used to delay fulfilling a simple, routine, or otherwise readily answerable request. So there's a twist here that really There's a twist here in what's been said that I think very much misrepresents what has been said in the ordinance itself. Now, if they had decided that the entire record was non-disclosable, they should have sent exactly that statement as required by the Bruce Wolf thing. And if there were partially redactable records, those should have been sent with the redactions. Thank you.
Thank you. Is there additional public comment?
I just, Ray Hartz, Director, San Francisco Open Government. I just wanted to agree with Mr. Warfield's comment. I have received also from the Library Commission just recently a response to an IDR saying we don't recognize this as an IDR. They took then 10 days, and their next response was we need an extension of 14 days, and they actually took the entire time and gave me 13 pages. That was the total response. And, it was 2008 to 2010 material. It was all in electronic format anyway. So they basically said, we need 25 days to give you 18 pages, which we had on our computer, and lump it. So basically, I think there needs to be some clarification with bodies and let them know that if someone makes an IDR, they need to have a legitimate request. If it's voluminous, if it's going to be thousands of pages, that may and does probably make sense. However, if what they ultimately give you is 13 pages, what was the need for denying it as an IDR? It wasn't voluminous. It wasn't something they had in records. It wasn't something they had to go look at, this, that, or the other thing. They just basically, but they do it on a consistent basis. So that is a thing that I think needs to be addressed with bodies, to let them know an IDR is what it is, and you can't just wish it away. The second thing, and this is just a humorous comment, is one of the things I learned about credit cards is if you do not sign the back of your credit card and you lose the credit card, and I find it, and I write your name on there and then proceed to use it, if that comes up later, the credit card company can say no, they accepted the credit card in good faith because the signature on the back was a match on the things, even though it wasn't yours.
Is there additional public comment on the item? Seeing no public comment, I do want to say that I agree that there's an odd thing going around about saying somebody doesn't have an immediate disclosure request, and I just want to repeat that an immediate disclosure request is the intent of the requester. It's not something you can change, but there are extensions and ways that you can deal with it. Now, if the extension is requested and it's not needed, or it's ridiculous, or it's obviously ridiculous, that's not they didn't provide a proper justification for withholding. But an IDR is the intent of the requester, not something that can be changed because it's not. Because it's something that maybe if it's voluminous, it's still the intent of the requester. We received one while Mr. Rustum was out, and then it was Thanksgiving, so I had to ask somebody else to do it. But if I had not seen it, there would have been the holidays. It still would have been an IDR, and we still would have had to address that. So, is there a motion?
Again, I move for 6727B.
And is there a second? Okay, so seeing none, the motion dies for lack of a second. Member Nee?
Request for recess, please, 5 minutes.
Let me just close it. So the matter is closed. And now we will recess for 5 minutes. Okay, so we're going to call it back to order. We are now at item number 11. Excuse me, could you please read item number 11?
Yes, Madam Chair. Item number 11 is file number 11081, determination of jurisdiction on complaint filed by Jason Grant Gaza against the Department of Public Health for allegedly not responding to an immediate disclosure request.
Is there a motion to find jurisdiction?
Second.
Is there public comment on the jurisdiction? Seeing none, public comment is closed. Can we take the motion to find jurisdiction without objection? So that motion passes and we've found jurisdiction. Can you please read item 12?
Item 12 is file number 11081, hearing on complaint filed by Jason Grant Gaza against the Department of Public Health for allegedly violating certain sections of the Sunshine Ordinance.
The complainant will have 5 minutes, and then the respondent will have 5 minutes.
This is about denial of services for when I went to the Tom Waddell Health Clinic in August. I sunshined them for all this. I was told by them that I should sunshine the Tom Waddell Clinic. Dr. Pace is who I was directed to at the Tom Waddell Clinic. This is the sunshine for the Tom Waddell Clinic for my medical records. To Dr. Pace. And before we go any further, unlike the last case, which we skipped numbers 2 and 3, it did only include the medical records. I want to be sure I read this entire request so that when you screw me over the medical records, we'll still go on to the other items that I still didn't get and still didn't receive. Item number, let's see, let me read this. Let me actually find it for you. You know, he goes back and he tells me that I need to do all these things, and I write back and say, no, I don't. And, you know, it's like he said, you know, it's just an easy push of a button, but not what's required. Okay. Number 1, a copy of my medical records for both August 2011 and June 2010 from the Tom Waddell, considering the denials, which of course you're going to go ahead and screw me over like you did last time. But number 2, a copy of my signed HIPAA release for my Tom Waddell healthcare information to have been released through San Francisco General under DPH to the Haight-Ashbury Free Clinic, for which San Francisco General was found in violation by the California Department of Public Health licensing and certification. So they broke the HIPAA law, and there is the number of which they broke the HIPAA law, or an admission that they broke the law. And number 3, per the MOU provided by Haight-Ashbury, that anytime the HIPAA law is broken through any of the clinics or anybody else, that the proper state and federal levels are notified. This did not happen. I did not receive that. Number 4, on my IDR, this is an IDR, an immediate disclosure request, was that the complaint process for Mr. Williams be sent to me. Also, Mr. Williams was a security guard who, you know, bullied and intimidated me into leaving without answering the questions that I was asking, and by merely stating policy was in effect denying me health care also. And number 5, all the notes, the reports, etc. by Tom Waddell regarding the 2 denials that was supplied to Shona Peralta to create the false and misleading representation in which I was sent a risk management response. Now, it also goes on further to say that this request also asks for all the paperwork to any of the individuals involved since the inception of this particular case further down. Now, I do know, I believe Ms. Peralta is here, so she can answer some of these questions, and why Dr. Pachi is not here, or Barbara Garcia, who is a director of public health, you know, for my medical records, who, under programmatic access, I've continually asked for all this and been denied. I would like to know why none of them are here. And I believe, like I said before, under federal law, it is not required that I sign anything, that I merely ask for a copy of my medical records, and that I'm entitled to a copy. Well, apparently, I am not, per your Augustus board here, which cannot seem to make the correct decision at the Ministry of Sunshine.
Thank you. Is there anybody to present facts and evidence in support of complainant? Seeing none, respondent will have 5 minutes.
Good evening, Eileen Shields, Public Information Officer for the Department of Public Health. If you will look at Mr. Garcia's public records request that he just read to you, the first 3 requests were verbatim to the item that we just covered. The only difference between this one and the previous is the addition of, he wanted information on the complaint process for Security Williams as priorly requested in the notes, et cetera, and all that. You can read that from Tom Waddell. We did respond to him that there were no documents responsive to this request, and I do have Ms. Peralta here, and I'll let her talk about her response to Mr. Garcia. Thank you.
Good evening. I'm Chona Peralta. Thank you. Good evening. I'm Chona Peralta, the Compliance Officer for the Department of Public Health under Barbara Garcia. Yes, I did get an email from Mr. Garza on both times about his complaints that he was denied services by Tom Waddell. And what I did was call the medical director and explain the information that Mr. Garza had forwarded to me regarding his complaint. The medical director took time to make sure that he covered all the bases and to investigate the situation. And in both cases found that Mr. Garza was offered services the first time he was asked to speak to the social worker to see whether he could apply for some benefits. And when the social worker came out, Mr. Garza left. On the second occasion, as you heard from Ms. Eileen Shields, there was an incident that caused the sheriff to escort both Mr. Garza and his companion out. Although he was offered another time to come in and meet with another social worker, Mr. Garza never showed up for that appointment.
Is that it? Okay.
Yeah.
Okay. Is there anybody to present facts and evidence in support of respondent? You can sit down. I'm sure they'll have a question. Okay, seeing none, the matter is with the task force. I'm not sure which one of you is the appropriate person to answer this question, but Ms. Shields had said that there was response that there were no documents responsive. Can you specifically address the HIPAA release, the 2, 3, 4, and 5? I don't know if we have a copy. He asked for medical records, but then he asked for a copy of my signed HIPAA release for my Tom Waddell healthcare information to have been released through SF General to Haight-Ashbury.
Yes, Eileen Shields for the Public Information Office. As I had stated before in the previous issue, on 9/30 he was sent those. He was sent a signed HIPAA notice, and he was also sent the documents produced into his HIPAA investigation at San Francisco General Hospital. So he already had those.
And
the first 3 are exact.
I'm sorry, you said on 9. Yeah. Okay, so, and then what about the others, the MOU, again, between DPH and health clinics? In that line, he's saying that there is some sort of requirement that if there's a HIPAA violation, there be a notification.
That was That was the Haight-Ashbury Free Clinic issue that was litigated or heard here at the Sunshine Task Force back in, I want to say August, perhaps, July or August. And all those documents had been sent to him previously.
Okay. And then thank you. And then Mr. Garza, if you could address it. You're saying that they're saying that they sent you these documents. If you could address that.
It's not true. For starters, on number 2, let me find it because it's I want to find what I specifically asked for. Could you please read what number 2 was again? Because I just don't have it in front of me.
It says a copy of my signed HIPAA release for my Tom Waddell healthcare
Correct.
information.
I did not receive that. What I received was a copy of a HIPAA authorization release thing that she's talking about, notification of the HIPAA practices that I scratched off, signed under duress, said no, do not release. So no, I did not receive what she's claiming I received. What is the second part to that?
Can I ask you a question about that? I've seen the document that you scratched off.
Correct.
Are you saying?
And can you see the date on it? What's it dated?
I don't know if I have it right here, but I
It's
have
2006, madam. I can tell you. And I can tell you that I went to Tom Waddell in 2010 and 2011, not 2006, as they are trying to wonderfully slip in under the radar, bait and switch, don't look over here, look over there. No, it's not the valid one. Totally incorrect.
So you're saying that there's a later one following
I
after 2006?
went to Tom Waddell in 2010. That's dated 2006. Where is my signed HIPAA release for that information to have been released to Haight-Ashbury, in which DPH was found to have broken the HIPAA law?
Was that in 2010?
Yes, it's stated right there. Licensing and certification complaint number CA00265297. I probably have it with me. So licensing and certification said that they broke the HIPAA law. Maybe we should ask licensing and certification whether I need to sign something to get my medical records.
Yeah.
It's an interesting question.
We should ask them.
Yeah, maybe we should.
Okay, that is from 2010.
Correct. But what is the HIPAA form that she's claiming?
Right.
If it's in front of you that I scratched out. It's in 2006. That is not what I requested. So they did not send me the correct form. It's a bait and switch, the usual for DPH.
Chris,
Now,
I just want to ask Mr. Rustum something about that form. I've seen that form, but we don't have it in front of us.
That is correct, Madam Chair.
So that we might need, I hate to say this, but because we don't have the document in front of us, that could be an issue. We might have to continue this because I've seen it. And I can't recall if it was. I didn't realize that it was this second document, and I can't recall the date, and I couldn't prove it. But we do have it.
Why don't you ask them? They're right here. They sent you the document. They should know the date on it, and they should have a copy of it.
I think you sent me the document.
No.
I think it's in an email.
They sent it in response. I asked. Remember, she said 9:30. They submitted the documents back saying that they had submitted my HIPAA signed request. She got up here, Ms. Shields, and she said that on 9:30 they had responded and sent me this stuff. And she's right here. Ask her about this stuff. Ask her about the scratch out, and ask her about the date.
But I would like for the task force to see it too. And then the information on the complaint process for Security Williams.
Didn't get number 3.
Is that something that that Ms. Shields or somebody, one of the two of you who is here, is that something that you would have that process, or could you refer Mr. Garza to where he would get it?
If he wanted to complain about security, then he would go to the sheriff's department to complain about security. I don't have that.
Is it the sheriff that the same as here in City Hall?
Yes.
The sheriff's.
Mm-hmm.
Okay.
And I will I will tell you one thing that I've realized, and that is, as far as number 2, we only have one HIPAA release for Mr. Garza, the one from 2006. That was the one that we sent him.
Okay. So,
So there was not.
So
There
that's
is
the
not
only-
one from Tom Waddell. Well, I sent him the only thing that we had that was a HIPAA release form. And I did that because it was the only one I had. And if there was one from Tom Waddell,
okay,
there evidently wasn't.
Okay.
So it was a way to respond. That's what I
Did
had.
did anybody respond to Mr. Garza about Security Williams? About the deputy? I'm sure it's not Security Williams. I'm sure it's
No.
Deputy Williams. Okay. Thank you. Mr. Garza, I just wanted to ask you if under number 2, you were saying that, I understand that you're saying you didn't receive your medical records, but I wanted to ask you.
No, madam, that's not what I'm saying. What I'm saying is that they broke the HIPAA law and released my medical records.
No, I mean under number 1, but under number 2, now that they've said that they only have 2006, are you agreeing that they do not have a 2010 copy? It's not something we have to tell them we think you have it.
No, they know that I didn't sign it, but they also know that I don't have to sign to request my own medical records. This is what the whole bait and switch is all about. You know, the personal health care information was written for my control. And this constant game playing by this other side. You know, I said, send me this form or send me an admission that you broke the law because licensing certification has said you broke the law. This was well over, you know, when was this sent in? Let me see. 10/4. So today is 11/29. My goodness, this was 60 days ago. Is this an IDR? Is this the spirit of IDR? If I'm having a heart attack because I'm seeking my medical care, it's been 60 days. Where's the immediacy around all of this?
Okay, thank you. Are there any, Vice Chair Wolf? I do want to say one thing. We have 1 hour and we have 2 complainants left here, and it would be great if we could make some attempt at really focusing very specifically on what is at issue so that we can try to address as much as possible because we have a lot of complaints backed up. Okay?
Okay, so,
thank you.
You know, it's not in our purview to determine what HIPAA is HIPAA is not our jurisdiction, first of all. Okay? The only thing we're concerned about with HIPAA is whether HIPAA has a requirement that would supersede local law or state law, for that matter. Now, the one thing that I failed to do was go to the source, to the Health and Human Services Department, the federal government, and I just sat here for the past 10 minutes or so reading just their FAQ and all their questions, and it, you know, in all deference to Mr. Garza, it is exactly as he says, that the purpose of the privacy rule under HIPAA provides for 2 sections. One is consent. Do I want to consent to give my information to a third party or what have you? And the other one is authorizations. Do I want to give authorization? They're very specific on the 2. But what it comes down to is the protection of the person's information from other people, not from themselves. And that's the crux of the matter. Wherever you read in any part of this regarding the privacy rule, it is specifically about protecting the person's information from other people. And it even says without HIPAA, a state or local law would have to have something like that in order to protect the person's personal information, which states and local law, local governments would probably not like to have to do, because it would be very, very extensive and time-consuming. So, you know, I just wanted to state that because I think this is a bigger issue, and it's more than just taking a couple of sections of the HIPAA code and trying to make a good case or give us good advice on this. I think what's important is that that we get some real answers as to exactly how HIPAA was meant to be used. And every city or every county, every state is going to interpret it differently in the way they do. There's probably not enough federal investigators to go around it to make sure that it's all being used properly. So I'm going to suggest this. I'm going to suggest that we do postpone this particular item, and for the purposes of the release of the information, with or without the need of a signature or not, I will track down somebody either in medical ethics or somebody from the federal government to come to us and give us an education. I did this the first year I got here on metadata, when the issue came up on metadata, because nobody knew what it was. I don't think this is a perfect opportunity, especially since this could be precedent setting. And we had already ruled in the past that with regards to the withholding of information on this particular similar item, that it involved Mr. Garza last year. So that's my suggestion.
The other 5, we're addressing them. Okay. I'm working on that right now, but I'm letting him finish it. That's why I asked you all those questions, because I wanted to make it. And I just I wanted to ask Member Wolf, are you
on the issue of release of documents and the requirement by the Department of Health for him to sign a authorization, I believe it's called authorization to disclose form? There's an official name for the form? Is that correct?
To get access to medical records, the request needs to be made in writing to the place where you got the service in the medical records department there. You can use the authorization form that we provide, or you can use another form that has all the essential elements. All that information was in the documentation that was sent to Mr. Garza.
Okay, because Dr. Pache...
It's an authorization form.
It's an authorization form.
Not to be confused with the notice.
Right, I got
Which is the first thing.
I understand. Dr. Pache mentions, quote, authorization to disclose health information, unquote. Is that the form you're referring to? Okay, thank you.
Would you need to have this particular complaint continued in order to do that sort of research, or can we refer it to the Compliance and Amendments Committee?
I think, well, we could separate the item out, that particular item. Because the complaint involves a number of different issues. I'm only concerned about one issue. The other issues can be, dispensed with in whichever other way the task force wishes to dispense with them.
Okay. Is there any comment from the task force about Member Wolf's idea to further research what the HIPAA law intends?
I think it's a good idea. Excuse me, I think it's a good idea to do that.
Mr. Garza, would you have any objection to separating out the first part and your first request and then having a decision
I have
on two?
no objection to doing that, but I do have a request. I do need an answer. Let us just assume that I'm correct later on down the road. What does that mean for all the time that has passed that I've not gotten what I wanted, the case of 10038 that I've asked to be reopened because of the fact that medical records do fall under sunshine per the prior 2 determinations that I had, that I sent in to you people. You know, I don't mind separating it out, but the question is, what's in it for me? I've been here for 10 years, and I'm still seeking medical help, being dead right. So what's in it for me? I'd like to know.
Your medical records.
I haven't gotten them yet.
It's just that I'm not concerned. Still have a concern about the medical providers covering themselves in a way that is standardized.
I have another concern. Where's Dr. Pachi? He supposedly, according to them, if I was to request my records, I'd have to go to the clinic. I went to Dr. Pachi, who supposedly is in charge of the Tom Waddell Clinic. So why didn't I get him then either? And why is he not here to respond to any of the questions regarding that?
Well, that's the part that I'm asking you if you would object to
I object to him
out.
not being here. I object to not being able to get this to go the right way.
Mr. Garza, what I'm asking to do is that I want to separate out the release of your medical records because of the sticking point around having a signature.
I agree.
And if, depending upon the outcome of that research and our new education,
I understand.
you might get your records.
But can we also put into the record that because Dr. Pachi was not here, you could not ask him the questions regarding my medical records?
That's a different issue. That's a different issue.
But he's still not here. Right now, I'm just saying, I just wanted further record.
We hear you. We got
That's
it.
all.
We got it.
It could still be addressed when that first part is addressed.
No,
okay.
But I'm still being denied it being addressed here now by a knowledgeable representative, which is, harming me.
Okay. If there's no additional discussion, we'll have the respondent have 3 minutes for rebuttal, and then the complainant. Does the respondent have a rebuttal?
We are more than happy to provide Mr. Garza with access to his medical records if he would present himself to the clinic where he received the service and make the request in writing. That's all that's required. It's on all the forms that he's been sent. We are not trying to withhold his medical records. Frankly, I don't even know if he ever got services and has medical records. We don't even know that. Okay? But if he wants whatever he has at Tom Waddell, he needs to make that request there in writing. Oh, and the reason email is not in writing is for precisely the reason someone else brought up, that email can be sent by anyone pretending to be anyone. The reason that the request needs to be made at the clinic is because presumably they know you because they provided care to you. So they can confirm that the person asking for this record and signing the request is the person that had the service. It's to protect the privacy of the individual who received treatment and to make sure that they are getting their information and that someone else isn't getting it posing as them. That's why we have these requirements, that you need to go to where you had care and make the request in writing to the medical records department. All that information is contained in the notice that you receive when you walk in the door, and forms to authorize and view those records are available at the clinic as well. All of our HIPAA forms, all of our policies are based on state and federal law, and in many cases it's verbatim from the regs. That's how we're developing these things. We have no interest in making things up that are different from what is required in the state and federal regs. So in many cases you will see verbatim as you read through. So it states in writing, it states going to the place where you received care. More than happy to give him access to the records. That's all he need do, and he's been directed to do that a number of times. So he could very easily get the information that he wants.
Thank you. Mr. Garza, you have 3 minutes.
Well, everything she told you is not true because, you know, I did go to Mr. Pachi, who's in charge of Tom Waddell, and I didn't get the records. So apparently, that's a lie, a misrepresentation. I did send it in writing. But apparently, that's another lie, another misrepresentation.
Mr. Garza, if you could address us, that would be great.
So, you know, we could stand up here all day long, going round and round, and I can continue to have the law broken, and I will continue to go back and request, you know, medical care, and I will continue to be denied, and I'll continue to come here. But I'm still correct. Dead right. Now, moving forward, you know, that still doesn't answer the question of the HIPAA law-breaking activity that they got busted for. Nobody has addressed that in number 2. They claim they're so wonderful with their policies. They're so concerned. Isn't the opposite true then? Shouldn't they be here also equally concerned about having broken the law and not provided me what I asked for about that specific law-breaking HIPAA thing that I have from California Licensing and Certification, where they did break the law at Tom Waddell? Please, let us get some state officials in here. Let us get some federal officials in here. And while we're at it, let's get some officials from ADA in here. And also, let's get Barbara Garcia, the public health director, in here. Let's get Faye de Guzman. Let's also get the Ethics Commission in here, who, when, you know, we sent Ms. Shields up for having done this exact same thing and not complied with an IDR and everything else, there was no consequence. Before, you know, we go through all this motion, you find in my favor, it gets sent up to ethics, and guess what? Once again, no consequence, but guess what? I'll go back, I'll continue to look for my medical care, and I'll be here again. Because obviously, this is a rigged process. I'm still dead right. It's still my personal health information, it's still my medical care, and they're still getting up pretending that they care. Well, where's the admission of the law-breaking activity? Where's the forms that were sent to the federal government? Oh, and by the way, Shauna Peralta, she just said that she, you know, spoke with the medical directors. There was no notes of all these things at Tom Waddell and these denials? My, that we can't produce the records. Well, I'm just wondering what else they can't do correctly.
Thank you. The matter's back with the task force. Okay, so I want to start by asking, is there a motion to separate out the item 1 request for medical records from the other 4 items?
I think it's fine.
Is there a
we can make
motion?
any. So I'll move to that the. I'll move that the complaint against the release of medical records be. Where should it go? Should we do it to CAC?
Divided?
Yeah. Well,
First let's divide.
There's no
Is there a motion to divide separate?
But there's no
complaint 1?
question there's no motion on the floor, so.
I'm asking if there's a motion to separate out item 1, that section 1 from the other sections.
That's what I'm attempting to do.
Yeah, but you don't have to decide where it goes. You just have to make the motion to do it. Because we haven't even decided, we haven't even said we would do it.
But there's no. It doesn't make sense to me.
Because I want to make a motion on 2, 3, 4, and 5, but we got to separate out 1 to do it.
No, you don't. You could just say that that we're doing this with number 1. And
Okay, so make the motion and separate it out in the motion.
Right. So
Okay.
I move to on the complaints issue on receiving or not receiving his medical records, that it be continued.
Can I try? I'm gonna.
Go ahead.
I'm gonna.
Make a suggestion.
Okay, I want to I'm going to suggest a motion that they agree on number 2. He was sent 2006. The request number 2 was fulfilled with the only thing they have. They admitted that there is not one from 2010. So that I feel like that request has been satisfied. And 3 and 4, although overall in 3 and 4, so 4 is the request for the complaint for the security process. And 6721C requires that you respond to it. And even if it's not you, you assist a requester in responding. And there was no response to that. In addition, it was an IDR. It's not voluminous. There was no reason that couldn't be responded to by saying that's a sheriff's deputy. So that would be a violation of 6725A of responding to immediate disclosure request. And sorry, I forgot to write that down. 6727 does not apply to that, the justification for withholding. Okay?
Okay.
And nothing was received for item 3.
Okay.
So the same thing would be for that. Now, item 5, are you saying you said from item 3? He's saying he didn't receive it. So
He had
3.
received that previously during the Haight-Ashbury Free.
Okay, but he asked for it this time. So 3, the motion is going to be that 3 and 4 and 5.
There are no
there's-
documents for number 5.
Then that would be your response
And
when I put it in.
We did
here.
respond to him on that, on 5.
Okay, so
On 10-4.
all right, so let me start again.
Well, you can
We would-
include number 1, just saying that number 1.
Well, I don't want to find a
Okay.
violation. I'm
Okay.
just trying to find the violation of 3 and 4.
Okay.
It's a failure to assist the requester, 6721C,
Right.
and a failure to respond to an IDR, 6725A.
Right.
And it's 6727 it's not a justification for withholding that it's voluminous, that telling them that the sheriff is not voluminous.
Right.
And then continue, find those violations and then send it to compliance and amendments for your research for the medical records.
Right.
We satisfied number 2. They sent you what they had. And you said it didn't exist.
Please, can you come up to
Wait a minute. This is it. This is my motion. This is it. It's late. We have 2 things to go. That's the motion. Is there a second?
Second it.
Is there public comment on the motion? Okay, seeing no public comment, is there a discussion of the motion? Can you call the roll so we have it individually?
On the roll, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
Aye.
Wolf, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 6 ayes. The motion passes.
Okay, so then I move that the non-receipt of medical records, that be continued, and that the item be referred to compliance and amendments.
I did.
Okay.
That's it.
So that was included in your motion? Did Chris get that?
Did you get that?
Oh, you did. Okay, cool. Great, thank you.
And so on 3 and 4, we're asking you to return the information over to Mr. Garza. And then item 1 is going to compliance and amendments. That I already told you what I think about 2, and that's our motion. You said that they didn't have a HIPAA form from 2010 because there isn't one. It doesn't say admit that they've broken the law here.
Point of order.
Or an admission. Okay.
Point of order, Madam Chairman. There's a motion on the floor, and it's the people in the audience gallery, whether they're parties in interest or not, should not be joining the discussion at this point unless called upon. Excuse me.
Okay, so that item is closed, and we're going to move on to the next item so that we can try to get to it. Mr. Garza, just to finish it, is they did say there isn't one. They said it right here. They don't have to create a document that doesn't exist. Okay, so Mr. Rustum, can you please, the anonymous, let's,
13.
Item 13.
Yes, Madam Chair. Item number 13 is file number 11071, determination of jurisdiction on complaint filed by Ray Hartz against Dennis Herrera of the City Attorney's Office for allegedly advising city departments to violate the Sunshine Ordinance.
So moved.
Second.
Is there public comment on the motion to find jurisdiction? Seeing none, the public comment is closed. Can we take the motion without objection? So jurisdiction is found. Please read item 14.
Item 13 is, no, sorry, Madam, 14 is file number 11071, hearing on complaint filed by Ray Hartz against Dennis Herrera of the City Attorney's Office for allegedly advising city departments to violate the Sunshine Ordinance.
Is the respondent still present? No? Okay. Let me ask you, Mr. Hartz, I know that you have your case prepared. Do you feel like it's something that we can do without them present?
It wouldn't bother me at all.
I'm just not sure if we can get, it's going to be it might be difficult to understand. It might be worthwhile to hear their argument. I'm not sure what the task force. Member Nee.
Madam Chair, we might inquire of the complainant if he has any objection to a continuance.
I think he might. Do you have an objection to a continuance?
Well, we went from October to November and now to December, so I guess not.
Would this, okay.
I'll be honest with you. I really do not expect Mr. Song to have any real contribution to the matter, and I fully expect he will do what he does in most of these cases, which is say, I don't know. So I'll be honest with you. I would prefer to just go ahead with it and have it heard and get it out of the way.
Well, it's one of the difficulties about it is that it's not about public records, and it's not about meetings. So it's difficult to just, without their explanation of it, it's a little bit difficult to know what it is their reasoning is, or what did they? I know he sent a letter responding, but
we can always refer to the 143-page response from the Ethics Commission.
And there's some analysis here that obviously I'm going to ask him about. But for example, I don't know if Mr. Song is an attorney. Do you?
That's what I'm saying. Mr. Song is not an attorney, and this is really a matter of law, because what the city attorney's office is saying is we can advise someone.
Well, I understand. I'm just trying to
ignore the law and to ignore the decisions made by this task force.
Vice Chair Will.
I think that we can move forward on this. I have several investigative questions, and if we come to a place where we think we can get stuck, we can then choose to continue it then.
Well, I have a number of questions that there's nobody here to answer. Like, I want to. They're just. I don't want. I don't want to break the law by having a discussion about it, but I just want to give you an example of what I'm saying. He says that the city attorney's office has not changed its advice, but I provided evidence that it has somewhat changed its advice, and I would like to ask him about that.
So did Mr. St. Croix.
Yes. Well, we can't really, without.
I would say move forward, open the case. We can have the discussion.
Well, we have another complainant and respondent sitting here, and we have 27 minutes, so we could hear a complaint that we know we could actually. The respondent's present, correct?
Can we put a time factor on this? Can we give it, 15 minutes or 10 minutes?
If Mr. Hartz is willing to continue it, I think that we should hear. Is the respondent present for the next complaint? They're both here.
Right.
And she's been here. What time? Mr. Hartz, are you willing to continue it? Look at them sitting.
I, for one, would like, I think the issue that Mr. Hartz raises is one that we have discussed at great length. It's an important one. I think we need to give it its due by having somebody from City Attorney's Office here. And I suggest we move on to the next case because both parties are here. If that would be okay, Mr. Hartz.
Can I ask one
I agree.
question?
We literally have minutes.
Yes.
So we have to decide now or not do it.
I just want to ask Mr. Hartz a question. This is not substantial necessarily, but do you have evidence to support your complaint?
This is getting into the merits of the case. That's what the case is.
I'm just asking if he has documentation.
You mean in general?
In general. Do you have evidence to present us?
Yes.
See, that's what makes it significant for me.
Madam Chair,
Member Nee?
I move to continue this item till our next meeting.
I second it.
Is there public comment on the motion?
Peter Warfield, the representative of the Arts Commission, who has kindly stayed for many hours, as I have done, just said her garage closes and she needs to leave in 15 minutes. I don't think that even if we had all that time from the moment she spoke, I don't think that our complaint can be handled in 15 minutes. And I also think that there are some issues there that I think are very significant and need the full attention of the task force and as much time as is necessary. And 15 minutes isn't even what your minimum estimate says for these hearings. With respect to Mr. Hartz and his case, the city attorney has, at last count, when I saw the figures, 220 attorneys. Why couldn't they send a representative who could deal with the issues at hand? It seems to me that while your wish to get all the information you can and all the answers you like is certainly commendable, to delay a case that's ready to go and which you've heard from the complainant where it's likely to go, and when they send somebody who's not an attorney, I don't see what you're gaining other than to delay the complainant by postponing this case. And so I would urge you to go forward if you have difficulty, if you really, really need explanations, which there's no guarantee you're going to get them the next time you have this. Maybe it'll come up and Mr. Song won't be here. Maybe 220 attorneys can't find one to come here or to stay after 9 or after 8 or whatever it is. So I urge you to go forward with this case and to hear it as fully as you can, as Mr. Member Wolf has suggested. Thank you very much.
Is there additional public comment? Seeing none, public comment is closed and the matter is back with the task force. Mr. Warfield, would you like to continue your complaint? Is that what you're saying? Not that you prefer that, but at this point it's very late and the
I do
respondent
not
has to leave.
prefer to continue the complaint, but given where things are now and the need for reasonable consideration and not tension, and let's hurry it up, quick.
Yes or
I'm
no? Are you want to continue your complaint?
I'm
yes or
willing
no?
to continue the complaint.
Okay, and I apologize to both of you. I thought that we might be able to. Yes.
Commissioners, I have been here since 4 o'clock in the afternoon. I'm sick. I came here to do this hearing. I've sat here since 4 in the afternoon. I think we have this is a very straightforward matter.
How long do you have to leave?
We flip the items.
What time does the garage close?
Well, I think they close at 11. I mean, if you're going to hear what the other one, I can run and get my car. But I would at least,
Madam Chair, City Hall closes at 11.
It closes at 11. We sometimes have a little bit of extra time. This is a problem that we have with the respondents having to stay here, but now we're wasting a lot of time just talking about it, which I didn't want to do. So we either have to do something about it. Let's make a decision right now about Mr. Warfield's case because they're both here.
I move substitute motion.
It's just disrespectful to have people sitting here. I'm trying very hard to.
I would move a substitute motion to flip the items so we hear Mr. Warfield's first.
Is there a second? Is there public comment on the motion to hear Mr. Warfield's item first?
What happens if you have legitimate questions, and what happens if you haven't come to a decision? That has happened to me once before, some years ago, when in the middle of a case, quorum was lost. In this case, it's possible that the time will end. How are you going to handle that? Are you going to rehear it when the full task force is here on another day? Are you going to make up some kind of rules about how to handle it? It was not handled well, in my opinion, quite some years ago when that happened. And there was a whole series of very unfortunate rules that were set in place and so on and so forth. I don't want to take up additional time, but I don't think that when your estimate says 30 minutes, it's going to be done that fast, and I do ask your serious consideration about a very important argument that was made by the Arts Commission, which is very significant and important for you to adjudicate. Thank you.
Okay. I don't know what to do. There's a huge possibility that we won't have enough time to get through it, and then you'd have to come back anyway. So there's a motion on the floor to flip the items. It's been seconded. Is there a substitute motion to continue it, Member Nee?
Madam Chair, I'd like to offer a substitute motion.
Can you do that? Double a substitute motion? Substitute a substitute motion?
Why not?
I understand there's only allowable 2 amendments on any motion.
Based on what?
Robert's rules.
I don't think a substitute motion is an amendment.
I'm not so sure about that. All right, do whatever you want. Let's go.
Madam Chair, forget I spoke.
Okay, we clearly don't have enough time to hear it. I'm going to do my best to put whatever this is at the very beginning of the agenda, because we just don't have the time. We spend a lot of time talking about it. We don't have time to hear it. So I'll do my best to put it at the beginning of the agenda. But even if we started to hear it and we got stuck in the middle, we would have to have you come back anyway. And I'm very sorry. I apologize. So is there a motion to continue items 34 and 35?
So move.
And is there a substitute motion, I should say, to substitute?
Excuse me, I believe you mean 33 and 34.
I'm sorry, 33 and 34. A substitute motion for the motion to flip them, Member Nee?
Well, my substitute motion would be to continue 3 items, number 14, number 33, and number 34.
Number 14?
Number 14, that's the substance of Mr. Hartz's complaint. We have 15 minutes before City Hall closes. We're not going to be able to do either of those cases justice.
You are correct.
Continuing both is our best course at this point. That is my substitute motion to continue items numbers 14, 33, and 34.
Is there a second?
Second.
Is there public comment on the motion?
I understand you have to continue it, but I would just like to say that in the future, these agendas should be set so that you have time to hear all these items. It's really unconscionable to ask people to sit here from 4 o'clock in the afternoon till 11 o'clock at night and then not even to have their item heard. I mean, what it costs my department for me to sit here for, how many hours non-productively is really a waste of my time and city funds and everything else. So I understand you have a lot of cases, but I would just say that in the future, I hope that maybe you would think about not having this happen to people. Thank you.
Thank you.
I'm just going to say that I appreciate fully what you're in. If you put them on and you don't hear them, then they're upset because it didn't get heard. If you don't put them on, then they're complaining because you waited too long. So damned if you do, damned if you don't. Do what you may.
You are in a difficult position, as the previous speaker said. It's unfortunate. I, too, have waited for 7 hours and am still here at the end of this meeting. But these things happen, and I do appreciate the motion, which recognizes that you want to do, as the maker said, justice to these things. And I also appreciate the time that you've spent to be here for 7 hours tonight to try and do justice to the other complaints that you've had before you. And I appreciate that, even though I would very, very much and very much wanted and hoped for a very prompt hearing for this complaint and the other one that I filed. Thank you.
Thank you. Mr. Rustum, can you please read item number, I'm sorry, we didn't vote. We have to vote on the motion. Can you please call the roll on the motion to continue those items?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Wolf?
No.
Wolf, no. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 5 ayes and 1 noes. The motion passes.
Okay, so those items are continued. Can you please read item number 36?
Number 36 is announcements, comments, questions, and future agenda items.
Are there any announcements, Member Wolf?
I have 2. One is I would like to suggest that we have all items on the agenda, all their jurisdictions be done at the beginning of the meeting so we can determine who is here, who isn't here, how much time things could be taken. It could be asked during jurisdiction. because I think what we run into, what I am very disturbed about, is when an item comes up, and then we find out there was communications from that person days before, and there's been no communication with the rest of us. That really annoys me. So I'm suggesting that we have all jurisdiction items be heard first. That way we know who's here, who isn't here. People can then gauge if they can leave and come back or whatever, and deal with things in that way. Also, I would suggest that we request the annual report of the supervisor of records. I think it's important for us to review those things because who knows what decisions they're making, and that comes directly from the city attorney's office.
It's been on the agenda a couple times, but we didn't get to it.
Okay.
So,
but do we have it?
Yeah, it's been on the agenda like the last 3 times.
Okay. No. The report from the supervisor.
Yes.
Right? Oh, okay. Okay.
And Mr. Reston, I would like to request that somehow we need to forward the emails. I don't know what's going on or why I don't get the emails. I'm not making a suggestion about it, but I need to get the emails when people say they're not coming, or if they're some of these were older and I didn't get them. So maybe that, because having the jurisdiction all at the beginning is going to be really difficult and take up a lot of time at the beginning. But we definitely, as you can see, there's a difficult balance because the task force, you know, there are a lot of people that don't want, a lot of people say don't want sunshine, and it's difficult. People get upset. It is difficult for have people sit here for 7 hours, but we do only have one meeting a month. So I have to try to balance out the respondents and the complainants' time as best we can. Although Member Nee was absolutely correct, we could not have given it proper, hearing. So you need to send me the emails, but perhaps more than just me, so that it doesn't get maybe me and Vice Chair Wolf. I'm not sure if Vice Chair Wolf wants to get them.
More information, the better.
To be clear, if the respondent or the complainant says he or she is not coming, I need to forward those emails.
To me and Vice Chair Wolf.
And GCA3.
And yeah, you can forward them to GCA3, or one of us will, but definitely to one of us so that we can
It helps
confer.
with agenda creation. Because if we know ahead of time that they're not going to be here, then we can contact the complainant and ask them if they want to continue it or not. And then it solves a lot of issues for us.
Okay. I guess that's it. The only other thing I was going to say is we're going to talk about the ethics. Oh, I'm sorry. Is there public comment on 36? The Ethics Commission information is going to be handled at compliance and amendments. So we'll let those of you who are not on compliance amendments know about it.
I hate to beat a dead horse, but for future items, I really would like to have 10050 come back before the full task force. It was a case where the police commissioner told me you aren't allowed to speak. He violated the law. He fully knew well he was violating the law. He did it anyway. And it was sent off, and it's gone into limbo. And I think it's because it is so similar to the Cawthon Library Commission case. It is something that the executive director will have a hard time dismissing out of hand. And it really is a case where someone who fully knew well when he was doing it, telling me that I was not permitted to talk about something, and when I challenged him on it and told him he was violating my rights, he denied it. And he has continued to obfuscate about the issue. And it's been 14 months. And I think that in itself is going to cause me a little bit of problem before ethics, but give me the ball, I'll run with it, and I will take it to ethics and beat them over the head with it. And I think, unfortunately, being the outsider, that is something I am able to do that you may not be able to do. And it is something they need to have done because obviously even the civil grand jury can't get through to them.
Peter Warfield, you talk about forwarding emails. My complaint filed October 11th got a response relatively promptly, if not absolutely promptly, from the Arts Commission on October the, I believe, 19th, possibly the 17th. I did not get a copy of that response until it was sent by your administrator almost a month later, on November the 14th. When I inquired of Mr. Rustum, he said, well, they had sent me a copy, so that's why he didn't. Whether or not they sent me a copy, and whether or not I got the copy, and whether or not they sent me the same thing that they sent Mr. Rustum, et cetera, would have been very simply solved had your administrator just simply forwarded the item to the complainant, which didn't happen, evidently for a month. And then when it was sent to me, the response of the Art Commission, I only got the actual 2-page letter that gave their argument. I did not get their cover letter, which might have had something interesting to say, nor did I get the other attachment that came with their cover letter. And that was what they were telling you they had sent me, namely the minutes. But I didn't get the minutes they said they sent, because Mr. Rustum forwarded just that particular 2-page letter. A whole lot of confusion would be very simply solved. Just click the forward button, put library users 2004 at yahoo.com, and just ship me what they sent. I think that needs to be an absolute practice. It also put us in the position of having to scramble to get stuff into the agenda packet, because now instead of a month, we had only a few days prior to the week before Thanksgiving mailing of your agenda packet. All of this was tremendously disadvantageous to the complainant. Instead of having it for a month, so we could give it a thoughtful, careful reply and send it in plenty of time to the administrator, we had to scramble. And that's the date that was on at the 14th. I'm not saying exactly the date at which we picked it up from email and then had to discuss at length what the deadlines were for including an answer in the agenda packet. So please clarify these procedures that you've got and insist that whatever the departments send back as their response just simply be forwarded to the complainant.
Thank you.
Thanks.
Seeing no additional people in the audience, public comment is closed. Is there a motion to adjourn? Second? So is adjourned.